Sure they can bring you specifics.
Yes. Nice to meet you. Oh, nice to meet you. Yeah, from Wings. How are you, man? Did you see the investigative report?
Good morning, everyone, and welcome to the Guardianship Improvement Task Force meeting. It is wonderful to actually meet in person and to see each other's good face here on a nice day here where maybe it's symbolic that the weather even changed today for us as a new start. Going from a warm day yesterday to a cool morning this morning. It felt good to be outside for this morning. So maybe that's a sign from God that, you know, he's blessing our work here today. Let's hope he is. I wish to welcome those members of the public who are here with us. It's certainly nice to have you with us. This meeting is being featured on the WebEx for our members who couldn't participate in person to participate. It's also being featured on YouTube. And so anyone out there in the great universe who has access to the internet can watch it on YouTube. And we know there's been tremendous interest in this over the time. We've had a range from I guess a low of 120 people on our meetings to up to past 200 people participating in our meetings. And then there's the hits afterwards that happen where people go and watch the YouTube video. So it's good to have you here. And why don't we go ahead and get started? I wish to send regrets on behalf of Senator Bradley. Senator Bradley intended to be here. She's had a family emergency. Matter of fact, she drove back last night to her home and then is flying out for a family situation. Katie Heffley from her staff was kind enough that is going to be here, not in a participation capacity, but to take notes and to give the spirit of the discussions to the senator. Representative Burton also expresses her interest, a continued interest in this. She had to get back to Lakeland for an appointment there today, but she is very interested in this process and wants to obviously stay involved. So why don't we go ahead and give the introductions, and instead of me introducing and calling roll, we're just going to do self-introductions. And Hillary, would you please start?
Good morning, everyone. Hillary Hogue.
And would you give the perspective, how we, as part of
My name is Hillary Hogue, and I am representing the ward's perspective.
Good morning, sir. For those of you who do know Bob, I am not Bob Estalis.
Yes.
My name is Roy Clark, and I'm with the Florida Department of Veterans Affairs.
Very good.
Good morning, I'm Shannon Miller. I am a board certified elder law attorney, but I do not represent the elder law section. I'm just here in the individual capacity.
Very good. And it's always tough for a person from Gainesville to come to Tallahassee, so.
Mike Donovan, I work with Legal Services in North Florida. I would represent the indigent people, and I represent primarily wards.
Shantae, go ahead. We'll give an introduction there later.
Good morning, Shantae Jones, the Director of Office of Public and Professional Guardians, sitting in for Secretary Prudu, the Department of Elder Affairs perspective.
Good morning, Karen Murillo. I'm with the Office of Court Attorney General, and I'm providing the perspective of a criminal prosecutor today.
Good morning, I'm Tom Hall. I'm consultant with the Florida Court Clerks and Comptrollers, and I'm helping staff this task force.
My name is Ken Burke, and I'm Clerk of the Circuit Court and Comptroller from Pinellas County.
Good morning, I'm Anthony Palmieri. I'm the Deputy Inspector General and Chief Guardianship Investigator for the Clerk of the Circuit Court and Comptroller's Office in Palm Beach County. I'm also the Administrative Coordinator for the statewide Investigation Alliance, and that's the perspective I'm giving today.
Good morning. My name is Jose Ramon Rodriguez. You don't have to roll your R's. That's okay. But I am from the Ninth Circuit. That's Orlando and Kissimmee, the Orange and Osceola County seats. I retired as a circuit judge after 30 plus years on the bench. I represent I do not represent the views of the judiciary as a whole. I do represent the views of someone who has had experience on the other side of the bench, listening and listening and listening, following the rule of threes there. So my perspective is one of having had experience in the application of 744, 393, and all of the other statutes that at one point or another intersect with guardianship. I am also an adjunct professor of law at Barry University Law School. And I teach guardianship and children's rights.
Hello, my name is Michael Lincoln McCrate. I'm a former ward.
Good morning. My name is Sancha Brennan. I'm a practitioner in guardianship in Central Florida. Although we're not here in a representative capacity, I suppose I'm on the executive council for the real property, probate, and trust law section, the 11,000 plus members. And so I'm here with that perspective.
JD Peacock, I'm the clerk of court and comptroller in Okaloosa County. My perspective is I'm a member of the investigative task force. Our office is with an IG, as well as the role of the clerk of courts in general.
Good morning. I'm Dennis Moore. I'm the interim director of the Florida Guardian and Vital.
Great to have you. Great to have you.
Thank you.
Good morning.
Morning, I'm Viviana Bonita Lopez. I'm an Equal Justice Works Fellow sponsored by the Florida Bar Foundation and Disability Rights Florida. I'm an attorney. I work with people with disabilities, helping them avoid guardianships or get out of a guardianship, and that's the perspective that I'm representing today.
Thank you. Kimberly brought up an important point. Since the folks on YouTube, for them to hear what we're saying, the microphone needs to be directly in front of our face. So we may need to, there's a shared microphone here, so we'll have to move it back and forth, but please get in front of the microphone when you're talking, okay? So that the good folks who are listening in through the WebEx and on YouTube can adequately hear what's happening in our meeting. I did want to thank Kimberly Bredsby for helping us staff this. She does a magnificent job, and we appreciate all that you do, Kimberly. Tom Hall, of course, who has devoted so many hours to helping us move this thing along. Tom, I appreciate your good work, and thank you. Patrick, thank you for being here today. We also have Jennifer from the association who helps with facility management, and she helped set up this room. And also Ben, who's with Florida State University, and Ben was in the room a few moments ago. Ben's back there someplace, but he's helping us from the host of the nice center that we have here that we're using today. So I want to thank those folks for all of their help. I have some comments to kind of give us an overview of today and some points that I hope we can come to some agreement on. This is a big issue, and we know, and we never had the illusion that we're going to solve all the issues involved with guardianships by having this task force. I mean, that would have been an impossible task we would have to put our superhuman outfits on to accomplish. But this task force can move the needle and start the process. There have been other task forces. There's never been one with as many varied views, and it was good to hear when we went through the introductions here, the different perspectives. Again, none of us represent per se our organization, but we bring the perspective that we have from our experiences, from our organization's experience to this task force. And that's important. And I think going forward, any future task force, I hope it's as wide, with a wide variety and spectrum of points of views and perspectives so that we can have the best result, because hearing from just one perspective really doesn't move the needle. It's not going to accomplish what needs to be accomplished. And we realize that some of these perspectives that we have may conflict with each other. I think we've come to that realization. And that's not all that bad either. That's what the democratic process is about. We do know that the state of Florida, well, because of people living longer and because of the influx of people, the population of elderly will constantly increase. I'm sure Zane could tell us the exact figures if we called on her, but I'm not going to put you in that position. But it's been reported that, in the next 5 to 10 years, over 30% of the population will be over 65 years old in the state of Florida. As that population percentage keeps increasing, with longevity of life and that type of thing, the perspective of the possibility of guardianships and the importance of guardianship becomes all that more intense. And so it's good that we as a state which is known for elderly issues is devoted to this topic, and the conversation must continue. Now, being a realist, and those of you who know the legislative process and have experienced it, know that this is an interesting year for the legislature. First of all, it's the second year of leadership in place. Generally, a lot more activity happens in the first year of leadership in place. The second year, which is always an election year, less, generally speaking, less legislation gets passed. And then those of you who have studied Florida history over the past 30 to 50 years know when they're handed the topic of redistricting, it generally sucks all the oxygen out of the air, because that's important to legislators, the districts that they serve, and whether they're put into a district with another elected legislator potentially. And so a lot of energy is spent, and they won't tell you that probably, say, gosh, this is one of the biggest issues, but we all know redistricting by history takes a lot of the energy of the legislative process and consumes it. And so we know that when we're submitting a task force report this year, that we have those two maybe challenges against us: less legislative activity potentially, and going up against redistricting, which is such an important topic to the legislature. So I think you have to keep that and be mindful of those types of things when looking at the effectiveness of how we can be most effective with submitting a report. We reached out to other folks who have led task force, not necessarily guardianship task force, but task force which are looking for legislative responses. And there's two ways you can go on this. You can go with a very prescriptive task force report, which says, here, pass these statutory changes with this statutory language, and we're going to give you the statutory language we want to have passed. Okay, that's one way to do it. Okay, and it's sometimes effective, sometimes not effective. The other way to do it, and it's the way which I'm going to ask for this task force to adopt, and especially because of the diverse nature of our task force, is basically that we propose concepts to the legislature. That we say, here are important things that we consider that are important to move the needle to improve the guardianship process in the state of Florida. This concept needs to be looked at, and this concept needs to be maybe embraced by the state. Now, legislature, you have excellent committee staff and legislative staff who's well-versed in putting statutes together. Now, take this concept and please hand it off to your staff and start putting it into statutory and bill drafting language, which then all the organizations such as us that we represent and the general public out there can then have input on that drafted statutory language. And we're going to have a report in a few moments about how that process works in the legislature as far as getting something to passage through the process. And there's pluses and minuses to both concepts out there. And I just think because of the type of task force we have, also to be quite honest, we don't have the amount of staff bandwidth to put together the statutory language and to, those who've done that in the past have a lot longer time. And one of the things that we've had, we acknowledge with this task force, this is not a several year task force. This was a shorter duration task force. And so the idea of putting concepts probably is more appropriate for this type of task force. So that's the idea I'm putting out there today. and would like to have some conversation on that before we move on to hearing from Mark Pinto. And the format for today, and we put together what we considered going through the various testimony that we've had during our 6 meetings of the issues that were brought up. And we kind of made a laundry list of those issues. And we put them in some type of order that we can discuss today, with the more controversial ones we considered up front. So we're not deciding between broccoli and asparagus for lunch and then take 2 hours to talk about that, and then leave the big issues at the end. So we've kind of put the big issues forward first so that we can talk about those. And then the idea would be that Tom is going to present on each of the issues, some background from basically what's been presented to us. And then we have a chance, this is our time to talk. You know, we've been very patient during the presentations, to listen to presentations that we thought were a good variety of topics that you, many of you submitted recommendations that we hear from. And then based on those topics, we made that laundry list of items that we thought that seemed to have the most interest to the task force so that we can discuss today. So Tom will present on the topic, and then that we have our conversation. We can do the voting one of 2 ways. Again, this is something I'm going to ask you to help decide, but we could actually have a vote, 6-4, whatever. Or we can do it, is there a consensus on that without a formal vote? Okay, where does this concept, and if there's division, we can say, okay, this is obviously doesn't have consensus, let's go with the formal vote. So we can handle that on each issue. So let's take the first thing, okay, thank you. And I've just been told that we have task force members who are on the video. So we want to, or the WebEx, who we wish to have introduced. So if you would unmute yourself if you're muted and introduce yourself. And Sean, would you please start?
Good morning, thank you. While I'm not representing the court, my relevant experience is as a magistrate in Tampa and the program director of the court's Elder Justice Center program.
Thank you, Sean, and welcome. Gina, please introduce yourself.
Hi, I'm Gina Rossi with the Florida State Guardianship Association, and I guess I'm representing the views of guardians and the people that we work for. Thanks.
Thank you, and it's nice to have you with us today. Anyone else? And we had a arrival. Thank you for being with us. Would you introduce yourself and speak in front of the microphone, please?
Tamara Cribben, and I represent the perspective of the Offices of Public Guardian.
Thank you. Thank you, Tamara, for being with us. Any other housekeeping on that part? We're going to handle this issue first, then we'll get into public comment. So let's talk about the approving of concepts rather than prescriptive statutory language, and see if we're in agreement with that moving forward in that direction. Anyone wish to speak? Tangent. And I hope people don't mind. I've been, I know in these task force, they have tremendous formality. I'm not a formal guy, so I call everyone by their first name, and I hope no one's offended by that. So, tangent.
Not offended at all. Sanch is an unusual name, so if he's just saying it right is troublesome. I'll answer to hey, you. I am concerned. We've listened to some fantastic presentations on this task force, and I know a lot of work has gone into compiling the notes, and I appreciate the work that Karen did to do that. I've made some notes myself. I am concerned that our task force is not making recommendations based on just presentations until we've had a sufficient amount of time to really vet some of these concepts. I also think that our very first meeting, a number of issues were raised at that time, and there were some that seemed to have some consensus. And I believe that, data gathering may be one of those. If I was reading the room properly then, and then maybe now looking at all the heads shaking, yes. But I think that to be most effective, our task force may want to narrow the topics that we're looking to focus on, and even just the concepts generally. I think we may find it easier to get some traction by being more focused.
Sandra, let me add, and I should have pointed out, in the philosophy here is once we think a concept is one that has either consensus or we vote has approval of the task force. One of the things that we will do is then the next process, right after that discussion, we adopt something, whatever that process is to adopt. We will say, is this a 1 to 5 priority? With 5 being the highest priority, 1 being, okay, this is nice to have, but this is not our top priority. Now, we're going to rate them 1 to 5, but then we'll look at them all to see if there's 3 out there that have 5s or that type of thing. And you're absolutely right, because and again, Mark's going to speak about the legislative process, but when you propose 12 items that need improvement to a legislator, he or she may say, well, what's the 1 or 2 you really want? And some of these may be more, gosh, these aren't that big. We can also add these to it because they're not, doesn't involve an appropriation. It just involves some regulatory language change, which we can do. So I think we can kind of prioritize these things too, as part of our discussion. The idea is after all this discussion takes place, and we have some type of idea of concepts, the next thing will be Tom will take those concepts and write them into a more thorough report with some factual data with it, with reader devices in it to make it easy and for people to see the data or the recommendations or the concepts. And then we would send that out to the task force with a period of comment from task force members, which they would submit their comments to Tom, and then we would send out that document. Again, the advantage of us not being under the Sunshine Law, we can have lots of discussions and emails back and forth within our task force and still be within our rights. And then from that, we would convene the task force again through virtual means to review the report. So there will be a comment period of time after that we can submit our comments.
Going through the operational procedures that we voted on at the very beginning, there was a provision about submitting minority reports, for instance. So what is going to be the method of submitting those if a member wants to issue a minority report?
We haven't come up with that, to be quite honest with you. But the idea would be, I think we have to take that after today's meeting and see where, obviously we'll find there's points where not all of us are in consensus or in agreement. And then we would have that as part of the report. We would give any person here the opportunity to present a minority report that would follow our concept. I think does that sound fair to everyone?
I would like to just speak to your kind of division here of concepts versus actual statutory language. And, I've been involved with drafting legislation since 2012. I've been engaged with work groups. We've revamped statutes such as the criminal exploitation statute. And my experience is that when you give a concept to a legislator, they say, give me the language. So I'm concerned that if what we do is say very broadly, like in the report that we've been provided, we want to create a database. The legislators are going to say, what do you mean? You say comprehensive information about each guardianship case in Florida. That's so vague and broad. And what my experience tells me is that we need to have actual language that we're proposing. I was on a call this morning, and we're concerned with even finding legislators to move forward with legislation that we would like to propose for our section. So it's late in the game if we're looking at this legislative session. So I understand that this task force has kind of been in a hurry up mode. And I think that's because we're trying to get stuff done for this legislative session. I think that may be impractical because legislators have pretty full dockets at this point. So my suggestion would be perhaps this could be a 2-stage process where we come up with concepts initially, and then this task force can continue and actually create legislative language that is consistent with everyone's opinion, not just a report that we come up with today And then Tom puts it into language that, he's conceiving of. Instead, we come up with a report, and stage 2 would be to actually create legislative statutory language for legislators. Otherwise, it's just talking points. And I think it's very much more valuable if we actually have specific language for the legislature to adopt.
Karen?
Thank you. I echo Shannon's point about the two-step process. I think we've looked at, and I appreciate the fact that Tom brought to our attention all of the prior task force reports that have been generated, which were very valuable. And yet they didn't seem to go very far because they were this conceptual, not necessarily a specific, how do we fix the problem? And we have experts in terms of the staffing. I know we've got representatives of 2 of the largest sections of the bar that have the staffing as well to assist in that drafting process if we need to call on them. I also want to just raise very briefly that I think Tom did a great job compiling this information and putting it in concepts and points that we were going to address. But there are several concepts that I didn't see on here that were themes that were introduced early on. And I want to make sure that we as a task force are going to be able to add those to the list for voting purposes during this process.
Absolutely.
Perfect.
Let's.
Burke, one other thing, going back to our last meeting.
We're calling each other first names, they can. Okay.
The final report from the 2004 Guardianship Task Force, it was raised at the last meeting, and I indicated I offered to go through and check to make sure, because I think there was a belief that perhaps some of the prior task forces did not generate new legislation. And I just wanted to let this task force know that after reviewing the 2004 report, there had been a significant number of changes to the guardianship statute since that time. And I think, the report was passed around by email. I think Mr. Black may have done that. But there is specific language in here. But our legislature passed quite a number. There have been a lot of changes since then. So it wasn't all just smoke.
In 2018, I'm not sure how much of this, and this had very prescriptive statutory language. And in my conversations with folks, that this did not have the legislative legs that considering their proposals were very prescriptive in here as far as direct statutory language.
Is that the Supreme Court's report? Okay.
Can I touch in for a second?
Certainly.
So for the past couple of meetings, I know we talked about a lot of the statutory language in the guardianship reports, but I do also feel like it's very important for us to talk about the alternatives to all of our guardianship issues. It is because we all have to admit there are some cracks in the guardianship system. There are major ones. And it is our job as a task force to actually recognize those cracks and fix them before it's too late. And as a former word, I think supported decision-making is a major fix to a lot of solutions, because a lot of judges don't look at least restrictive options before appointing someone in a guardianship. So as the co-chair of I Decide, I really think it's good to learn more about supported decision-making. And because I'm not saying supported decision-making is going to fix all the cracks in the guardianship system. There's still going to be some cracks. But I feel like that will bring a lot more freedom that, people are being thrown in guardianships that shouldn't be, and it will open up more doors and more opportunities for individuals with disabilities, even non-disabilities, to basically have a life that they want to live. So I really think we should be looking at more least restrictive options than just, statutes and laws because it's important. It really is.
I think Michael raises a good point, and I think that harkens back to education.
Yes.
Specifically. So no matter what concepts we agree on today, I think, and I know that the draft report also includes education. I think that's going to be, it's an important point. Also, I think that there were comments made about overhauling the guardianship system, and I didn't see that in there, just as a whole, as opposed to piecemeal legislation, and that may be something to consider as well.
Other thoughts from task force members? And I'm going to be, we could try with the statutory language, and maybe the concept of phase 1 and phase 2 is a good concept. I know that the elder law section and the reptile section of the Florida Bar have great experience in this, but at the same time, there's a lot of folks in this room represented who may not have that same level of experience and a team of people who could come up with the statutory language. And I think it would be, again, we're trying to honor all perspectives here. I think it'd be very difficult, for I think some people may feel a bit
Intimidated
by moving forward, because they don't have the same team of people who can put the statutory language together. Lawyers obviously are very good at that. I mean, that's what, lawyers are good at statutes. And I think it may, it would be very difficult to say, well, we're going to, as Karen pointed out, since she did point out correctly, the 2 sections of the bar are very good at that type of thing. But I don't think I would not feel comfortable saying, well, let's have those 2 sections of the bar draft the statutory concepts that we come up with, because there's vested interest there. I mean,
But then who would do it?
I just want to, I don't mean that in any pejorative. I'm just saying, I do think that's a problem with us, because when we get into the statutory language thing, who's going to write it, and how is it going to be perfected so that there is a consensus here?
But who would eventually write it? If we just say, like, these are the concepts, legislators don't draft.
But their staff, the committee staff does.
They're actually going to probably want proposed language.
And it can work in different ways. We have Chris Hart here, who's executive director of the Florida Court Clerks, but also he's a former legislator. And we have Mark Pinto. So maybe what we need to do is go to Mark and talk about the legislative process some as to how it works and how it can work. And maybe based on what we said, we're really putting Mark on the spot to maybe talk about that concept. And Chris, maybe as a former legislator, you can add some perspective to the conversation. But Mark, let me introduce Mark, and then we'll have more comments, okay? And then we'll go to the public comment format. Kimberly, I'm not forgetting about that. Mark Pinto is a lobbyist with the Florentino Group, a respected lobby firm here in Tallahassee. They're based out of Tallahassee and do a lot of work in the Jacksonville, St. John County area, representing a lot of government entities and for-profit, nonprofit, public and private entities. And he has great experience in the legislative process. So Mark, would you please give us your report on how that process works and any helpful hints you have for this task force?
Sure, absolutely. I'm trying to pull this a little closer. Good morning, everyone. Clerk Burke, thank you for the opportunity. Senator Bradley, Representative Burton, I know you all couldn't be here, but thank you for being part of this task force. Members, you have 2 outstanding women here serving you in Tallahassee who care really deeply about your issues. So you should be proud to have them here working with you. This is a great group of people. I know I haven't had the opportunity to meet a lot of you. I met some of you yesterday. We see task forces all the time, obviously, in Tallahassee, but I got to tell you, I was really impressed when Ken shared me everything. You have done a lot of hard work, and you're probably wondering, hey, where do we go from here? Do we do a bill, or what? Do we do statutory language? And that's what I'm kind of here to talk to you about. But having seen everything and where you are now, you all should be kind of really proud at this moment of all the information that you've collected. in the short amount of period of time. But you're like today, you're probably asking yourself a lot of questions like, where do we go from here? How do we get a bill? So you have your recommendations, that you've worked really hard on. You're going to give your reports out, distribute them to the President of the Senate, the Speaker of the House, the Governor, the Florida Supreme Court, members of the legislators, and chairs of committees in the legislature. And that's an important part too, giving them to the chairs of the committee in the legislature. Your concepts will be packaged and delivered. Now, once your concepts are all delivered and your package is delivered, you may hear from the governor's office, you may hear from the Florida Supreme Court, you may hear from a chair of a committee, you may hear from a member who gravitates to your issue, and they may reach out to you. They may not reach out to you. But once your reports are delivered, it's going to be incumbent upon you in this short amount of period of time to educate members on your recommendations. And this process really begins with reaching out to the committee chairs in the House and the Senate and educating them on your important recommendations. And then you're going to have the opportunity to ask them, Chair, hey, can I present before your committee? These are the findings that we have. Now, keep in mind that the topic that you all are discussing is a very, very important topic, obviously, not just in Florida, but nationally. So I see it gaining a lot of traction on its own. Whether or not it's addressed this year or the following year, this is something that the legislature is probably going to want to take a look at, given what's going on nationally and in Florida. Now, if you're given the opportunity to present before a committee, obviously this is a big step forward, in filing a bill. This is really your shining moment to present all the facts and all the recommendations before a committee. This is not like you're going to be given 3 minutes or whatnot. You're going to be given the floor, you go up, and you're going to be able to talk before the committee and give a formal presentation, whether it's a PowerPoint or not. The committee's going to vet your concept, and they'll ask you questions. And then after presenting a committee, this is where things really start gaining momentum, and there can be a news story, and conversations will begin circulating. You'll start to feel the momentum building at this time. Now, after the presentation, the chair of that committee could potentially reach out to you and say, hey, you know what? I like your recommendations. This is something that we thought of before. Maybe we're going to start a committee bill. And basically what a committee bill is, the committee itself will take your recommendations. They'll have their ideas as well from the entire committee and form a bill known as a committee bill. And then that bill will go before that committee, be voted on, and then have a member sponsor carry the bill from there. Or another alternative could be, whereas a member will pick up the bill itself instead of the committee, and the member may say, hey, you know what, I like these concepts. This is something that I had been working on myself, or this committee had started working on, and I will file the bill, and then that's how the bill moves along from there. This is really the bridge kind of where we are now from where you have your concepts, and whether you develop them statutorily or not, or do you bring your concepts to them and bridging the gap to filing a bill? So, and then the bill will go through the process from there. So I just didn't know if there's any questions, but whether you all want to do this statutorily or not and give them a bill, I've seen it that way, but task forces also give recommendations and ideas. And anyone that knows through the process, give the legislature a bill, they're going to make it their bill as well. They're not just going to take your recommendations. They're going to have their recommendations, and some of the recommendations that you have, quite frankly, they may not want as well. So that's going to be up to this committee, this task force, to decide how you want to be able to package this and present this going forward.
Mike, you have a question or comment?
Big question.
And right in the front of the microphone.
And maybe this is for you, but when I hear you may appear before a committee, who's you? Is that Penn appearing before the committee? Who's that going to be?
I think that's going to be for all you to decide who would be the, who would be the best voice to speak before a committee.
26 people showing up.
So,
speak. Okay.
And sometimes it's 2 people. So, and sometimes it'll be up to the chair to decide as well of that committee. But that's a good question.
Mr. Hart, do you have any comments to add or words of wisdom as a former legislator in the process? Did you have extemporaneous speaking in school?
Yeah. Let me get my prepared speech out here. So, no, thanks for inviting me up. I think the conversation is a good one. It's the right one for you all to have. I'm actually going to start with this gentleman's question.
So, and just so you know, I've chaired 3 task forces, statewide task forces. So not only being a former legislator, also a former aide. Roy and I have known each other since I was 24. So I mean, I've been an intern, an aide, a legislator, and I've run task forces. So I think my perspective is pretty good for what you all are doing. But this gentleman over here, I would start with this. The task force product that you're about to vote out, it is the task force's product, right? So it's all of you coming together with your collective wisdom. It really is. And so it's not unusual for a task force of this type with so many varied interests coming together to stay at the higher level concepts, right? So the task force report you're creating is really well articulating the problem statement. And this gentleman over here, you know, he said there's a problem with guardianships. We recognize that. And I think that's true. So part of what you're doing is you're highlighting the problem. So you're putting out there the problem statement. And then you're coming together collectively in all of your self-interest, but coming together collectively behind your report to say, this is where we think we need to go as the state of Florida. So when you are asked, which I believe you inevitably will be by at least one committee in the legislature to come and present the task force findings, I would suggest it's more than likely going to be Ken as your chair, maybe someone else, but the presenters will be presenting on behalf of you, the collective. So the presentation could not be made by Ken Burke as clerk, Ken Burke from Pinellas County, clerk perspective. It would be his job as the chair to stand there as the chair and present your collective concepts, those recommendations that you've put forward. So now let's take that, right? Let's take that and then go to the question of whether or not you actually write out legislation. Writing legislation is potentially a dangerous game because that is where the self-interests come in, correct? So that's the brass tacks. That's where the rubber meets the road, and that's where we can start to fracture here. So in order to have the biggest impact, and I think you're already having an impact because of the conversations you've been having, my recommendation is stay as true as you can to the collective. Find those things, that coalition of the willing, those things you can get behind. I think you said prioritize them 1 to 5. Find those big things that really need to be done in the state of Florida and just hammer it. Just hammer it as a task force. And then more than likely what will happen, now let's get into kind of the details of it. If you present before the committee and they decide that they like the idea, it can become a proposed committee bill. They have the skills within the, believe me, within the legislature, they have the skills to write new statutes. They do it all the time. They have staff attorneys, they have bill drafters. They do this all the time, every day. They can do that part of it. And they probably will if they decide to do that. So it could become a proposed committee bill. Or you could have a member. A member could be sitting there in the committee, hear some ideas, and maybe not want to take all of your proposals, but take some of your proposals and write their own bill, sponsor their own bill. Probably don't have the actual expertise within their own office to write those. And in those cases, legislators sometimes will reach out to individuals and ask if you have proposed language. So that is correct, happens all the time. But other times what they'll do is they'll go to bill drafting. There's actually a bill drafting service within the legislature, and they send their aides to bill drafting, and they do it all the time. And they say, here's the idea. This is what the member wants to see. Draft it up. They do. It's a confidential process until that bill gets handed off to somebody else outside of the office, and they go back and forth on that all the time. So don't worry. I mean, proposed language can be written either with or without you. But I do like, I have to tell you, Mr. Chair, the idea, if you're willing to stay together as a task force, to look at a two-staged approach. But I would definitely start with get those concepts out there first, because that's where you're going to have the biggest impact. That's where you're going to make the statement. That's where you can stand there together collectively and say, we came together, we decided these are the 3 to 5 things that must be fixed within the state of Florida first. And then after that, if you find that they're asking you for details on those questions and you want to come together and try to write legislation collectively, then you could tackle it at that point. But I would recommend you start with the concepts.
I have a question for Chris and Mark, and either one. Thank you for those remarks, Chris, and excellent extemporaneous speaker there, boy.
I'm glad I put on a tie today because I've been wearing COVID, bro. I wasn't even sure this would fit.
Let's say, and I hate to use an example, but I'm going to use the example because it's an easy one to use. The task force has expressed concern and some consensus that we need more data. It's hard to fix a system where there's no data collected statewide currently. And so let's say the concept of having the Department of Elder Affairs charged with establishing a data bank. Well, wouldn't the legislature kind of basically come up with some type of language saying, hey, Elder Affairs, you're charged with doing this. You have to come back next session with an appropriation, with a scope, with a, how are you going to do this? What information is going to be collected? And is that something the legislature in the past has done, is charge an agency which basically saying, we want this, but obviously none of us can come up. We're not experts on how much software would be developed, the cost of a data system. We can spend all the time in the world in this task force. We still wouldn't be able to do that. But we know it needs to be done, and that we need to know the legislature needs to direct some agency of government, and I should pick on Elder Affairs, whoever they determine is the best one to have this data bank. But is that how would that work as a process? If we put that concept that we need data to help make sure that we, instead of anecdotal stories, we know exactly how it's done in each circuit and how many cases it is and how many gardens there are and when they start and finish, and if there's discipline, whatever the data points are. How does that, Mark or Chris, with something like that?
I'll start and then I'll turn it over to Mark. So like most things in life, the answer is depends, right? So if you all have talked about this to the point where you know exactly what it is you're asking for, the more specificity, the better, right?
Okay.
But my guess would be that you don't have that level of specificity. Like you don't know exactly what the system looks like. You don't know exactly how it would need to be administered, exactly what the cost would be. So what you could do and should do to be more impactful is the concept. But then as much as you can, maybe 3 bullet points below that, you specify what the objective is for that database, right? So we want the database to be able to do X, Y, and Z, because as that goes to the legislature, and if they decided that's a good idea and they want Department of Elder Affairs or someone else to look into that, they're going to want to be more specific as they tell that department, because what legislators know as policymakers and budgeteers is they don't really have a lot of control. But if they can be more specific when they make a request, the chances are they're going to get back something a little bit more similar to what they're hoping to receive from the department. So the more specificity that you can provide with that request, the better off you'll be, the better off that they'll be, because it's then going to go through a whole RFP process. That's a whole other thing that none of us would ever really enjoy.
Mark, any comments there?
Yeah, I mean, to echo Chris's point, I mean, we see this in bills all the time, and we worked on legislation like this as well. I mean, try to get specific as you can, but it's going to be up to that department as a whole. Once they go through the contractual process of issuing an RFP, that's where all the details and all the sausage making happens, going from there, how it's all built upon. So lay out how you would envision it, and then pretty much it's going to be up to the department and through the RFP process of how this is going to look like.
Yeah,
So.
start with what you want to achieve,
Mhm.
really. I mean, like, what is it you want that system to do for you? And then be as specific about that as possible. The technical aspects of it and the costs will be worked out.
Questions for Chris and Mark?
And just to echo again, remember when you're writing out something that's specific, and if it's put into the bill as legislation, the department has to follow that. I mean, that's going to be into law. That's not going to be a recommendation or whatnot. That's going to be in law. So they're going to have to follow those parameters as they craft that RFP. So keep that in mind.
Questions? Yes.
Just a comment that I think both Chris and Mark touched upon. The fact that once this legislative process actually gets underway and the committees are considering it, we may put forth 5 recommendations or 20 recommendations, and the committee may only take 2 of those, whichever they determine to be most appropriate. So while I like the idea of prioritizing our recommendations, I don't necessarily think that means we should limit our recommendations to a specific number. I think we should put forward all of the best recommendations we can.
Amen.
And Mr. Chairman, if I could piggyback on that, and you might not be happy that I got this mic for, sorry. I want to say this to all of you too, and I think this is important. And when I did the BP oil spill task force to kind of give you some context, the Workforce Innovation Opportunity Act. So I mean, it was like this. I mean, lots of different players coming around the table, with different self-interest. So what we worked at is staying true to one another and really getting behind those, 3 to 5 big recommendations that we have, so that it's that task force is saying, we want to see the legislature do this. But there was also an understanding, because look, at the end, and the question already came up about kind of the minority report, there's going to be disagreement. There will be disagreement sitting around this table in terms of the details. And the fact, just so you know, the fact that you get behind collectively 3 to 5 big priorities and things that you want to see accomplished, that does not diminish, and it does not stop any of you, in my opinion, the chair will speak to this, it doesn't stop any of you from going to the legislature with your own ideas, right? And also injecting what you think needs to happen in terms of the details as you get into some of that. So, that's kind of the push and the pull of what happens with a task force like this. But I would expect that some of you will probably have some legislation in the future. But if you can agree to those big principles and concepts that find their way into this task force report, I think then you have the greatest likelihood of making a positive impact.
Any other questions? Gotcha.
Yes, how much time is usually allotted for presentations to committees?
It completely depends on the chair. I mean, it really does. When Senator Gates was there, he wanted me to come and present on the rimming model for the state of Florida, and he gave me an hour and a half to present. I would have liked to have had 2 minutes. So it depends.
Yeah, it's up to the committee chair at that point. I mean, it could be half an hour, it could be the whole block of 3 hours. It will just depend on the committee chair and the issue.
Thank you.
Other questions or comments? Hillary?
If I could just, this is really, if I could just make a comment that we always have to keep in mind that we are here for the benefit of the elderly and the disabled community. This is a very serious thing that we are doing, and I'm thankful for Sancha and Shannon because they do have quite a bit of expertise. But again, I sit here and I start to get a little bit, I don't know, just a little bit just shaken, because we just have to remember that we are here for people that we don't even know about. We don't know how many elderly and disabled people are, as we speak, in locked facilities that don't need to be. And that is why we are here. Thank you.
Any other questions for Chris or on the process? Thank you, Chris. And thank you, Mark, for being with us today. And Mark, I know you have other responsibilities today, so thanks again for taking the time. Kimberly, would you please go through the public comment process today? And your microphone's not on, Kimberly.
Good morning, everybody. For today's in-person meeting, we're going to do public comments slightly different than we've been doing for our virtual meetings. We've reserved the final 30 minutes to take public comment. And as you see on the screen and as being projected on YouTube, for those that are attending virtually, please feel free to go to guardianshipimprovementtaskforce.com, and you can go to the contact page and submit written comment there. For those of you that would like to participate with virtual or with in-person comments, excuse me, Patrick, if you don't mind waving. Patrick has comment cards. And so if you would go over to Patrick, you can grab one of those cards, fill out your intent to speak. We will give 3 minutes to each individual wishing to speak in person today. There will be a sign for 30 seconds, 10 seconds, and time, just so that we can be respectful of everyone who would like to speak today. Our process will be to take those in the order in which the cards are turned in. And so Patrick is keeping track of that. Make sure that you get them. Again, Patrick right here, he's got his card. And as just a reminder, we are reserving, as stated on the agenda, that public comment is restricted to only those that are in the room today. We are not able to take virtual comments. Thank you.
Any question of a task force member on public comments? Okay, thank you, Kimberly. Excellent job. Well, why don't we go ahead and get started? With the robust discussion already. I've lost my agenda. Okay, here we go.
Clerk Burke, did we need to vote on that issue of whether or not we're just going to make it broad, or we're going to do a two-step process, or did you want me to make a motion on that?
Shannon, maybe what we need to do is hear a first issue and then see and kind of measure it and see which direction we go into. Because I'm conflicted now too. I maybe like the two-step process, but I'm not sure which way we should go.
And Ken?
Yes, JD.
And I'm not sure exactly where, but there's still some fact finding that I feel like I wanted to sort of get from some of the committee members. So
very good. And Karen, you brought up a point, and maybe before we even get into Tom's presentation, were there items that you want to add on to the concept list that were not on? And Mike has one, so I'll give you a moment to catch your notes. I know you're very thorough. Mike, go ahead with your item.
Well, the one I'd like to add that I think I heard from comments, and I think I brought up some, is just a general concept of anywhere possible, the involvement of the ward should be increased.
I say that again, Mike.
The involvement of the ward should be increased.
Oh, involvement. Okay.
And I think that's indirect in one or two places, but I think it should be directly in there.
Okay. Who else has a concept which is not on the list that we should add to the list? Sanchi, you had a big one. Total overview of the How did you put it? I don't want to put words in your mouth. You're the lawyer.
Overhaul, I think might have been the term that I used, but I think that we, both in written comments, and I know a number of people spoke about the fact that guardianship needs to be a complete overhaul.
And Sandra, that may be in that second one, the one that talks about the future task force. That's a government sponsored one to given that task.
Clearly that is beyond the scope of this task force, but to speak to that, I think that, and I know that Shannon will probably agree with me about this, but piecemealing legislation in guardianship just creates more fodder for attorneys to fight about and cost the wards more. So I am concerned about any kind of, further piecemeal legislation, because it is, the judge and I had a nice conversation last week about a statute that could have been interpreted a number of different ways. And one of the things that I raised also with the OPPG recently is that in guardianship, you don't see as many appeals, and we don't want to encourage that. I think what ends up happening is if you have a guardianship that doesn't have millions of dollars, you've got somebody who has, a nice sum for me perhaps, but they have reasonably modest estate.
Indigent appeals.
Well, right. And so the point is that the legislation and this, our statutes aren't going to be refined in that process because it doesn't happen that often and shouldn't. You don't want to use the word's money to fight, grandma's money should not be used to fight for someone else's, betterment later on. It's something that really ought to be done in the legislative process. You don't find that in other areas of the law because there are appeals.
Other items that were left off, Karen, you had some?
Yes, thank you. The medical healthcare industry pipeline to guardianship process, that was something that was raised as a task force goal from the get-go.
Okay.
I think that needs to be discussed. Sure, sorry about that. So the medical and healthcare industry, addressing also the alternatives for the medical industry folks, such as what's proposed in that article that was circulated and mentioned in our prior meeting with our national experts. There's also kind of piggybacking off of what Sancha just talked about with the cost of the ward. I know there's been a lot of questions and suggestions about additional options for family members and parties to have a less formalized outside of the court system process for resolving disputes, something that doesn't cost as much for, especially something that doesn't need to be litigated or is really something that could be mediated outside of a courtroom. And I think that we also, actually, Brooke, I believe that you raised as a task force goal, and I echo this, the improving the process and reducing barriers for the restoration of capacity. That is a point that's been addressed numerous times, and I don't believe that was on the list of recommendations. And finally, the concept or right, rather, of a ward or an alleged incapacitated person to retain counsel. That point needs to be clarified. Thank you.
Okay.
All right, Ken?
Okay. We got JD, Shannon, and then, Viviana. Okay, go ahead. Go ahead, JD.
So a couple of things. I agree with most. Although it could probably be done there, but certainly on the court rule side, because that's the reason you're there in the first place. There's a court rule that says every guardian hires an attorney. So, and that's a court rule. That's not statutory, that's a court rule. So how is there a way to make sure that there is a specific requirement that the privilege for your client is the ward who's paying the bills, not the guardian who selected you? And really, that's my question. I've got some follow-up to that. Shannon, you may be able to sort of answer that relationship.
When you say privilege, do you mean like attorney-client privilege, like information? I'm not clear on what you mean by privilege.
Well, y'all have used the term a couple of times about privilege and expertise. So do you have a duty to the guardian or duty to the ward?
To the ward.
Okay.
You have certain duties to your client as well, but as guardianship attorneys, which you know, it's an unusual role for attorneys. We normally would have one client, but in a guardianship proceeding, we actually have duties directly to the ward, even though that's not our client.
And JD, I don't want to stop this conversation. I want to put, my question, this part of the agenda is what concepts have we left off the agenda? So let's just put that down as an item that obviously you want to put on the agenda. So we will, okay? So we don't, this is not the time to debate that topic. We're gonna do that in a few moments.
I'm not trying to debate anything.
No,
I'm more soliciting information. That is not the case. Of my office, of guardians that are doing that. Guardians are bad. I do not. I think a predominant, most, all of them do wondrous work for the people they're working for, including the attorneys. And so I don't want anybody thinking that somehow I'm against you, because I'm not. I think you're a critical part of the solution to the problems here. And generally what we're talking about is the bad actors, which is a very small percentage of the people we're having problems with here. The problem in this kind of environment with guardians is because you have taken somebody's liberty from them, the impact of a bad actor is huge. And so therefore, you can't rely on it. Everybody's going to do right. It's the old theory of us accountants and the people that do accounting. Trust is not a fraud prevention. You have to have structural incentives to keep that from happening. And so that's the reason I'm diving into this issue of how do we solve to make sure that the attorneys, who are even the ones who are hired by the guardians, their job is to report back to the court, even when the guardian's not doing something right. Because I've never heard an example of a attorney that works for the guardian going to the court to say that this guardian's doing bad. What happens is they ask to be removed from the case.
They withdraw.
And-
They're bound by an attorney-client.
And again,
There you go, right there. You just said it. They're bound by attorney-client privilege. So to me, I don't think it's I don't want to blame that attorney. What I want to do is change the system so that your role, your client, attorney-client privilege is the ward. So therefore, your duty is only to the ward. And so I think that's a structural thing that all these other concepts will, if we could solve that, so that now we have making sure everybody in the system is looking after the best interest of the ward. A lot of these other concepts will help us. So thank you.
Okay, so the inherent conflict of interest of the attorney representing the guardian is the concept you want to put out there.
It's inherent. You don't have to, there's one of these concepts is disclose conflicts of interest. It's built in. You don't have to disclose it. It's designed to be a conflict of interest.
Okay.
Whether you call it or not.
We'll add that to the, and I think we have that somehow on some of these things. I thought we did have in the concepts, but maybe as we discussed it, we could see if they really are there. You had a concept you wanted to add, Shannon?
I think Sancha wanted to.
Well, I think ancillary to what is being discussed, I think there's a misunderstanding too about the role of the guardian, because it is not always best interest. It is substituted judgment. And if, for instance, if you have someone who is a ward of a guardianship who smokes 15 packs of cigarettes a day, the guardian's role is substituted judgment, not necessarily best interest. In certain circumstances, now that changes depending on what the circumstances are, but I think that that's something to keep in mind, what we're asking our guardians to do.
Shannon, did you have a concept?
I did. We did file a motion with prescribed, language for the court monitor provision. And I noted in the original report, it wasn't there. And also it looked like in the original report, it was letter F as in Frank. And then when we had the substituted provisions that came out, I think yesterday, even letter F is not in that new version. So what I see there is that it says require court monitor system in each county with effective measurable outcomes. That is not consistent with what we've proposed, which is to adopt really the Broward County method of using court monitors. And we did provide language.
And during that part of the, we could discuss that. Okay.
The language is not one that will be approved by all, because
Right.
you are basically kneecapping the Ninth Judicial Circuit.
Right. And
Jose, we're finding which topics we need to discuss. We're not discussing the topics now. Okay, so.
But again, in what we have been instructed that we need to find common ground, that's the number one.
But neither of those is in this proposed report. So that my concern is that Judge Morley also put forward a motion that kind of crafted the language differently. And neither of those are reflected here for discussion. So I'd like both of those to be added so that we can really vet the issue of court monitors.
Okay, thank you. Deanna?
Oh, Viviana.
Viviana, I'm sorry.
Okay. So I would like to add to the agenda, number 16 touches on alternatives to guardianship, but what it says is that we want the legislation to say that the orders need to say why an alternative wasn't used, and there already is some of that in the law. I would like for the agenda to include actually adding what are those alternatives to the statute. So do we need language about supported decision-making in the statute? So I'd like to add that to the agenda. I don't see anything about fee caps and other accountability measures that have been discussed. I'd like to have a conversation. I'd also like to add, talking about an alternative, not an alternative, a solution to the school to guardianship pipeline. So requiring that schools provide information about alternatives like supported decision-making when they talk to parents and other caregivers and adults who care for students about guardianship. They should also talk about alternatives. And then lastly, and I think this relates to what we're talking about, right now, when a person is under guardianship, once they've been placed under the guardianship, their attorney goes away. They don't have someone who's constantly representing them, for example, for annual guardianship reports. So can they keep their attorney? Because the guardian always has their attorney. So should the person under guardianship.
Kind of gets to JD's issue there.
Yeah.
And
Zane?
Hopefully this is on. So in addition to the medical pipeline that Karen mentioned, I would like to expressly state the long-term care industry, which would include nursing homes and ALFs. I know on number 20, we have about self-reporting conflicts of interest, but that's not going far enough to actually understand the extent to which it is used and then how it is used and in what situations. So if we could maybe raise that.
And that's definitely been a talking point for this. We try to incorporate it there, but we need to be more specific.
I apologize. I missed one thing too, is the difficulty of terminating a guardianship. Is there anything we can do to make that easier for people?
And part of the challenge of this task force, and we have many challenges, obviously, is that it's anytime you're dealing with the court system, you have court rules and statutory rules, and there's only so much that can be done in statute, and the court has certain, as a separate unequal branch of the government, has a responsibility to go through. But it's so on a lot of these, you get to the question, is this really a statutory thing that can be fixed, or is this an overstep by the legislature on telling the judiciary on how to conduct its business? So, and to Sancha's point, maybe some of this and other states seem to be doing this, that maybe a lot of this needs to be taken out of the court system, and really the court system is probably the not as most appropriate place for some of this, and maybe government agencies can do a better job with this, with the court playing a less significant role. But that's, again, that's a big, hairy topic. That's a complete overhaul of the way the system would operate. But I know other states have, and that was part when Tom gave his report, other states have done that. And that's not on our here as a concept, but that's something as if we do have in here about a subsequent task force, maybe a government-sponsored task force, which has its negatives. By the way, a government-sponsored task force, we couldn't do a lot of conversations of picking up the phone and speaking to Jose and saying, gosh, what's your feeling on this here? And I've been a part of the task force too that had those restrictions. It is very restrictive because the only time you can talk to each other is at a formal meeting like this. And that's not always productive. Even like Anthony and I trying to plan today's meeting and getting together, and we couldn't do that. So it leaves it to one person almost with staff to plan those things. So be careful of some of the things we want because, having the independence, the problem is, I can tell you, as great as the Clerks Association has been to support this, they don't have the bandwidth for the ongoing support of this task force. So that's one good thing with if a government-sponsored task force. There is some usually government employees who can staff it, but the down part is the sunshine law. Hillary, you want to say something, and then we'll move on to Tom presenting the first thing.
quite briefly. I'd like to mention the OPPG, the Office of Public and Professional Guardians. You know, more has to be done. I don't know if it's staffing. I don't know if it's advocates, you know, being on the hotline, but more has to be done. And we have got to have more transparency, that there has to be every year a list of the disciplinary, you know, actions for guardians. And it's, you know, it just has to be done, has to be done. And, you know, not to quote an attorney in Hillsborough County, but, you know, that equates every AIP as a child. Well, if a child is at risk, they will be removed by DCF. But if an elder person is at risk and there is a complaint made by a family member or a mandated reporter, you know, that person is left in that guardianship, you know, lingering under a potential abuse for years. That something has to be done.
Okay.
You know, time is of the essence.
OPPG, we'll put that down as, you know,
Thank you.
additional point there.
I do have, because I was looking over this thing, and there is one, and it doesn't have to be fixed. We can fix this like on future like task force meeting. But there is a word that, you know, I feel like needs to be renamed, because when you put someone under guardianship, they're still a human being. So I feel like ward is not really appropriate to call someone under guardianship. That's basically like labeling someone when you're basically saying, oh, you don't have a say in life, you're just a ward, you know? And that's why I advocate, like today, I'm wearing a shirt called Label Jars, Not People. Because you're basically labeling a person when that's basically labeling a jar, you know? And I feel like there's other words that we can call a person under guardianship than just a ward. Like, who came up with that? I don't know. But I feel like that's something that should be looked at and should be renamed.
I agree. My father is no longer in guardianship and he's still referred to as a ward, so.
Let's wait to be recognized. I appreciate it, Hillary. But
Sorry.
And Michael, have you concluded your remarks?
Yeah.
Okay, thank you. And I'm going to apologize to you because that topic's been brought up numerous times and that just escaped us. And that should be on this list.
That's why I brought it up.
So thank you again, because that's a national conversation too on that topic. Jose?
I'm sorry, I just had a light bulb go on. I hope it's 100 watts and not 15. So I'm just going to toss this idea out because as I was reading the things that we thought were important and sharing the concept with my colleague Sancha Brennan, that probably some major rework has to happen. One of the areas that as a judge, I never heard whether or not there was accountability. I always would watch it come up in a lawsuit later on, is trusts. And how, although I realize that they are an alternative to guardianship, there really is no accountability for trusts. If there is any, it is minimal. It is to allow the court to know that if guardianship trust funds are used and placed in a trust, then the court has to be advised that it's in a trust, but there is nothing, it goes and it's goodbye.
That's becoming a significant issue, especially for
Thank you.
the oversight role
Well-
of anybody who's looking over the oversight of it. You lock it away in
Yeah.
a trust and now nobody gets to see it.
Thank you. Appreciate that.
I think it was 100 watt.
That's how it was. Good. Yes, Karen.
Sorry, one last, this is kind of a procedural question, and I do have this noted as to some of the specific comments we're going to go over or recommendations we're going to make. But I do think that whether it's in the suggestions or it's a section on its own, I want to make sure that we refer and cite to some of the existing statutes in other disciplines. My area is criminal law, so I made a lot of notes in terms of the parallels with the criminal justice process with mental health review, just so the legislature is considering those statutes and that language for consistency purposes and for funding purposes.
Excellent. And Robert and Teresa, who I work with in the Pinellas Clerk's office, are taking notes over there. We're hopefully are going to take, and Kimberly, and maybe Patrick, if you could help with this, we're going to take what has just been added to our concept list, which is a lot. And I think some of them are embedded in some of the concepts that Tom's going to go over. Maybe we weren't too artful in our wording that we sent out, but they're going to try to print up this list. If there's a way, Kimberly, I'm not sure if we have access to a printer here or we can. Okay. Okay, so they're going to come up with a list of comments were just made by everyone to see if we can print that out possibly today and give that to each of us. So anyway, I just want to let you know we're attempting to do that. So Tom, why don't you take it away with the first one, and that's the idea of some type of database.
Thank you, Ken. So just let me say first, though, that to the extent that we left some of these things out, or it's perceived that we left some of these things out, you can totally blame me 100%. I was literally trying to capture the things that I thought there was lots of consensus on and trying to do it in all candor at the 10,000 foot level. I literally was trying to avoid the specific things. So for example, the thing about monitors, I knew we had that specific proposal, but I was trying to capture the concept that everybody thinks there should be monitoring in every county. And then later we would talk about how that exactly works. I wasn't trying to preclude the motion that was made or that we use the Broward County model. I was just trying to say, can we get agreement that we should have monitors everywhere? So that's the way I was looking at it as I went through it. I want to, and I'll ask the chair to reserve me a little time later I want to talk specifically about how we go forward in terms of actually doing the report. I know there's maybe minority reports. I know people may want to include some big section about what they want to say. For example, Veterans Affairs, they may have issues that are unique to them that they want things in. So with the chair's approval, of course, I'm more than willing to have people submit stuff to me that I'll try to incorporate into the whole thing. I recently did a Supreme Court case in which there were 8 different people who filed a comment in a rules case. There were 25 lawyers who were trying to craft one reply. I got charged with being the one lawyer. I got the short straw. I was the one lawyer who was trying to take those 25 things that lawyers were saying to me and put it into one document. So I've done it before. When you do that, you're not going to take everything everybody gives you, but you try to pick the things you think represents the overall thing. So we'll definitely try to do that going forward. So the first thing up is a comprehensive database. I think it was the very first thing that was mentioned in the very first meeting. My recollection of that meeting was everybody shook their head saying yes, that we agreed we needed data. We can't find, and I had a very short section in the thing that said about, most everything we heard was anecdotal. We didn't have anybody present statistics from us from some source where they had access to data and they gave us those stats. It's not really available anywhere. If you haven't read the most recent article about, well, I don't know if it's the most recent, but it's a very recent article by BuzzFeed News about the whole guardianship process. It's a 3-part thing. One of the first points they make is there is no comprehensive data that exists in the guardianship system. They made public records requests in all 50 states and found that more than half the states had no usable data at all. Unfortunately, Florida falls into that category. So I think this was one of the ones we all agreed was probably something we want. I tried to capture it, as I said, again, at the comprehensive level. In the court system where I worked for 25 years, we would get reports like this. I've been on committees, lots and lots, way too many committees over the years. And it was pretty much as I think Chris said, or maybe the other speaker, you try to say, we want this database. You try to give them some idea of what you want. And then from there, as you go through the legislative process and you go through the RFP process, when whoever gets it, that's when you really develop the details about what goes into it. So that's where we structured this the way we did. And then I guess I'm going to turn it back over to Ken now to sort of lead the discussion, unless anybody has any questions specifically for me.
Let's not get into the details of what the database but a general database of some guardianship information on a statewide level. Is there a consensus that is needed? Okay.
Can we call it a unified tracking system as opposed to a I'm obviously, we have some
Uniform.
concerns about privacy rights for the wards. So, yeah, comprehensive information is different somehow to me than unified tracking system. We want to be able to make sure that somebody who's investigating a guardian, for instance, can determine how many guardianships they have and no matter what jurisdiction they're in.
Even across counties, because that's one of the
Absolutely,
things that we have
that's one
found.
of the problems.
It's extremely difficult.
Yeah.
Okay. Let's go Hillary and we'll go right around the room here.
Karen.
We're going to go right around the room. Go ahead, Hillary.
I'll just, again, the privacy thing is to me, it's really, it's enough. Again, not to quote my colleague, Viviana, but we are not looking for health issues, health information, or financial information. We as advocates are looking to see how many wards are in Florida. How are they doing? Should their rights be restored? How much, maybe how much the guardianship has cost them? How much were they charged by the attorneys and the guardians? But the end all is, are they healthy? And should they have their rights restored? And are there least restrictive alternatives? That's all we care about.
Right around the room, any comments? Shannon, you have a comment?
I would like to see a tracking system. I think professional guardians, it's appropriate for them to be listed and, the number of cases that they have from county to county. However, I do have concerns about family guardians being listed. And I think what that will do is if family guardians become listed in this database, that means that everyone will know that there's a guardianship established for their family. And it could be searched. It could be searched by people who may not have good intentions. And with all due respect to Hillary, I have a lot of clients and they don't want someone knocking on their door and saying, can I see your mom who's bedridden to see if she should have her rights restored? There are lots of privacy issues. Wards should be able to say if they want someone to come and see them. It shouldn't be something that's just publicly known. There are a lot of people who go through the guardianship process, and it is incredibly embarrassing and humiliating to be someone who needs a guardianship. But that does exist, and that's for the majority of guardianships that exist. So I would prefer that this tracking system include data that's anonymous as much as possible. The data include information related to professional guardians, but as much as possible, family guardians in particular be permitted to have their names not included in that tracking system. Because a lot of people will say, I'm not going to be a guardian then for my family member, and that's going to shift more people into professional guardianships.
Mike?
We didn't talk about this, but I had the exact same comment. I totally get that if you want to know if somebody has 5 wards in this county and 10 in another county. I see no benefit to having the name of a parent who has guardianship over their adult child. And so if a motion's appropriate, I'd move that we have that list of names, not exempt relative guardians.
We want to have discussions first before we get into motion. Karen?
I think that this point is actually 2 separate points. Personally, I think this could be broken down, whether we're calling it a database or a data tracking system. The information that is monitored by Office of Public and Professional Guardians is for the guardians specifically as a profession. And so those points that we have about discipline record, how many cases any particular professional guardian may have, that type of information seems to be its own database from a professional monitoring standpoint. And then there is the separate question of data collection from individual cases, which would then be probably more sterilized, so it doesn't have that information that would yield confidentiality issues or privacy issues. I think that also might address this family guardian problem that we're talking about. I'd also suggest, kind of in that same vein, that we cite to some of the other agencies that already do this professional guardian database, like Department of Health and Department of Business and Professional Regulation, that have a way to check to see if somebody's compliant, if they have disciplinary records, the Florida Bar. These are examples that we can cite to as, potential examples. And I question, lastly, whether or not, especially since there's two different systems here at play, it seems that the information that is collected on cases individually is something that is currently in the possession of the courts and the clerks, not in the possession of any other department. So I don't think that putting any department by name in this recommendation is necessarily appropriate or best. I think we need to suss that out a little bit more.
We'll rather very much on.
Oh,
Michael, go ahead.
you want to go?
Nope.
Oh, you sure?
I already have.
Okay, I didn't want to interrupt you.
I've spoken more than I should.
For a database, I kind of feel, okay. And I'm gonna use my kind of like my I think there's audits all around the state, okay? And to me, I don't understand for data, if we want to do a data collection, why each clerk cannot appoint one person to do audits on all of the guardianships that's going in and create kind of like a list of who should get reevaluated or who should not. Because, I know the states, for example, for security, some people send someone from the state to audit files to make sure we're all to compliance. That should be the same thing for guardianship, and that should be the same thing that the comptroller should do for the guardianship statutes, to make sure that people are not being in guardianship that shouldn't be in guardianships anymore. That's my personal opinion.
Certainly a good idea, and I certainly am certainly supportive of having an entity that audits my office, make sure I'm doing what my job is, because it's statutory. I have a responsibility, and certainly I will be the first to tell you that I don't know that we as clerks have done as great a job as we could have in that role. I think we're getting better at it, just like everybody in the process is trying to do better. And I speak for myself, not for my fellow clerks in it. But granted, there's some concerns. So we're a big believer as comptrollers and auditors. We're a big believer in oversight and audit roles. And so I have absolutely no problems when somebody comes and checks me to see if I'm doing things. So I'm a big believer in that. But back to the database in relation to what's private and public, I think that the need for the database has multiple roles. Hillary had one role that she wanted to be able to see. The investigative team and oversight team has a role. The judicial has a role. So it has to be a comprehensive, whether you want to use the term unified, comprehensive, whatever, it has to have enough data on both private, public, and family to do all the different jobs. If we get into the details of which components, private and public, that can be sorted out during the process of establishing the database, because you're just talking about which component's a public thing, which one's not, and protected. Our families protected, family and guardians protected a little bit higher. That's substance of or specifics of the database and how it protects data. The database has to do multiple jobs, and so therefore I wouldn't want to limit what data points going in. In other words, I don't want to carve out all family guardianships from the database, because now two parts of the system have just lost their ability to have a comprehensive sort of look at things and history of things. So that's my concern about that. I think that the confidentiality is part of it, but that doesn't drive the fact that we need a comprehensive database.
We're going to go around the room, get back to you, Jose, there. Who's next here? Do you have any comments?
Viviana.
Any comments here?
I'll just agree that I don't think it is a good idea to label which agency would be charged with the database. I think it's smart to let the experts in the agencies decide who is best suited and equipped to be able to do that process. And then I may be jumping ahead a little bit, but I do think in the database discussion, uniformity of forms is key, because it won't matter if we have a database collecting information if we have 67 different forms at intake or in the court judicial process, and you've got all these different data points coming in. So I think uniformity is key in this discussion as well.
Viviana?
So I'd like to say that.
Oh, Viviana, would you move that microphone real close to you?
Can I move it? Oh, I can. Okay. This is great. So I'd like to say that I believe that family guardian should also be on there. I've heard a lot of folks here say that part of the reason that they need professional guardians is because sometimes family members have bad intentions. You can't have it both ways. You can't make that argument for one thing and then deny it in another place. So if people are potentially at risk with their family members, then they should also be on that database. It's already, you can already look up if someone's under guardianship. Those court records, you can find out if they've had a guardianship case. And I also think that some of the arguments that have been made it's a little bit of fear mongering. My understanding is that when people like Hillary Hogue and others get involved, it's not because they were going around looking for someone in trouble. It's because someone came to them asking for help. So I will say, I don't think there's people running around trying to find people in guardianships to save them. It's people, the people who are in guardianship are reaching out for help. So that's my comment.
Thank you. Sean or Gina, do you have any comments?
Yeah, I just wanted to reiterate what some other folks have said, that I think a certain amount of data collection
Gina, are you
is
trying to speak
necessary.
because we can't hear you? There you go.
Yes, I'm
Now try.
speaking. Can you hear me? Can you hear me?
Oh, we still can't hear you, Gina.
Computer audio.
Okay, we may have a problem here with the WebEx.
Can you hear me? I just unmuted. Hello?
Gina, can you speak now? See if we can hear you? And we can get some baseball scores too while we're at it here.
Hi, I'm unmuted. Can you hear me?
Yes, we can. Please go
Okay.
forward.
Oh, awesome. Thank you. I just wanted to say that I agree that some data collection needs to occur, especially in terms of how many guardianships there are in a jurisdiction, who the guardian is, if it's a family member, if it's a public or professional guardian. I think that information about guardians can be made available. However, I also think that within this, alternatives to guardianship, whether or not they've been explored, whether or not somebody had documents, could also be collected. If you want to look at, what one of the many problems are, according to the task force, is too many people are getting into guardianship who do not need guardianship. And so it's very important that we have education at the onset of the guardianship, statewide education to everybody, community members, judges, people in healthcare, about having your documents in order and having powers of attorney and having your advance directives. That all needs to happen, and perhaps that database could collect some information as to what other alternatives to guardianship have been tried, because that's something that I work through with the dozens of callers that I get in a week. Well, does a person really need a guardianship? Where maybe they just need a payee and some case management. So I think that if the database can collect general information about guardianship, that's important. But obviously, as a guardian, I treat my clients' information with extreme care, and I don't want to share it with anybody that the law doesn't require me to do so. on a need-to-know basis that is going to help the individual. So I do think it can drastically help the system to collect some information, but not information about, not in very specific information about my client that I have to share.
Thank you, Gina. Oh, go ahead.
Just the issue of confidentiality is one that's important, and we can't really just give it short shrift. But we don't have to reinvent the wheel to be able to know who is involved and who can be held accountable and give up that personal information. We don't have to reinvent the wheel because we've got, as clerks, you know, the care that you take to keep juvenile records confidential. And if anything is going to happen where we're going to be dealing with family guardians giving away some of that, being able to be held accountable, then I think to some extent, those that may not wind up going the wrong way need to have the protection and need to have the safety of, as Shannon pointed out, from being embarrassed, from being solicited, from being marketed. But at the same time, there needs to be accountability for family guardians. It's just that a balance has to be stricken. Here's the mediator coming out. A balance has to be stricken between the privacy interests and the public interest, public accountability interest. That's, you know, if it goes one way or the other, it's both wrong. But I think that there is a central way that all of this can be accomplished.
Jose, you set up my remarks perfectly, so we didn't even practice. But for any reform to take place, you need good data. I mean, it's hard to pass a lot of legislation based on individual stories because you're not sure of the how individual they are and how unique they are. And it's a big problem, small problem, and so you have to do things that provide some facts and measurables. And the legislature, to its credit, has really focused on this in recent years. The clerks, I don't mean to pat ourselves on the back, we're expert at this. I mean, we know confidential and non-confidential information. We work with state agencies all the time. We have a massive project right now with FDLE, which is called the Criminal Data Transparency Project, where it's going to be a compilation of data. A lot of it will be data with no names. Some of it will be reportable data with names, depending on a whole bunch of different circumstances. For every arrest, and JD can tell you this, we have to submit 135 different data points for every arrest to FDLE. Okay, some of that information is confidential, some of it is public view, but it's also going to be helped to determine the reason why the legislature wants this. They want to see, are there different judicial patterns throughout the state? Is a person in Palm Beach getting 20 years for this crime with the same history record and point system? And I won't go to the criminal justice system. In Escambia County, they're getting 30 years. Why is that? Why is that disparity? Is it if a person's an African American, are they getting a bigger sentence than a person who's a white male? Is it, but there's all this anecdotal information about this, and there's some statistical information right now by thing, but statewide, the legislature wants this because they have all these data points to help them to make these determinations. And it's also going to help the judiciary to see if they're outliers in particular areas. We have so much experience with what's called the David system. The David system is populated mostly with clerk information and law enforcement information, which is confidential. I can tell you there's severe penalties. Cops get fired for even though they have access to the David system. If they look for something that they're not supposed to look at, they get fired for that almost uniformly across the state. I mean, there are severe penalties we're blocking, and we know how to keep confidential information in databases and even access. Just because you have and again, in the court system, we have a matrix of security access of who gets access on every particular file, who gets to see that file, if there's confidential information with a whole security access that we have programmed in. So this idea of that we're going to somehow release confidential information because it's in a database, I can tell you, I think it's an unsubstantiated allegation. No, please, no applause. No applause. We're not trying. But we can make the data that's relevant available. The question is, which data is relevant? What data will help policymakers and the state legislature look at the system and say, and it has to be measurable data. It's very hard, and Hillary, it's very hard for what some of the points you've made as a person, healthy, not healthy, should they be in, but you almost have to look and say, okay, things that are measurable, the examining committees throughout, have they determined, what's their record? Is it 100% of all cases always get passed by the examining committee as being determined incompetent? And then this one has 50%. Well, boy, that seems kind of odd. Is this, what's the rate of people being returned to competency or whatever? I'm trying to, I'm making some points up here as I go along, but I mean, what are some measurables that you can look at, which then can, you do diagnostic testing and say, boy, this looks a little odd in this area. Maybe we need to find out why it is. It doesn't mean you make results and you change policy, but at least you question then the data to say, why is it this way in this particular area that's different from this way over here? And that's the purpose of a database that people use. Again, the state uses all the time with different things. It's to share information, but it's also to make policy decisions. So we'll go back again with discussion. You haven't spoke, so we get to hear from you.
Well, I think, and Judge Rodriguez, his comments sort of provoked this, and Michael's actually, because when you're talking about, what we're talking about here is a database so that we can have oversight and better oversight. And, and then we get into those tricky questions regarding confidentiality, capacity, and so forth. And then you have these layers of things with the Florida bar and so forth that I personally see. And so when, it depends on what the layer of oversight you're talking about. If you're talking about the court system, as I'm hearing it, I mean, I see it, and I know we're talking about data tracking systems, but as I see it, the first thing that you want for sure is to make sure that judges have the tools that they need to exercise oversight, the level of oversight that we'd all want. And certainly if you're talking about sharing information within the judiciary, I think that's an easier lift in terms of things like confidentiality than it would be to make it public. And even the legislature it's the legislature, but it is a public agency and its branch is public. So when you give them that information, you're giving it to the public, and I think that's a hard concept. I know it was a hard concept for me to get my head around at one point, but those are just my, I know that we could be headed in a variety of different directions, but it seems like the first layer of oversight in these matters is always going to be the court and the judge and the judiciary. And so, I mean, and I know you're talking, Ken, about a much bigger data system, statewide data system. But if my thinking is that as much as you can do within the judiciary, that's an easier lift on some of these matters.
Other comments? Sandra?
I think that this task force clearly could talk about this particular issue all day. And I think we've had insufficient time to narrow down or even to try and make any kind of a parse out specific things that we want this system to do. So I think the more general we are in nature and the way that this is worded, I think, some kind of data collection system that is statewide is what we're getting at. So a unified statewide data collection system, maybe that's the concept that we're looking for. And the more general we are, the better off we are. We can leave this for a further task force to nail down specifics.
I'm going to interrupt this side. Sean, since he's WebEx, you're recognized.
Thank you. Well, I support what Sanja just said, that I think my comment is that this concept be proposed as a top priority because we've been operating without such a system for all these years, and we see where it's gotten us, and we see the problems, and it would benefit, you know, all the array of agencies involved and the wards themselves. It benefits law enforcement just to know that someone is under guardianship who may be found wandering in a county that is just adjacent to where they were living. And the courts, we already mentioned that. And I just think I would like to propose that this be a top priority, that this concept of developing a statewide database included.
Anyone here first? You go ahead, Anthony.
Thank you. Thank you, Chair. Just to re-echo what Clerk Peacock said, data is going to, what is collected it really depends on your role in guardianship. The data collected for, what the court wants to see is going to be different than what an investigator wants to see, is different than what an advocate wants to see. But looking for a consensus, building consensus with this group, I think, a concept to consider is let's not parse out exactly, what data points we want to collect, but maybe agree that an independent body makes that decision with input from the stakeholders. Because, you can tell only one side of the story depending on what data is collected, and that's not the intent of collecting data. We want to universally analyze the entire system to make improvements to that system. So I would propose as a concept that some type of independent body, not with a singular perspective, especially if you're a stakeholder in the guardianship system, that would decide what are those data points, what can be collected and what should be collected. Thank you.
Karen?
Clerk, I think that it sounds like
Oh, yeah, right in front of you, Karen.
it sounds like from the fellow task force members, it sounds like we're talking about, we're in consensus that point one should be that there is statewide data collection on specific points. And echoing what Anthony talked about, getting in the minutia of specific details that are going to be collected, I would suggest that we don't vote on that today, but we make that an exhibit of suggested or proposed things that could be tracked.
That's a nice idea.
And instead, I think that it might get us a little bit further if we just reframed point one to start off with statewide data collection on specific points to be addressed and suggested by this task force in an appendix.
And by the way, Karen, I think is the most organized person I've ever met. Look at that binder with all the tabs. Very, very, very impressive there. Any more comments? Chante, do you have a comment?
Yeah, I agree. I just wanted to challenge the task force that we think about what information to Karen's point, what information we're gathering, what mechanism there is to get that information. And I think we have to be careful in our wording because when we say here the database should include at a minimum, the first point is complete information. So, that we just have to be careful how we choose our words, but I agree. I think it's definitely needed to get the data so we can pull things out. But we also have to recognize that oversight in general is a shared duty with a lot of different folks, right? And so that data may look different for different folks. And we have to also understand the mechanism of getting that data.
Well, I think I'm in support.
Right in front of the microphone, right in front of you.
If I understood what each of you have said, I think I'm totally in support of that. I'm opposed to the language as proposed up there for part two. I'm totally fine with 1, 3, 4, 5. If I heard better language that's a little more general, I am fine with that. I just don't think that I think demographic information is great to get. How many elderly people have guardianships is great to get. How many young adults have guardianships? I don't see any purpose to having the names of a guardian who's a guardian over their own kid. And so how many of people have guardianships over their own kid, that's fine. I don't see a purpose to having their names.
Mike, let me ask you, if it was part of the database, but was not made public, would you have a problem with that?
I don't see somebody putting their name into a statewide database. I mean, the way you're putting it, maybe. Not quite sure I understand that, but maybe.
Okay. Shannon.
I was just going to add that, I know what Anthony had said, that it would be a third party. I don't think we need a third party. I think the clerks can collect this information. I mean, they already have it, and they're very good at keeping confidential information confidential. So I would say that, not to add to your list of things that clerks have to do, but we always do.
Because we need to talk about appropriation here.
Yeah.
But I would suggest that this kind of data could be collected. And it could be done internally, and then everybody we have a storage place within the clerk's office, the statewide clerk potentially, that would house that data. That would be my addition, but I like the idea of keeping it general without specific, and I like the term statewide data collection system. I think that's a good term, and we just keep it internally in the clerks. But a lot of that language that's in the 1, 2, 3, 4, 5 is overbroad, and I don't support it as a task force member. I think what we should do is really slim it down to include something like statewide data collection system to be housed by the clerks.
And Shannon, to your point, if you have a basic system, and let me tell you, when with this thing I just talked about with FDLE, with us submitting 130 some data points, well, we've always submitted information to FDLE. Okay, it was just very limited before. And as they say the capability, they say, gosh, maybe we need more information. Maybe we need, in these different, and so the data points keep, going. This was a great elevation from like 30 to 130 some points. But so it's a natural process too. When you start a database, you say, gosh, this information will be helpful. Maybe we need to start collecting this. And so I can see us starting, and this, again, being reasonable. Let's start with the basic information first. And then as the legislature and policymakers see the need for additional data points to be added, that they'll charge the agency, whatever agency is charged with this, to keep increasing it. The only point I will disagree with you, it has to be a state agency that collects the data. It could be done through clerks. Would be the ones just with FDLE. We submit the data, but it has to be there is no state clerk, so it has to be a government entity that would have to collect it. Going along the line here, any more comments? Hillary,
I think
Roy, did you have any comment? No, sir. Okay. Tom.
Well, and I just wanted to make a follow-up point on that. And normally I'm not on the task force, but there's a couple things I can't, it's hard for me to take notes here. So I want to say something so somebody else will take the note, is that the clerks are 67 separate databases. They're not one database. And that if you're going to have a comprehensive system, it'd be tough. They have ways of doing it, but it would be. The other really critical thing I think you have to take into account is the clerk's court system is governed by Rule 2.420. Right now, under the current rule, if the filer doesn't identify it as confidential, it's not confidential. The clerks have been tracking that since that new rule went into effect. In all candor, attorneys who are the filers are horrible at identifying confidential information. The rate is abysmal about how they're doing that.
Those are the rules of judicial administration, correct?
Right.
But we're not going to discuss 2.420. We could be here.
but
I would slit my wrist. Maybe entertaining, but.
Well, the point I wanted to make about that, though, is that what the document that data has come from is not confidential if the clerks are maintaining it, where it might be with an agency, because 119 applies to
Actually, yes. Non-court data is a lot more confidential than court data.
Right, exactly.
There's a lot more confidentiality there. Viviana, you had your hand up.
Yes, with all due respect, I would ask that we refrain from suicide jokes.
I'm sorry.
I just will make the quick point that the data, we're just talking about putting data that is already collected in one place so that we have better accountability and it's in the hands of the government. We already ask people to tell us when they are someone's guardian because there's a court process and they submit annual reports. So it's not new information, just putting it in one place so that we can better track
Okay, I do think there's a sense of consensus here that there should be a database established that, how are we going to put the wording here? Do you have enough wording, do you think, to get that basically it start with the basic information of identifying that the clerks would submit, this to some type of state repository and it start off with with what? Help me
Well,
here.
I think somebody said a data collection, a centralized data collection, something.
What was the word you used, Shannon?
Data collection system.
What do you mean by unified? As opposed to unified?
Collected together.
Thank you.
Does it exclude uniformity?
No.
Okay.
What happens usually when you have, again, we have great experience in this. When a agency is, well, whatever the government agency which is tasked with developing this, they'll do what's called a data dictionary. And they'll say, this is exactly how you should report this data. Okay, so, and we have this with judges. Okay, so it's not, is it Jose R. Rodriguez? Is it just R. Rodriguez? Is it J, or whatever your middle name is, Robert Rodriguez? So we're not listing you as 3 different or 4 different judges, which in the past, when we had bad data, you listed 4 ways. And so we come up with a data dictionary which says your name will always be this way, okay, and presented this way. And this data is always to be presented in this fashion so that we can compare it. You're getting into the weeds here, but the data dictionary tells each clerk how we are to submit the data. And that's up to that agency to work with its partners in developing a data dictionary. And and we have all types of work groups that make that happen. Okay, so we have that topic and we have consensus. And so what Tom will do then is to take what we've said into a narrative and put that as our first proposal. Now, on a scale from 1 to 5, with 5 being the highest, I'm just going to assume on this one, because we've talked so much about it, that this is a 5 as far as a high priority. Does everyone agree with that?
Mm-hmm.
Yes, sir.
Okay, so that's good, folks. Yay! Celebrate some success. It's now 11 o'clock. Let's take a 10-minute break. Y'all can go ahead and take.
If everybody wants to take their seats, we'll get started in just a second. We're not having chat like I can choose those email I sent. I can get to that email once I do this.
What's that? I know, just for my lower back, I like need that little extra support. Then on my back will be sore driving home. And we were just talking about CCIS.
If everyone would please take their seats, we're fixing to get started again, please.
Like that. Basically.
Wait, I'm have numbers. What's D?
Data mining and all the things
Okay,
that,
fine.
you know, are problematic for our clients.
Hey, Tom, we're going to go out of order and do uniformity of forms. That's been a request, and I think it's appropriate with the past, the first item we passed. Everyone, please go ahead and take your seats.
What number is that?
Well, it's the great,
Yeah, I got it. So if you look on everybody ready here? There's another.
just go ahead and get started, Tom.
Okay. So if you look on the shorter thing that went out yesterday, look at number 5, which is require uniformity in forms, processes, and data collected and reported across the state. As a background to that, one of the things that I wanted to give the example of is, as Ken said, the clerks keep comprehensive data about all kinds of things. And one of the ones that they do is traffic data. And actually traffic data, there's more traffic cases than any other kind of case. So there's tons and tons of data. But one of the reasons they're able to do that is there is a uniform traffic arrest thing. So that every piece of data is in the same exact position on every arrest. So by having that uniform traffic citation, it makes it very easy to collect that data, and then you can use that data. The legislature, whoever needs that data, has assurances that they have the same data from every place. So that's the sort of basis behind this recommendation. I think when we talked about it preliminarily, pretty much everybody agreed we needed to do something along those lines. And I just tried to, again, capture it at a sort of 10,000 foot level.
Comments from the task force?
I'm sorry. I don't understand the intention behind this. We have a process of auditing that's already statutory, and I don't understand a uniform financial tracking system. We're
on 5, not 4.
Oh, I see. I'm sorry. My bad.
Karen?
Just like we did in the prior discussion, Clerk, I would suggest that we not figure out which forms we're going to amend or who's going to be amending those, but just that the task force consider the adoption of uniform forms statewide for this data collection purpose.
I think that's a good approach, Karen.
I agree, and partly because there'll be a question about whether a form is the court adopted form or something the legislature. Generally what they do is the legislature says, we need a civil action cover sheet so we can capture a lot of data. Then the Supreme Court approves the actual form.
I don't know if this would make it easier for the smaller counties to deal with guardianship or make it harder. But not having heard from them, I'm fine with it for today.
I think uniformity helps us all. And when you have data collection, and again, I'll use the big FDLE matter because it's just such an obvious one to use. Part of the problem there is that each sheriff, each law enforcement actually can have their own arrest affidavit. That's different than the civil traffic citation that Tom was referring to. And so one of the things that's coming out of that is that there has to be a uniform arrest affidavit in order for us to be able to uniformly collect data across the state to submit those 130 some data elements. And so that's the idea here. We're not going to say which particular forms need to be uniform, but that there needs to be some type of, you shouldn't have this type of form in this county and a different one in another county. Yes, Tamara, it's good to hear from you.
Thank you. So as public guardian, we frequently, not frequently, but there are times we take over cases where the ward or the protected person is indigent and there might be a family member guardian. And back to the uniformity, if there are check boxes, which I know some areas don't like, but it also forces the guardian to address certain issues. So we might take over a guardianship where a family member has passed away. What they've said in their narrative is very brief. So we might not know if the person has glasses or a walker or different specific items. So in the uniformity, there could be a lot of specific things that are addressed, whether it's dentures or glasses or things like that, that we wouldn't know are missing because we didn't know they existed. So having the uniform forms that trigger an answer to all of those questions that, it's just helpful in general.
Great points. Yes, Michael.
I do have a question. In regards to unifying data collection, does the financial reports can the financial reports be included with that to see, because I know when you're in a guardianship, you have access to all the financial that the ward would have, but would there be a possible way to actually include the financial report in that, or would that be too difficult?
Accountings are required, so
Okay.
unless they're waived, and usually that's when the guardian is not the representative payee and doesn't control the finances, but guardians do accountings.
So does that also include financial guardians?
Yes.
Okay.
Okay. On this point, and this is, as Tom mentioned, is a lot of times, even though the legislature may not have jurisdiction, they'll pass a statute to give the courts some direction, saying they give me direction. So it's not unusual, even though it's not in the purview of the legislature. It's it's been a tradition where the legislature often says to the court, hey, we want this type of, outcome, and court, please do it. So, also in guardianship forms, you do have a combination of maybe non-court and court forms in there. I'm not sure what the non-court forms are, but I'm sure there are some. So are we fine with this recommendation here, this concept moving forward? And probably because the other one was a 5, this one probably needs to be a 5 too, because it goes hand in hand. Does anyone disagree with that? Okay, good. 2 handled. Is there Karen asked that we handle that one out of order. Is there another one you would like handled out of order as I think we do need to talk about the follow-up task force. This one has, treacherous waters either way. If we have a private task force, which is recognized by the legislature, kind of like this one is. And I will tell you, when we formed this task force, we just didn't do it in a vacuum. We went and spoke with some legislators and said, is it fine for us to do this? We certainly don't want to, and we spoke with some influential legislators to say, we are going to form this task force. It's a big topic, and it's going to be private. And, will you give us your blessing? And we did move forward based on that, because obviously if we don't have buy-in from the legislature, it's as ineffective as can be, and we didn't want to waste everyone's time. And there have been, as Sancha mentioned, back in, was it 2004, the governor's task force was created, and that's done by, I assume it was done by statute. Usually those task forces are done by statute, or the governor could have just appointed. But either way, if it's done by statute or if the governor appoints, those are subject to the Sunshine Law. And it really does, and I love the Sunshine Law, but it makes a working task force very difficult, and it almost puts tremendous responsibility to staff to do a lot of communications, to do a lot of the work of the task force, and you can't have any conversations between hand. And so that makes those types of task force, and those of us who have been involved with them know it's very frustrating when you can't talk to your fellow members without the confine of the publicly noticed meetings. And there's been even some conversation about public comment here. Public comment is now required for all public meetings. It's a statute, so you have to make sure. We've done it because we've embraced that as a task force, but it was not a mandate of this task force because we're not within the confines of that. So I guess, but the obvious problem is that if you don't have a government-sponsored task force, there's no government agency supporting it. And here, the Clerks Association has been kind enough to do it, but there's not the bandwidth to do that in the future. So we say we want to go from here. So how do we go about going from here as a task force? And task force, a lot of times, will have specified members on it. I mean, there's a economic task force or workforce, and it says that and it names private individuals. It says the head of the Florida Chamber of Commerce should be a member, the head of the Associated Industries should be a member, the chancellor of this, of the university system, the state college should be a member, and names these people should be members of this. And sometimes they'll say a representative of this organization. And sometimes it, will again be very specific that names the Secretary of Commerce or whatever shall sit on this task force. But that's up to the legislature then, if they sponsor this, to decide who they want. And usually they'll put at large citizens that are appointed by the Speaker and the Senate President. So what's your thoughts as far as obviously a government-sponsored task force has then I guess the perceived power of the government behind it, that it is an official event. So your thoughts? Yes, Hillary.
I think anything is great. Anytime that we're talking about guardianship, whether it's family guardianship, whether it's for-profit guardianship, anytime that we have a task force and the public is able to attend, public who can't travel here, public who are intimidated by the threat of retaliation, this is good. to have people in every single aspect of guardianship. So I am grateful again to be here, and I am grateful that we are talking about guardianship from my perspective, from the ward's perspective, and again, for the public to be made aware of what's happening and what we're doing to try and change it for the better.
And Hillary, to build on your remarks, I do think the legislature is looking for direction in the future. I mean, they know this is a big issue. It's going to continue to be a big issue. And they want people to contact them. And the more formal it can be in a process, the better it is for them, rather than hearing from 30 different stakeholders individually to say, hey, these are some uniform or unified concerns, or maybe not so unified concerns, but concerns. So I think the legislature, which has the opportunity to make a real difference, would welcome some type of continued task force going. Karen, you have some thoughts?
I had a question, actually. If the task force were to adopt this provision, that wouldn't preclude us from still continuing with the phase 2 as Shannon proposed, right?
No.
So,
Or if, we felt very good about this task force, which gets appointed in the statute, we would say, here, phase 2 belongs to you. Please take it away. We've done the initial work. Again, that would be up to, it would be hard though for us to compete against a government-sponsored task force. I mean, because obviously they're saying they're putting their imprimatur, is that the word, on it?
I guess I've found that every task force I've ever seen, one of their first recommendations has been to recommend another task force. So beyond that, I really like including number 6. So I want to make sure, emphasize lessening the burden on ward.
Yes.
I think it's very important to have there, and I really like seeing that.
So I guess our discussion should be, should we ask the, again, I went to some legislative leaders before forming this task force to get the temperature in the room, and they were very supportive. And even if a person I thought may not be supportive was very supportive. So I was very impressed with that they consider this a major issue and want to hear from us. I do think if I had to make a recommendation, I think we have to ask the legislature to form it under statute and let them have it and let them give legislative support for it with the proper staffing. And whoever gets appointed to that would have to just operate under the sunshine law, realizing that it's a little bit more difficult and more burdensome. And also, there's when you have a government-sponsored task force, there's not as much flexibility, just like we've had on the discussions, but also even in scheduling meetings and that type of thing. There's a lot of different things it has to compete against than the way we've been looking at it. Thing.
I do think that a follow-up task force would be a good idea, but all things considered with the current state of politics, I would encourage us as this task force, if we recommend it, not to maybe prescribe who gets the designation authority, because I've seen many legislative proposals with task force that you fight about who gets to appoint people, but make it clear that it should be a bipartisan appointed process. So members from the majority and minority party both get to elect people on the task force if they move forward with it.
Okay. That's very hard to make happen.
Yeah.
I don't mean that. In a different world, that's wonderful, but I've never seen a task force where it's done by political party. It's usually done. But a lot of times saying, if you do prescribe who should serve on it, by the nature of it, there is and this is not a bipartisan, I don't think anyone here is identified as by political party. It's by different interests that we have and advocate. So I think maybe that's more, to me, and I'm not disagreeing with you, but more appropriate way to have, making sure the points of view. JD.
So I think that we've got history of ad hoc task force that have come, either government sponsored or not, along the way. I tend to think that the issue that we're dealing with is probably of the level that they need some sort of continuing council or continuing entity that does what we're doing here to continue each year to give perspective to the legislation as we move forward, as opposed to an ad hoc every now and again when there's a story in the paper all summer long that they can rely on. It's one of the few things that, considering that we're talking about somebody's liberty, every other part that government plays in somebody's liberty in the criminal justice world, there's tons of councils and people who look out for the varying interests. we're doing it ad hoc way, we probably need a continuing some sort of council, some sort of entity.
That's a great idea.
Yeah.
I'll editorialize. So why don't we do that? What our suggestion, instead of a task force, that give it some good name, Tom. Or
Yeah,
come
I was
up with
gonna
something
say,
from the
well-
wisdom in the room, and a council which advises the legislature and comes up with suggested legislation to improve the guardianship system. Yes.
How about a working interdisciplinary network of guardianship stakeholders? How about a working interdisciplinary network of guardianship stakeholders with, again, the similar representation that we have here, or even expanded, and then to have that break out into separate committees depending upon interest, to come up to the main group and make recommendations and then have them voted. And the reason is we already have a WINGS program. I am, in full disclosure, the statewide chair. It is out of Stetson Law School with Professor Rebecca Morgan, who would wonderfully welcome, as I would, the participation of everyone here in making sure, from a both academic as well as a legal and making sure that vulnerable folks like the aging and the and again, all vulnerable populations be included, to make sure that we do what we can to improve guardianship. And I'm sure that Professor Morgan, with the assistance of all of us, would be able to help draft legislation, as would the entire WINGS group. So you toss the ball. The Supreme Court gave Stetson, due to its embarrassment of riches in the area of elder law and their subject matter expertise in that area, they have deposited the WINGS program. It is an ABA program, and after the Supreme Court did their stint with WINGS, it now is
At Stetson.
out at Stetson. So that's probably something good to continue for that group that's already constituted to continue the work.
Chris Hart left the room, and is he still here? Okay, there's very few, and Kimberly, you may know this, I know you have a lot of experience with the legislature. There's very few legislative sponsored committees which aren't assigned to some type of department. Okay, just that's, they have to figure out who's going to support this. There's no like general legislative. So what they do is they look to what is an agency that is best. And they usually say, you know, again, we deal in the criminal justice system a lot, so it's always FDLE staffs, whatever and they'll say, okay, if they want to create some type of task force under criminal justice, they'll say, okay, FDLE, it's your responsibility to staff that. If it's, you know, whatever department but they'll assign it to a specific department to say, that's your responsibility to staff this. That's usually how it works, in my experience. So again, on this, not that we have to, that's up to the legislature to assign it, but they probably would want some input. Is like who's the appropriate, you know, department that's going to, whether it's the Attorney General's office, Department of Elder Affairs, or something, they would assign that to someone to say, this is your responsibility to staff this task force. That generally how it works. I know, like a court task force, OSCA has the responsibility of staffing any body created by the court. So there has to be some entity which we're put into, just so, again, from a logistical standpoint. Karen?
For purposes of this point, the discussion of a continuous task force, I think it's a great idea. And I think just to avoid us getting lost in saying who should be this task force, who should be the leadership for it, I think that making a recommendation that the legislature consider empowering and staffing for Wings, which is one of the things that I think Wings could greatly benefit from. It previously was, and please judge, correct me if I'm wrong on this, it previously was staffed and supported resource-wise by the courts.
By Oscar.
And,
Yes.
but is no more. So I think that the idea of bringing that to the legislature's attention as a possibility
Yeah.
for solving this suggestion is a idea.
It was originally the ABA that funded the Wings project.
And Karen, I'll disagree with you on this one. I don't think the Wings group is a diverse group, and I think it has a specific charge, not to improve the whole guardianship system, but a segment of it, where this is I think has a much broader mission. So I would hate it to be put into something which is prescribed by ABA as a narrower path than what we're looking at here.
That's true. It does basically deal with guardianship. It does not, and it deals with the elderly primarily.
So it's, Viviana?
I would just echo that, but I don't think Wings is the right place for this, and that I would prefer to see it in the legislature or somewhere where it's closer to where we want it to go, and it has more teeth and it has more possibility of turning into actual language.
And Mr. Chair, could I address just a housekeeping type issue? In this number 2 recommendation, I included recommendations made by the previous task forces, just so as a starting point for discussion. But some of those, if you look at those, some of them include things which are not legislative. They were at the court system. So if anybody, when we do the actual draft, it would be really helpful to me if you have specific things from those other task forces that you want to recommend that we mention, please, email me and we'll include and we'll change this language to, instead of saying include all the recommendations from 2018, we'll pick out the ones from 2018 we think should be looked at. That'll be very helpful to me going forward.
Anthony?
Yeah, I just wanted to mention that Wings is in many different states. And yes, Judge Rodriguez is correct. The American Bar Association has these basic principles. If the American Bar Association is funding Wings for that particular state. But that's not the case in Florida. The Wings, as it is right now, isn't getting any funding from externally. So Wings can be defined any way we want it to be defined. Under, and we would have to ask Professor Morgan if she would be willing to be the administrative part of that Wings going forward. But we could make a suggestion to the legislature to carry forward Wings with whatever we want Wings to move forward with. I know when Oscar was administering Wings, we really couldn't get into legislative recommendations because of judicial canons. But we can redefine those rules going forward. I would recommend that the Wings group be more narrow and more, filled with more decision makers, because the first go around with the Wings was a very broad group, which is great, but it doesn't lend itself to efficiency. So I would, recommend a smaller group, but that concept is a good proven concept.
Hillary?
And I know a bit about Wings, but I'm not fully knowledgeable on it. So I would like to look into that and do more research, before we put Wings next to something that I'm included with. So that's my view.
Viviana?
Just one more point is that I think that whatever group is put together needs to have more representation of directly impacted people, people with disabilities, self-advocates. We need to do better about including the people whose lives we are talking about.
And
Sasha, did you have your hand up?
Yes, just that I agree. Again, this task force hasn't had enough time to evaluate this, to make that a recommendation specifically one way or the other. But I think they're generally another task force or another group ought to look at this, in more depth.
And I think it's a mistake to tie us to Wings. I mean, has a defined mission that's different. And to me, our recommendation should be to the legislature that they should form some type of entity on an ongoing basis. I love that idea, JD, so it's not a task force thing, but an ongoing basis to submit legislative proposals to improve the guardianship system in the state of Florida.
I just tossed it out as an alternative, as a starting point. I'm one of those who does not like to reinvent the wheel. And I think with Wings, we've got a basis for it, or if not Wings, something like that, where you've got, again, a group such as you all, us all, coming together for the improvement of the guardianship system.
Right. And no disrespect whatsoever.
Take it. You don't have the power to disrespect me.
But honestly, with the situation in guardianship in Florida, sometimes you do need to reinvent the wheel.
Taking it a step at a time.
And I think too that we do need to put as part of this proposal, Tom, something which I think everyone said, it needs to be a broad-based, and maybe we don't define the people, you know, but we mentioned it's a broad-based perspectives are brought to this, that it's from, maybe you can craft something which in that narrative which talks about that. And they may, hey, a legislator may look at that and say, hey, I'd rather have specifics. You know, should be someone from the Guardianship Association, from AARP, someone from here, someone from Guardian Ad Litem, and someone, a representative from the judiciary, that, you know, blah, blah, blah. You know, that's back to when Mark Pinto was here earlier. That's up to the legislator to determine which direction they want to go on something like this.
And
To piggyback that point, I think that just like we talked about, sorry, I hate this. To piggyback that point, just like we talked about with the data collection points, I think that the specifics of what we're recommending as a task force to include in the demographic or examples of other task forces that can be modeled after, that's something that we should include as an exhibit or a section after. But the core concept that, as you proposed it, Clerk, the legislature forming a entity on guardianship to make legislative proposals, a continuous entity. I think that that's a good idea, and I think that that is probably neutral enough that the task force would feel comfortable voting on that. Just guessing.
So are we fine moving forward with this?
Yes.
And a 1 through 5, this is another 5.
And I do want to like echo on Viviana's point. I do think we need to have more self-advocates on the task force with people with special needs, because their voice matters. You know, at the end of the day, it's their voice that really gets heard. Like, I'm part of Stand Up for Independence, and I'm gonna tell you, every time we go speak somewhere, or every time we go speak to Representative Overdorf or any representative in our county, they are so impressed because they know that our voice matters. And, you know, to be honest, you know, a lot of people with special needs will actually get a kick out of, oh, good, I'm on a task force. Oh my goodness. Like, you know, that will bring joy. And, you know, I was part of Wings, and, you know, what I see is task force gets developed, but then they disappear. Like, they disappear often. And if we're going to fix a problem, we don't need it disappearing. We need it to continue, and we needed to continue to do the work, because if it just disappears, we're just letting more cracks fall, be more developed, you know? So I do think we need another task force, like continue a task force that, you know, we appoint people like, you know, whether it's me or whether it's the people that's on this task force, we appoint it and make it permanent until, okay, these things are fixed. So we don't need to have a task force anymore. That's what I personally think.
And that's how generally the legislature thinks. When they feel like the purpose has been solved, they cut off the funding for that particular entity and the task force ceases to exist.
And even if it's with the support of the governor, you know, even if we have to get the governor involved, you know, because it's important for our leaders to get involved.
Ken, quickly, and I know we're limited on time, and I'll just say, maybe this is just random, as the kids say, but, you know, my big hope is people like Jan Garwood will be able or someone like her to get their rights restored and not have to sneak in a phone to have access to someone like me or Sancha or someone that can help them. That is one of my biggest fears, that it will not happen, because not all times a guardian is, conducive to getting someone their rights restored. Another hope, with the clerks, I have something, and I'm not going to be case specific, but maybe I will. And then I promise I'll just be quiet. But, there's a filing, it's from November of 2020, and it's a case in Seminole. And it's the annual plan for the period 2021, and annual accounting was due on August 1st, 2020. The clerk sent a review letter. Nothing has been filed. Please advise. That was filed on November 6th of 2020. This is the last document that was filed on this case. What is happening to this ward? The ward hasn't died. There's no, notice of death on the case. Something has to be done. We have got to keep track. Because I can't go and visit this person, this American citizen. So the data and everything that we do will protect someone like this ward, whose annual plan, and if they're destitute, they matter as much to me as if they're trillionaires. And I hate to be redundant, but just looking through cases in Seminole and every single county in the state, there are problems.
So we have another topic which we've agreed to, that a permanent advisory council to the legislature be appointed. What it's named, that's yet to be determined. And that it have a broad base of membership and perspectives. So we put that as priority. Let's talk about what next item is one that we want to talk about and raise this to the top here. I do want to mention, folks, and this gets back to what we started with, the mood of the legislature. If we get these things that we just talked about passed, this task force can claim success. Okay. There was a laundry list of topics we all brought up, which are all important to us. I hate the fact that the ward gets charged for everything. It seems like there should be other payment mechanisms, and that takes an appropriation. Getting the appropriation passed, JD can do that easily, right? JD, appropriations. One of the most difficult things is to get an appropriation passed. That's the, a lot of what we passed so far, or as a group, may involve an appropriation later, but that's not an immediate appropriation. So when we get into some of those big ticket items, those are a lot more difficult to accomplish. And I'm not saying that we can't, but I think we were smart to come up with the ones we've come up with thus far, and really be big proponents of those. And I think, and I'm not trying to put the thoughts into other task force members, but I think we give this next, as part of this, with the saying of this next task force or permanent entity, here's a laundry list of items we've identified that need to be really looked at. And it could be the advocacy of the ward, with the continued legal responsibility and how best that happen. It could be the examining committee. How do we make that more effective and uniform throughout the state? Whatever the different issues that we have here are, but so I guess my question to y'all, because we have limited time today, and we have although we're scheduled for a certain time, Kimberly has reminded me at least 20 times today that FSU has us forced out of this room and all cleaned up by 5 o'clock. So we have to end before that, enough time to clean up everything and get out of here. And I know we're not scheduled to last that long, but I can guarantee the people with who wish to make public comment, I will sit here as long as Kimberly doesn't throw me out and listen to public comment. That's my commitment to you. And I know not all task force members, you have to get home and travel and all that type of thing. So I understand that. So what other items raised to the top that we want to cover next that should be in our top priorities? Karen?
As a point of clarification, based off of what we did for our first vote as a task force to the statewide data collection system on guardianships, I suggested that that not include necessarily the professional guardian specifics, that that's a separate database. So if everybody is on the same page with that or thinking that that's a separate issue, we may need to address that at this point. The idea of tracking the stats and information professionally for individual guardians, as opposed to the guardianship case information. Am I making sense?
I'm unclear. You're probably making sense to other people, but not to me.
Okay.
So help me.
So point one in Tom's system that we were going through of points that we were going to recommend included both a comprehensive, fully searchable database on aspects of the guardianship process, and also talked about information about the guardians themselves, the professional guardians, such as their disciplinary record. That disciplinary record and actions that are specific to a professional guardian are not necessarily going to go hand in hand with what the court is collecting as part of the statewide data collection system. So I'm suggesting that that may need to be our point number 4, is to discuss what is available statewide publicly or what needs to be tracked as it pertains to individual professional guardians.
Okay, I get you.
I'm still not clear.
A better statewide tracking of professional guardians and discipline history, whether they've achieved their education, how many, whatever other information on the individual guardian, professional guardian. Is that what you're saying, Karen?
Right, what counties, how many wards?
But that may be in the other
Okay.
database. This would be more, more disciplinary and history and all that type.
That would be open.
I'd be interested to hear from Shantae Jones about what we have already existing.
And let's get, and I'm not trying to cut off this, that I'm asking what topics do we want to discuss next? So this is an important topic. Is there another topic we want to discuss next? And we'll put this on the list. I'm just, and then we can have that conversation.
After Michael, I have a.
Okay. Okay, Sean, why don't we go to you?
All right. We had, I believe, several bullets on this list relating to education. I thought that we would want to actually address education, enhanced education for the courts, for guardians, for the clerks, everyone involved.
Okay, good. So professional guardians, tracking, education, what other issues? Because we're going to have limited time. We can't handle everyone that was brought up today. Viviana?
Just because it sounds like an easy one that everyone agreed with, was suggesting that they change ward to person under guardianship, just because it seemed like a consensus.
What was the term you came up with?
Person under guardianship is what we use.
Right.
Very to the point.
Okay, we're not discussing the issue. I just wanted to hear, I didn't hear her, so we're going to discuss the issue this afternoon.
Ken, if I could be.
Hold on one moment. I think Sancha had her hand up next.
They did, but it's a little bit of an aside. I wanted to address the goal in the report. I think that it ought to mirror the goal that we started with, and what is in there now is different than what we started with. And then.
Goal of report, okay.
Yeah, the very first sentence of the report. And then I would suggest maybe to the task force, if we are at a point where we think that the things that we've already sort of come to, maybe allowing the public comment earlier, perhaps after lunch.
Okay. And Michael? Excuse me, Michael. Now, there may be some items that we want to look at on our big list that say, and education may be one of them, that, hey, I think the legislature will be very receptive to something like this. And it may not be this hard, road to passing like something else, so we may want to include some easy ones, easy fixes in there too. And I know as clerks, we do this all the time with like legislative language, which has unintended consequences or created a inefficiency, and the legislature will give corrective language, and that's not considered, oh, you used one of your chits for your big, of your legislative agenda. Now we'll just fix that to make the system a little bit better. So maybe there are some in here that we're listing that fall under that category. That maybe, again, speaking with legislators, that they're willing to, hey, oh yeah, I think education should be increased, and I'm going to go ahead and put that as part of this, and that's, but you still have the big items out there. Go ahead, Michael?
I think, and I'm willing to lead this conversation if you would like, but, I would like us to talk about supported decision-making and alternatives to guardianships, which is, again, major in the state. And as, you know, my coalition is getting ready to try to pass a bill here in the state of Florida, it's really good to actually be educated on exactly what supported decision-making is and the terminology of it.
Okay. Hillary?
Thank you, Ken. I'd really like to discuss the ward's rights and how we can enforce those rights. The rights to visitation, the rights to change their court-appointed attorney, and how we can enforce those rights so that the wards can speak for themselves.
Karen?
I know it's going to be one that we're going to have to stay vague and broad, but I think court monitoring statewide is a topic that we want to include in this report.
Okay, so here we have 1, 2, 3, 4, 5, 6, 7. We have 7 topics for this afternoon and limited time. Okay? So, did I hear a comment?
Can you go through the ones you have? Because I have one more than you.
I have professional guardian tracking, education, ward, instead of ward terminology, use person under guardianship, the goal of the report, supportive decision-making, wards' rights and enforcement, and court monitoring, court monitors. What one did I miss? I got it. Okay. Yes.
Can we make it an even 8? I really feel strongly like the healthcare industry pipeline issue, because those are our most vulnerable. If you're sick, if you're aged, if we're talking about protecting the most vulnerable, aside from any disabled individual, this is the bucket of people we should really be protecting.
Okay.
And there's quite a pipeline.
But we're not discussing the pipeline, we're just discussing the topic. So, is there any, how do you suggest we do this real quick? I'm trying to lost like which, I know we won't be able to get to all these this afternoon. So
I already forgot the term, but the one Michael suggested, I'd like to do first.
Okay. Let's do that one first.
What was that one?
The ward versus person.
Supportive decision making, yes.
Oh, wait, corporate, which one's supportive decision
Decision
making?
making, that's the
Okay.
term.
Somebody.
Sorry, I need lunch.
Okay, it's now 12 o'clock, 11:58. I'm going to handle the one topic before we moved, before we have lunch. Is there consensus in the room that a better terminology is person under guardianship than ward?
Yes.
I have
person.
Protect.
Okay. Protected person. Protected person?
See,
Yeah, that's the term I used earlier, protected.
Protected person?
Under guard.
okay, I don't like protected person because I'm hearing some of them aren't.
And that's, then they need to.
Okay, if we're gonna have discussion, then let's have discussion and, onto the microphones. Okay, so go ahead, Anthony.
Another option is a person served by guardianship. That's used nationally.
Karen.
The mental health criminal court uses client or forensic client when referring to somebody whose capacity or competency is at issue. So it's just another alternative.
I like it.
Camera.
I just think in the healthcare world, where there might be physicians or people that aren't familiar with the legal side or the guardianship court side, I think protected person or person under guardianship as well, but that helps them understand that there's a legal advocate that's.
It's descriptive.
It's descriptive.
Viviana.
I would just say that protected person is euphemistic, and I don't like that.
You have to speak. I'm having trouble hearing.
Oh, I'm sorry. I was just saying that protected person is sort of euphemistic, and a lot of people under guardianship don't feel like they're being protected. So I would steer clear from that because we're kind of, it's better to do something neutral versus adding some sort of value to it.
Okay, is there, and maybe I'll give, go ahead, Dan.
Just, I especially in this environment that we're in these days, the rules of statutory construction are really focused on a textualist view of those things. And so when you're changing a legal term of art, which I believe this one is ancient, and when it's used in the legal community, it invokes a fiduciary responsibility for another. And so, I mean, I assume we're talking about changing this in statute or some other form of general law. And if we do that, I just think the suggestion should be that you're crystal clear that you are substituting that word for the other definition that flows. So when you follow this word, ward, you get taken into someone responsible for another, the definition of guardianship. Just make sure that because as I know in my profession, we tend to pick at such things in litigation if it's not absolutely clear, especially in this environment. That's all.
And I'm going to ask you to take your comments and editorialize, but do you think a person under guardianship term meets that?
I think it can if the body that if you're dealing with I would say in my view, if you're dealing with a body that has the authority to change that in substantive law, and they're clear that there's no definitional change to it by saying it is an absolute substitute and following the chain of what flows after it. So you've got a whole body of law that has been built around this, and it is a legal term of art, as well as the way we describe, people that are subject to guardianship. And so that's just, just to be precise.
At the same time, I think we've all experienced, especially in the past 5 years, there's lots of terminology which is being changed because of the pejorative nature of that terminology.
That's right.
And I think this is one of those that fits into that category, that even though it may be an ancient term and everyone refers to it, it has a negative meanings, which therefore people are open to say, even though it may create some issues here, the time has come for a new term. Go ahead, Anthony, then JD.
Yeah, I think the terminology word is the lowest hanging fruit, but there is other pejorative, demeaning, prejudicial language used in Chapter 744, alleged incapacitated person. We don't do that in any other area law that I know. And there may be others. So I don't know if we want to be so narrow in saying, focusing just on ward. I would just like an examination of all the pejorative language and, thoughtful substitution of that language.
JD.
So I'm sorry for not understanding why there's a negative connotation on the ward other than you're under control of somebody else. I don't get that part, but I'm not the only one here. But getting into the word police is probably going to be a concern for the legislature when we start. If that's what we're concentrating on, I don't know that the bigger picture is going to get served. If that's what we're going to worry about, is the terminology we're using for it.
Okay. Yes, Shannon.
The only other thing, if you think about person under guardianship, is that we have minor guardians, we have voluntary guardians. So are we then going to change all of it to be an alleged incapacitated person under guardianship? Are we also going to say a person under voluntary guardianship, a minor person under guardianship? We're going to have to change all of that language. So I just want to make sure we're looking at the big picture, which means a lot of statutory changes across the board.
Before I call on you, Hillary, maybe we go back with the Karen philosophy here, that we kind of say that the concept be that language in statute should be updated to reflect the current norms and the respect for the individual, the dignity of the individual, and just leave it at that, and then well, go ahead, Hillary, first.
I'm not sure what the answer is. I do like maybe protected client, but these are people, they are people. And again, in Hillsborough County, when you are put in, a petition is filed, or are an alleged incapacitated person, you on the court docket, you are listed as a defendant, like you have committed a crime. And that is not the case. And I did mention that to Honorable Sean Cadigan, and it's still as we speak, you are listed in the court dockets. If you look up Joe Schmo, he's listed as a defendant. And if that's not derogatory, what is? So something needs to be done, but I do agree with JD. We've got bigger fish to fry right now.
Yeah,
Deanna?
I'll say I really thought it was just going to be easy to do. I'm happy with Anthony's suggestion of, let's just say, look at the language, make it less pejorative. That would be fine. I think that we can move on to other issues.
Right. And again, there are bigger fish to fry, but this may be something which,
I thought we would agree.
Yeah, I just wanted to add that, yes, we need to remove the pejorative language, but this is a big issue. And it's reflective of the big problem in guardianship is that Florida guardianship law treats guardianship as one size fits all. And it's not, all these different communities have different needs. So, taking out pejorative is good, but I also would look at taking out the prejudicial language and stacking the deck against the person from the get-go.
Yeah, if we could include that, sorry to speak out of turn, that'd be good too.
Yeah. And of course, pejorative language is a judgment. I mean, in all due respect, Hillary, I don't consider defendant a bad term. I mean, in every, no. Every civil case, there's a defendant and plaintiff. I mean, there's doesn't, but I'm not getting into a disagreement or argument with you. I'm just saying it's funny for me that I would have never thought of that as a negative term.
And maybe that's just me being a New York City, native, but guardians are always referred to as professional guardians, and are they really professionals?
Okay.
All you need is a GED.
Well, no.
All you need is a 40-hour course. If you're an engineer, you need more than 40 hours. So, it goes both ways. To call someone a ward or alleged incapacitated person, you're behind the 8 ball to begin with, slim as it might be.
And I think that's the concept here, that maybe the language needs to be updated to reflect
Correct,
current
Chair.
dignity. And I think, do we all agree with that? And I would consider this a lower priority, obviously. This would be like a 2. Is that a? Yes, JD?
1.
A 1. Okay, a 1. This is a 1. But if some friendly legislator says, I want to take this on, we say, here it is, we'll help you do it. Okay, so we got that one done before lunch, so that's going to off our list. And by the way, as clerk, and JD can verify this, we're defendants all the time on these foreclosure cases, tax deed sales. So I yeah, so
I'll never.
I didn't realize it was a bad term. Hey, stop, don't sue us.
What's in a name?
Let's see, now 12:09, let's go ahead and break for lunch. Okay, do we have our lunch here? Does it have our names on it, or how's it done? Alphabetized. Jeez. Right, alphabetized by height, right? And folks, we have a half hour listed, but we really would like 15 minutes of and then you can eat during a working lunch. And you can stay with Tiger Little. There's water and cooler.
Yes, yeah.
And I'm sorry, you guys want to solve it.
Give me my card, because I see that.
Yeah. Right, and I just wanted to introduce myself because again, we kind of work for the same. And so I'm in your here,
Started a conversation about, the kids that are, like the aging out of.
It's on my old card.
And to, so we can talk about that.
Sure. Yeah. Please, yeah, no, let's, yeah, sure.
last committee member meeting we have gone to, and Liz wanted to talk more about the here, like having those individuals maybe priority week with.
Yes, yes. Alan started a program of mentoring
Problem I've just dealt with once or twice is when I'm representing the ward, the guards are the
I don't do that.
affected person.
I mean, I have done that. I've been in that.
And I'm looking at the guardians saying, there's no way. The Lord is telling me, yes, this is what I want. Yeah.
That's very hard.
Yes.
You're kind of like, I need to be an advocate, but I also like, want to make sure you're gonna be right.
Right.
Yeah.
So you want to really want to get an access control?
Go.
I actually have one of those little things next door when I'm watching TV. Plus my eyes, plus my.
Yeah,
Well, it's better than the alternative then.
you could just tap it.
Are you in comments?
No, I'm leaving tonight, tomorrow for a wedding in Sarasota.
Okay. Oh, was your friend you went to the baby,
I hosted the
Oh.
yes.
Karen, I'm not gonna get the Bible passage completely right. As much as given money or not. He's gonna send it, we're all gonna
I'm creating right now a list of what we work with because I think it would help to put up there.
It is.
And I think they have so much.
One of the.
You know what I mean?
Teach me and hear me about it. That one moment, that they went, shut that down, you know, and one way that was forwards and around the city elephants. But it's
This is literally, it's just me in a nutshell. This is how I prosecute cases, but this is how I do it.
I have one like that too, but I didn't bring it up. I didn't want anybody to be like, really?
I think we had this conversation the last time. We were like, oh yeah, I have one of those too. I didn't bring it.
It's exciting to figure like that. You don't get to look at them.
Okay, folks, why don't we go ahead and get started again? And I just want to say this, and I hope no one thinks it's condescending, but I really appreciate everyone's good behavior here today. And I mean, I have to admit, I was a little bit nervous about today's meeting. I was a lot nervous about today's meeting, but I really do appreciate everyone's temperament and try to. If I was a kindergarten teacher, you would all get gold stars. I still give those out, but I just want to say thank you for everyone's nice behavior. Let's handle another issue, which maybe is not as controversial since it's right after lunch. Education, because there seemed to be, even from the Guardianship Association, I shouldn't say from the association, from our speaker, who has great experience in guardianship, Irene Roush, she was saying that education should be increased on this. So is there Diddy?
I absolutely agree. However, one of the concerns that I have, sorry, but mid-cookie, is we still, I think, have an issue with the court waiving requirements, especially on family guardians. When I took office, I found the problem was driven by the fact that nobody was providing the training anywhere close. And so we had to go to the local college and get that stood up so that we could get that. And then convince the court to not, every time they walk in and say, I don't have time to do it, waive that. So the waiving of it is a concern, certainly for me. And obviously the legislature is not going to be able to tell the court not to do that, but making sure that there's an incentive on, or at least emphasis on making sure that there needs to be a logical reason why we're waiving it, not just, I can't find the service. Or goes cost out example.
And maybe there's different ways that this could be done. I mean, and I don't want to complicate the issue, but that's what we do. Maybe there should be a different standard for a family guardian than a professional guardian. And I was talking more in the context of the professional guardian arena of an education requirement, because you're right. In the family guardianship, they often waive it, and those are the folks who need the training on what to do, because that's completely new to them. But maybe it should be customized for family guardians, because I'm only handling one guardianship, and I just need to know on this particular one guardianship, what do I do? Santi, you have some thoughts?
I think education is a much broader topic, because I think we're talking about education for the guardians, for the judiciary, the examining committee members. I think it is a broad education that we need to be looking at. And then I wanted to re-raise my issue about the public comment, because we're at a point now where we're working on our report. To the extent that we have public comment that may be helpful going forward, I'm not sure how helpful it will be after we finish today.
Okay, let's go ahead. And of course, I think we need to wait a little, because in fairness to the folks, we told them they have we are having abbreviated lunch. So maybe what we can do, it's 12:37, maybe at 1 o'clock, we do a half hour of public comment. And I'm sure there'll be more beyond that. If there is more beyond that, then we'll stop it at 1:30 and do our business, and then have more public comment at the end.
Thank you.
Does that work? So at 1 o'clock, if someone tells me we're getting close to 1 o'clock, that would be helpful. Okay.
And Ken, if I could just clarify.
Back to the education, one of the things though, and again, we're submitting legislative proposals. Professional guardians are under can be statutorily required to do this. The judicial hours would fall under the Supreme Court again. So I mean, we can say to Supreme Court, you may want to consider that, but that's something we're less, we don't have the ability to, this task force, which is the legislatively task force, may not have the same authority on.
That's the exact point I was going to make. And somebody mentioned clerk education when we were talking about it earlier. Is that Anthony?
No. Sure.
And I'm assuming we should put that in there. Huh? Yeah.
And this is Sean. We need to include, besides the examining committee members, which Sancha mentioned, the court-appointed attorneys as well.
Yes. And maybe our recommendation, does anyone have some good wording as a concept here that could help me? Tell Tom.
Could you repeat that, please?
What the concept, what are we trying to articulate here as far as, do you have enough, Tom, to?
Yeah, I think I have. I think we're talking about enhanced education for every player in the guardianship system. And then we would say, for example,
And these ones can be corrected through statutorily, and others would fall to the court.
Fall to the court system. Yeah, I can word it, I think.
Let me get Zane first, and then Mike.
Just a quick wordsmithing, I would say enhanced and continued education.
Yeah. Thank you.
Okay.
Zane.
This is just one I'm going to be contrarian on. I work with lots of guardians who we're so thankful they're there. At all. We are so happy to find them at all. They're spending their own money because the board doesn't have enough. And to make it even more difficult on any level, is making it, if we want to say improved education, so that whatever they get actually does them some good, I don't have a problem with that. But if we wanted to go, if they have to do 4 and we're just going to make it 8, all we're doing is getting rid of more people. And the big problem the courts have, and the reason they waive it, is because if the guardian doesn't do it, what's the court going to do? I mean, they can't get rid of that person. There is nobody else. And that leaves the ward with nothing. And so I can't support, and it's just me, that's fine. I can't support making it more difficult on the guardians.
And Mike, I'm not trying to counter your point, but as an elected official, I have to take 4 hours of elected official ethics. Okay, I have to also, I'm a CPA, so I have to take 8 hours there of ethics, 4 hours there, which is separate ethics, but my 4 hours of elected official ethics, you know, they put that online, you know, where you could sit in front of your computer and take your 4 hours and it's free. Okay, to do that. So, I mean, there's different ways. I mean, and obviously the colleges have offered this and there's a price tag on it. This doesn't necessarily have to be a price tag item at times. There could be alternative ways to have enhanced education and still not put the, because this is complicated stuff. I mean, and again, I will counter you on this. It's like, this is an important responsibility. I mean, a tremendously important responsibility. So there should be, you know, some type of education component.
Yeah, I'm not saying get rid of it.
Involved. So.
I just wanted to concur with Mike. I don't think we should make it more difficult for non-professional guardians. But I think we should make the overall education, you know, improve the overall education and make it uniform statewide. The way the statute is right now, and I can speak specifically about Palm Beach County, our local bar association develops the content. It's approved by the chief judge and it's administered by another third party, not for profit. But there is so much room for improvement, such as, you know, interactive learning and all the, you know, cutting edge education stuff that could be incorporated. So I personally think in many spots throughout the state, we're wasting the non-professional guardians' time. And I would just encourage something that's uniform and greatly improved, whether it be interactive through some type of you know, web application. But that would be what I would advocate for.
As of education, I think it's important for guardians to also have required continued training as part of their guardianship license. That probably would include like fundamentals of guardianship or like different topics, because I'm not familiar with like when they first get their license, if they have to take a class. I think it's like 40 hours, but a one-time class for 40 hours should not be enough. So I think continued on-the-go training, like applications, whatever required by the state, would be encouraged.
Thank you, Michael. Gina, you're recognized.
Hi, I just want to point out that the FSGA has been advocating for more education for professional guardians, for judges, for attorneys, for family guardians, for anybody whose profession touches guardianship, the community in regards to alternatives to guardianship. And even now we're working on ancillary education for family members to be able to come to a video library and understand how to file reports. So I just want to underscore how important I think education is at avoiding guardianships altogether, and then pointing people in the right direction for what type of services that they need. Education, the FSGA has been recommending that professional guardians get 30 hours of training, and then in the specialized areas of fiduciary duty, ethics, and end of life decisions, a specialized 3 hours in each of those areas. So that's something we've been advocating for, and we think is very important, education all around, especially about the laws we do have and implementing them when it comes to person-centered care.
Could they send that to us, what their position on that is?
Yeah, and I think it's part of Irene's PowerPoint. Was that, Gina, was that contained in Irene's PowerPoint, those recommendations or those points you just mentioned? I thought they were.
I think that she may have mentioned it. I think it was in the letter that I sent.
Okay.
And we in FSGA, in addition to what we promote for professional guardians, are always willing to work with stakeholders to get education to everybody, regardless of cost and ability. But we promote it in every sense. Trying to make this system better.
Thank you. Are there any concluding comments on the education component? JD?
Real quick, I wanted to throw out a concept of either board reviewed or accreditation type of processes for professional and public guardians. And the association there is probably would be critical to something like that. It's an effect of voluntary going over and above industry standards or training requirements that I don't know that I've heard of any sort of comments about that kind of thing, some sort of accredited board. The attorneys use, I guess, board reviewed or whatever, board certified, which is somebody you went out of your way to be over and above. And then you also agree to have your peers come in and double check that you're holding those standards. That may be something that we can include into the concept. It's different than, obviously the families are way different.
Go ahead.
I just wanted to just clarify a couple of things from Michael and some of the others. The professional guardian does initially have a 40-hour course, and it does include a lot of topics as far as ethics, guardianship basics, how to handle guardianship on a whole, filing reports and all of that. And so that course is being updated today. So I've been working on that for about the last year, and we anticipate to have a new version of that available for the 40-hour course. In addition to that, professional guardians are also required to do 16 hours every 2 years of continuing education. Today, they do not have, there isn't a specification to say certain number of hours and certain topics. However, FSGA, among others, and included in Irene's presentation, there's been to increase the number of hours in addition to set specific topics that they need to cover. We have accepted those recommendations. We full-heartedly agree, and we've been pursuing that and other mechanism as far as the rulemaking process. And so we've accepted those expectations and those recommendations. We agree with those, and I'm working through that process as well. However, it's still in the draft review stage. I don't want to discourage the committee from putting that statutorily, but I do think that that's something we have addressed, and it is, so to speak, in the works, or something that we plan to do in the future. As far as other training, also, I think Mike mentioned there are some courses that are out there for guardians for continuing education that do not have an additional cost. I know you were specifically talking about non-professional guardians, but as a whole, there are tons of courses that are available for no charge. FSGA, for example, will have seminars. There are tons of information out there that they can get those credit hours for no additional cost. And then I'm also developing I've solicited a lot of different stakeholders, a lot of them here, Shannon included, that have created training specifically for topics that I feel there's a deficiency that I didn't see in the catalog, as well as OPPG. We have a YouTube channel where we're attempting to address just general topics for public education. So some of those things about alternatives to guardianship, what is guardianship, to kind of address some of those things. So I think it's great that we're attempting and we're putting that in our report, but also know, I'd be remiss if not saying we're working on a lot of those things that may possibly come to pass really soon.
I just want to, as a point of really clarification in the state, when you practice in one circuit versus another circuit, the practice of guardianship can be drastically different. So if I practice in the 8th, I practice in the 5th, I practice in the 3rd. Sometimes I go out to St. Johns County. What I do is I will call a local attorney and say, does your judge like a bond or restricted accounts? How does the DNR process really work? in your circuit. What I'm saying is that education can be different from circuit to circuit because the practices of guardianship are different from circuit to circuit. And so while I wish it wasn't like that, I wish everybody had, I mean, frankly, the monthly budget, right? So if we have someone who's incapacitated and on average they are spending $3,500 a month on the facility, on extra care, whatever it is they might need, in one circuit, you might have to specifically say how much money is being spent each month and then have a calculation for the entire year. And if you exceed that amount for any particular month, you may have to file a petition with the court because that month the person was in the hospital. So, I mean, it's just so different from circuit to circuit. There is no uniformity. And so it's very challenging from an education perspective to be somewhere in a smaller county with a smaller budget circuit to have the same level of education that you might find in Palm Beach County, right? So while I think education is important, we have to remember that some counties, some circuits are not going to be as capable of providing the level of education that we might see in other counties and circuits.
And Shannon, I don't disagree with anything you said. You're absolutely correct.
Yeah.
As a matter of fact, as we get more into this, you see a lot of differences. You know, I keep discovering differences that I didn't even know were differences. At the same time, for a guardian, they have a basic responsibility, which is uniform throughout the state of, you know, their supposed advocacy of the ward, the protection, the judgment thing that you talked about. You know, I think there's certain concepts that, you know, from Monroe County to Escambia are the responsibility of the guardian. And they can be educated on what's the court's responsibility on this and what's the clerk's, although, you know, with the disclaimers that the procedural part of a lot of this will vary from circuit to circuit and maybe even from judge to judge within a circuit. So,
well, and I would also just point out with the new DNR requirements, right? On day one, if you believe as a guardian, a family guardian, that the DNR that you had before the guardianship was established is still effective, that's a problem. You know, there is a process that's incredibly rigorous for a new guardian to have to get that DNR approved by the court. And it is very rigorous. If you don't have a DNR, you may have had one 2 years ago, but you may not have one now. And so it is incredibly difficult. And the challenge for education.
And it may be difficult in some circuit. It may not be difficult in another circuit.
It's pretty difficult in every circuit, just because the law on DNRs is incredibly difficult. I would guarantee that there's probably 80% of the attorneys who practice guardianship on a regular basis do not understand the DNR process because it's so new and it's very challenging. So is it an emergency or a non-emergency? There's two completely separate pathways for that. My point is that the education itself is so complicated.
It is.
And so, you know, we want to have uniformity, but we also have to recognize that it is going to be very challenging to keep up with all the task force changes, all the law changes that happen really every couple of years, making sure that everyone is educated, and then finding family guardians willing to do this job, because it is a problem. Like Mike said, we have a lot of people out there who cannot find a guardian can't find someone to be their guardian. You know, they may be on the wait list for a public guardian. They don't have anybody to help them figure out how to get their bills paid. So it is very challenging. And if we add a whole bunch of obligations on top of guardians that we already have, it may be difficult. And then to give the training that's appropriate. So,
Hillary, then Karen.
Thank you so much. But there are some things that are across the board that should be focused on concerning educating for-profit professional guardians. You know, time and time again throughout different counties, throughout the state, we see it's, you know, the order disapproving accounting. It lists A, B, C, and D. And then you see the activity logs. Lawyer spoke to guardian about the disapproving of accounting. Guardian spoke to Attorney Smith about disapproval of guardian. Back, forth, and the elderly and the disabled people are being charged for this. And we're talking about for-profit professional guardians who have been in this business as a guardian 10, 20 years,
who should know better, who should be at the point where there are very few, if any, discrepancies. And the wards should not be paying for that. So education-wise, that should be a prerequisite. You've got to get it down pat. The ward will not be paying for your mistakes.
Karen?
Based off of the initial recommendation on how this was worded, it was going to be the enhancement and improvement of education for all parties involved in guardianship. So anecdotally, I just wanted to suggest that somewhere within the report, we can refer the legislature to, as an example, for death penalty cases, there are certain minimum standards required for experience and for education for the attorneys in order to be court appointed or to become involved. And also for the uniformity of education for guardians just across the board from a prosecutor's perspective, I look to see if there is a standardized education method, and I know there needs to be a combo approach, but if there's a standardized education that all guardians go through, and I can point to on slide 3, this was the biggest point, and you definitely saw this, you definitely were put on notice that this is something you were supposed to do, and you violated that. That helps me as a prosecutor in proving my point that, you know, this person definitely knew what the rules were, they were on notice and they didn't do it. But I agree to your point that not everything can be uniform.
I think you have some stuff to go on in this one, Tom?
I was going to add that I think one of the things, and I'm not sure how we'll phrase this because it's not a statutory recommendation, but the Clerks Association has developed a really good relationship with the Florida Bar, particularly the Legal Fuel Department, who provides a lot of free education, particularly on new areas of the law. I think we could have some recommendation in here that we work with the Florida Bar to develop these specialized, when new changes come along, that those be developed and they develop programs and make it part of the legal fuel where it's free for a while.
Okay, we're now going to move to, score on this. Anyone want to throw out a number? Three.
Yeah.
Four.
Let's go with 4.
4.
Looks like consensus.
And it's 1 o'clock.
Yes, thanks. We are moving to public comment, and where's our person? Are you doing the timekeeping? Patrick is our timekeeper. Patrick, I know this is awkward, but can you move your chair right in front of the podium? I mean, it helps the speaker. They don't see you to the side. The public that are representing victims, they would prefer, because we really don't want to be managed here. Make a comment. Others who want to hear then get to start at meeting 30, and it becomes the defamation attack seen in the past. So just I would stick to the original. Those I can speak for. Sorry, at that time. He's made a comment to speak for the group, and I'm going to ask the group outside of the task force members if you all prefer.
We figured out here. I like the path we already started down, which is give them time to talk now. I like the idea of hearing if we're going to make it. I like the idea of hearing some comments before we make some decisions.
With all due respect, why don't we go ahead and just have some public comment now? Let's go with that. We want to hear from you, and I hope no one thinks this is a way to manage public comment. I think it makes your public comment more meaningful, that we can have time to respond to it during the course of our meeting. So we'll ask Marcia Friedman to please go first. Marcia? Oh, and you go to the podium right there that we have. And Marcia, Ms. Friedman, you will speak and you have 3 minutes, and Patrick's going to help you with your time management. And then Rick Black, if you could be ready to go next, that would be appreciated so that we don't have a lot of in-between time.
I want to make sure that you can hear me. Can you hear me?
Yes, we can hear you. You're now recognized, Ms. Friedman.
Thank you very much. Marcia Friedman is my name again. Sadly, my victim mother, Lilia Martinez, Cuban, immigrant, U.S. citizen, vulnerable elder, passed away this month. Based on the Constitution, we, the people of the United States, in order to form a more perfect union, justice, and to establish domestic tranquility. Fact, my mother was held captive for 7 years inside a garage, neglected, isolated. What was her crime? Had advance directives, I'm the only daughter, and was part of a marginalized Florida population. This was her crime. The Constitution established due process. That fact intentionally ignored. Lilia Martinez left communist Cuba dictatorship where there was no hope to the land of opportunity. In hope where she became an American citizen, but ended up dying alone with no hope because of the system that was supposed to protect her, my mother. Denied due process, human rights protection, and the basic dignity all humans deserve. No one is above the law. Until the stakeholders take full responsibility for their actions, the situation will get worse, and there will be other Lilia Martinez who suffer the same fate. Should anyone be isolated and die alone, would you? I can't bring her back. We were robbed precious times together. I went to seek guardianship to protect my mother, not to see her abused, neglected, and abandoned. Where it was good that the judge finally said, the daughter needs to be supervised, because God made a way that she still remember her daughter and wonder why I didn't come to see her. I'm not going away till the abuse stops. Thank you.
Thank you, Mrs. Friedman. Thank our condolences on the passing of your mother this past month. God bless you. Mr. Black, you're now recognized. And next, after Mr. Black, is Lawrence Timothy Reed, Jr.
Thanks, Ken, Clerk Burke and
Ken's fine.
Clerk Palmieri and the entire task force. I've been labeled a lot of things around the country for what we're trying to do for victims of fraudulent guardianships and conservatorships and other atrocities committed by the predatory legal community, the litigators. My name is Rick Black. My wife and I founded SEER. It's a nonprofit about 3 years ago. We've counseled over 4,000 cases in the last 3 years, actually the last 8 years, because we started working on this well before we formed our foundation. What we're demanding this task force to address are exceptions. Judges who routinely demonstrate poor judgment, they're human, just like us, and predatory attorneys who have more nefarious intent. Sadly, your courtrooms too often become a lawless environment where the narcissist and sociopathic individuals find safe haven. You can't manage exceptions without data, and that requires everyone in the system embrace transparency. The bar is demanding more confidentiality and privacy. Digitizing the information in a statewide system, all 67 counties, is critical to provide a check and balance on what is happening routinely. The issues we want to address occur in the initial petition for guardianship or the first objection. What happens after that has a snowball effect that allows a vulnerable adult to be exploited often for years. Judges too often entertain litigators versus demonstrating a steadfast and zealous commitment to protect the proposed ward. Our demands have not changed. Ensure transparency of these proceedings. State or federal funded trained and zealous counsel for the proposed ward, who stays as a steadfast advocate for that ward if a guardianship is established until he no longer needs it, or she, due to death or repatriation. Adult guardianship and trust frauds are entitlement in the Florida guardianship system. Bar leadership who benefit from guardianship and trust know exactly what's wrong with this system and what needs to be fixed. However, admitting those issues or fixing those issues will diminish their ability to make limitless profits, and no member of the bar wants to impact that. The bar's reluctance is not an IQ test. Let's stop shuffling the deck chairs on the Titanic and deal with the issues. SEER will continue to demand it for all Americans and all Floridians. And I pray to God that this task force does the same. Thank you.
Thank you, Mr. Black. Lawrence Timothy Reed, you're now recognized. And following Mr. Reed is Joan Stanton.
Thank you to everyone here who's here to reform the guardianship reform because it direly needs it. And thank you, Clerk, because I've heard you mention before that Florida should lead the way in this because of its sheer number of citizens who are seniors and who are at risk here. And I'm here to show how it's at risk from a personal example with my mother. But let me first say, I didn't know what Rick was going to say. He saved me a lot of time because the 1 billion pound elephant in the room is how much money the attorneys are making. This is not about guardians. Guardians are pawns in this operation. These are predatory attorneys who are ripping off estates. They're doing it deliberately. They're not stupid people. They're not incompetent in any way. They're doing it intentionally. And they're going to keep doing it intentionally until there's either a ceiling put on how much they make, a cap, or there's some kind of restriction on what they can take from us in a state. And I don't say this without evidence. In fact, to your right, Clerk, is Inspector General, who's a beacon of light in this aspect. Sharon Bach and the dignified gentleman there, I don't know his exact title, but Inspector General for Palm Beach, issued this Inspector General report years ago condemning the attorney fees in my mother's case. My mother's estate was worth about, let's say, $825,000. In the first 6 months, she was billed over $250,000. And now they want $650,000. And they're still, to this day, I had 2 motions this morning by Zoom. They're still, to this day, trying to raid now her homestead. Completely illegal in the state of Florida. And now we have some good judges who are ruling correctly. But in the beginning, there were bad judges. And just let me summarize, and bad attorneys. Firstly, the DCF in my mother's case and a police agency were contacted. They adamantly, emphatically said that my mom should remain in her home, was not in need of any guardianship, and had no mental incompetency or physical incompetency whatsoever. The guardian who filed secretly the mental capacity, or whichever was the first petition, never told the court. Remember, if the family members are not allowed there, something that should be changed. They never told the court that the DCF did that. In fact, she implied, basically said the opposite, that there's a police investigation, that the mother is in imminent danger. A complete fraudulent perjury. Okay? That started the process. Then my mother was appointed a court-appointed attorney. She was not allowed to have her own attorney. Well, guess what? This attorney, only 3 years earlier, was found guilty by the federal government of $26 million of money laundering, and $2.6 million of fraud. John Farina, you can look it up in the federal court system. Now, how in the world, this was not revealed to the family, of course, how in the world can this happen? The end result, with 10 seconds left, my mother died alone in a facility with 6 children who couldn't get in to see her because the guardian insisted she shouldn't have visitation. And the judge went along with this. Reform the system. Respect the citizens of Florida.
Thank you, Mr. Reed, and thank you for being with us today. I know you traveled from Boca Raton. We appreciate you being here. Joan Stanton, you're now recognized, and following by Joan Stanton will be Hillary Stanton.
Hello, I'm Joan Stanton.
Ms. Stanton, would you just move the microphone down so we make sure we hear everything you have to say?
Okay,
Thank you.
can you hear it?
Yes,
Okay.
ma'am.
In order to get a mortgage broker's license, I had to be tested, fingerprinted, a credit report pulled, and investigated. I'm also required on a yearly basis to take a course. When I had my mortgage business, I had to go through a yearly audit where they reviewed all my assets, accounts, including checks written and deposits made. In order to get a captain's license, I had to take a detailed class, tested, fingerprinted, had to keep track of my hours on the water and turn them in yearly. In order to be a guardian in the state of Florida, you are required to take a 40-hour class, a credit report, and a basic criminal check. You are then handed over a person's life and all assets to do as you please. Once a year, an acting guardian is required to submit a financial statement with 1 month's bank statement to verify the asset accounts of the ward. That gives the guardian 10 months to do as she pleases with the liquid assets, just as long as on month 10, you make sure all liquid assets are back in the ward's account, so that on month number 12, the statement reflects beginning balance and ending balance are in sync. There is no accountability for those funds over a 10-month period. In Linrod Douglas case, I visited Palm Beach County Clerk early on and begged them to do a full audit on Linrod and was told that would be too much work. I was told at the visit, we'll keep an eye on him. Well, after it was discovered he stole over $500,000 from various clients, then and only then did they feel an audit was necessary. I complained about John Kramer, my parents' former guardian, who allowed assets to leave my parents' premises without a court order. I never heard back on any of the complaints against Mr. Kramer. On July 15th, 2016, Michelle Hollister prepared a report ordered by the courts. In the report, she indicated Tony Weber, my brother, was in favor of my mother remaining at Perserum. She never spoke to or interviewed Tony Weber. I have a notarized statement from Tony Weber confirming this and confirming that he was not in favor of his mother remaining in the facility. Michelle spent very little time with my sister Mary and I, and based a lot of our comments on information that was provided by the owners of the facility, who were later arrested for abuse. Due to this inaccurate report, my mother remained at the Perserums, from which she was later removed by authorities after the Perserums were arrested, and she passed away 5 days later. And that hurts. I complained to the necessary authorities about the Perserums where my parents were forced to live. My complaints were never taken seriously. After the Perserums were arrested for abuse, it was discovered Mr. Perserum was tying some of the residents to the bed at night, leaving all residents unattended until morning. It is time to start paying attention. I'm going to start with asking you to require all guardians to submit the ward's yearly accounting on all asset accounts, all pages for the entire year. No one should have full access to someone's asset with little or no oversight. With all asset accounts in the proper hands, they can be reviewed for accuracy.
Thank you, Mrs. Stanton. Hillary Stanton, you're now recognized. And it looks like Ray Contreras will come next from Ponte Vedra. Ray Contreras.
I'd like to begin by saying my grandparents' name. Richard Weber and Elizabeth Weber were murdered by this system. They were robbed blind. Their families were denied access to them, all because of the lack of oversight by the state of Florida, especially Palm Beach County. If you think of any career that deals with the human experience as intimately as a guardian does, you might think of the schooling, the training, the in-service hours, the audits, the documentation, and anything else those careers have to provide. Nurses, doctors, teachers, childcare workers, social workers, to name a few, are all held to a certain standard and must continuously prove themselves. Even to begin one of these careers, there's countless steps and there is schooling required, specifically a college education. Guardians aren't even required to graduate high school. These guardians are in charge of every aspect of a human life, physical health, mental health, finances. They're in charge of their person, their property, everything down, even down to their spiritual well-being, by having control to access the houses of worship they may choose. Everything about a person is handed to a guardian, and they don't even have the adequate training to deal with the workload that comes with taking over someone else's life. They're not required to be trained in mental health. They have no medical background to know the best course of action for their wards. They have no training in finances or economics. They take full control of somebody's life, and they can drain a life savings in a matter of months due to their negligence. My grandparents were placed in an emergency court-appointed guardianship. My grandparents did not need this guardianship. They had a savings account in place that they worked hard for their entire lives. They had a power of attorney in place in case decisions needed to be made on their behalf. They had their remaining years planned out, and they were robbed. As a family member, you're stuck placating this crooked, disgusting system. You have to watch your family members be abused and killed. You have to choose to fight the system, and then you're ostracized and you're denied access to them. You're monitored and you're treated like the crazy criminal. They shut you out. If you choose to not fight the system, you're stuck with your family member crying to you, begging for help, asking to be released from this prison they did not ask for. We have a bigger societal issue, and as a society, we push our elders out of sight. They're the most precious pieces of our nation's history, and they're abused and drained and hidden away through this system. We say land of the free and home of the brave, but where are these brave people when your elderly are being tortured? Who is free when your World War II veterans are ripped from their homes and denied access to their family, friends, funds, anything? Other nations don't treat their elderly in this manner. They are revered and taken care of and treated as the precious keepers of history that they are. And here we are as Americans claiming the greatest country on earth, and we're murdering them. If Florida works towards setting the bar high and holding guardians accountable, perhaps our fellow states will follow suit and we can see real change and protect these people.
Thank you, Ms. Stanton, for being with us today. Ray Contreras, you're now recognized. And following Mr. Contreras is Lynn Saylor.
Hello, my name is Ray Contreras, and I just wanted to get a show of hands who's disappointed with what happened last week with the Olympic girls in the Capitol Hill, where they were molested for years. The FBI, the courts, I mean, they didn't do anything. I mean, it was traumatizing. It was a system.
Mr. Gutierrez, just move your microphone up and try speaking a little louder, okay?
Sure. What I'm talking about is what happened in Capitol Hill. All these girls, you know, they called the authorities and nothing happened. The FBI didn't do anything. The local police, the state police, nothing happened. Here we are, you know, imagine them being here today. Imagine if they were sitting here telling you what they experienced. And your response to them was, well, what if we had maybe 45 hours of continued education? Like, that's all I heard today was these little theories, but no one's getting arrested. No one's going to jail. This entire system hasn't put anyone in jail. It's the families that have come together that put away the very few guardians that have been punished. The state of Nevada had an April Parks case where they locked up the guardian, her attorneys, and all her accomplices. I mean, we're Florida. We're the capital of retired people, and yet nothing's ever happened here. In my family's case, my stepfather had a $100 million estate, and the court-appointed attorney, who's also the registered agent for the same professional guardian, showed up to a mediation with a military assault rifle and was intimidating my mother and her lawyers. He sent letters to the judge saying he wanted to rewrite the entire will, changing all the trustees, beneficiaries, and guardians. The judge went along with it. This is Judge Stargo, whose wife is Kelly Stargo, which is a senator. I contacted the governor of Florida. The first thing he did was promote this judge to the appeals court. I contacted Anthony's office. I contacted the Office of Elder Affairs. I contacted the Florida Bar, the Inspector General. All of them buried this case. I contacted Colleen Burton. The very next day, the case gets closed from the Office of Elder Affairs. I mean, this isn't a task force. A task force does things. So the word force, you do things. This is more like scrapbooking. You're scrapping all these cases under the rug. You're not doing anything. You haven't in the last 20 years. I mean, you guys can talk about all these little theories and changing the law, but here's a law where a guy brought a gun to a mediation. A lawyer showed up at a mediation with an assault rifle and the Florida bar did nothing. The Florida bar did nothing against his conflicts of interest. The Florida bar did nothing about his secret meetings with my stepfather, changing the will with little handwritten notes. None of that happened. So my question is, what action are you going to take? Because I hear you guys talk the talk, but nobody's walking the walk. I mean, if you want to take action and send a message for this to stop, you need to start arresting these people and putting them behind bars. We're Florida. Why is the state of Nevada more proactive in putting these people in jail and you guys aren't? Can anyone here say that they single-handedly put a guardian in jail? Or was it always initiated by the families who had the money to hire the lawyers to even get the justice that they needed? My stepfather, like everyone's here, he was murdered. He was exploited. They took everything. This professional guardian had 3 different law firms representing her. Her name is Peggy DeVivo, and the court-appointed attorney, whose name is Keith Miller. They should be in jail.
Thank you, Mr. Gutierrez, for being with us. Lynn Saylor, you're now recognized. And after Lynn Saylor is Douglas Franks. Ms. Saylor.
Hi, everybody. Thank you for the opportunity to be here to speak to you. My mother suffered greatly financially, physically, mentally under several guardians, several judges, and it did not go well for our family. But aside from that, I do have a 4-year degree in business. I was a guardian ad litem. I was an ombudsman, and I took the 40-hour course hoping I could be my mother's guardian. To say that it's too expensive, parents pay for college, kids get student loans. It should be a degree that's worked on if they're planning on making $40 to $100 an hour. I mean, it's getting to where these families, their mother's a guardian, so she teaches her daughter how to be a guardian. They have the father's a guardian, and they're all driving from Palm Harbor to St. Pete, all 3 in the same day to see the same 3 different wards. And that's $300 just to drive for that family. I mean, that's training your child how to be a guardian. Let them go to school, get a degree. They're teaching them in a community center on weekends. What's that? I wouldn't go see a dental hygienist who learned how to be a dental hygienist in 40 hours. I mean, I wouldn't do that. I would go seek a professional, not a 40-hour course person who doesn't know what they're doing. Aside from that, the police department seems to have down how to record what is going on, how to keep track of people, how to do all this. Why don't we get police departments in charge of guardians, or have them train, have an academy for guardians? Let a chief or a sergeant take care of them, not an attorney. I mean, they put cameras on these guardians. Policemen don't make the money that these people are making. They're making it a second career. They're not making money. They can't afford it because they don't have any money. Do you really want to turn over hundreds and thousands of dollars to people that are taking a course and they can't pay for it? I mean, I don't think normal people want to do that. Thank you.
Thank you, Ms. Saylor. Douglas Franks, you're now recognized. And then after Mr. Franks, we have Mr. Saylor, Alan Saylor.
Good afternoon. My name is Doug Franks, and I'm speaking on behalf of Americans Against Abusive Probate Guardians and its founder, Dr. Sam Sugar, who could not be here today. Over 50 years, despite multiple task forces, dozens of legislative attempts, countless media exposures, numerous high-profile guardians arrested, and dozens of document cases of objective criminality, Florida's guardianship system remains very badly broken. And it's lucrative, and the corrupt cottage industry remains in full swing. While many guardianships function as they should, far too many are demonstrating abuse and results in the exact opposite of the legislative intent. Instead of being the last option, it's the first option in probate court. It wasn't my mom's and everyone in this room that's here, it was the first option. The current system must stand while the current system must not stand while the next innocent citizen is hustled into an unwanted civil rights limbo. Easy prey for court insiders and their insurmountable desire for other people's assets. Because our parents, our loved ones' money is not their money. It is the lawyers, it is the judges, it is all the, what's a good term for it? Stakeholders, but also friends of the court. Friends of the court. What a good term, friends of the court. People that make money off the court, off the loved ones. Guardianship, especially professional guardianships, make mockeries of advanced directives and decimate the entire estates that people have spent so much time to try to follow what their life in the ending was supposed to be like. It threatens end-of-life medical care plans. It threatens our homes, our assets, our families, and our health. And once initiated, the only way out is death. But the best news is it's death alone, by yourself. Who in the hell in here would like to die by themselves with no one there to give any type of love? I bet you nobody, except for maybe, well, I won't be derogatory, sorry. The legislators must now summon the courage and political will to either abolish it or finally fix this massive corrupted system. Florida-based Americans Against Abusive Probate Guardianships has over 115 families that subscribe to them. The legislators, the leadership, need to make it their goal to reform guardianship for the people of Florida and then for the people of the entire country to be able to see. The real stakeholders in all this are the current and future residents of the state of Florida. And one last thing, this is something for my good friend, Mary Bush, and this is so true. Your unalienable rights. These rights include life, liberty, and the pursuit of happiness. This essentially equality means that no one is born with that natural right to rule over others without their consent. And the government are here obligated to apply the law equally and to everyone. That's all I have to say. Hopefully there will be some change. Thank you.
Thank you, Mr. Franks, for being here. Alan Saylor, you're now recognized. Mr. Saylor.
Good afternoon. My name's Alan Saylor. I'm a business owner in Pinellas County. I took 2 days away from my business to be with you all today. Thank you for the opportunity to address you. I'd like to mention I'm not a guardian. I am not an attorney. I have no financial interest in any guardianship case going on. However, for the last 15 years, I've observed a number of guardianship cases here in Florida, and I have been shocked by the abuses I've seen. I heard a judge say in court, and this is a direct quote, "I will not second guess the guardian." I've heard guardians lie to judges in court. I heard a judge in court invalidating a mediated agreement that he had set up to go, stating that it was not as he has ordered. And I don't know about you, but my mouth was open, just shocked at hearing this type of behavior going on. But I would like to commend you guys for your work and you drawing up this list of issues that need to be addressed. And I hope that this can come into something that's beneficial and helpful to all the wards that are stuck in guardianship here in Florida. The data gathering statewide and county by county, I think is really, really important. No one can really tell me how big the guardianship industry is here in Florida. The one thing that I would suggest is that all guardian fees and attorney's fees be made public. I would like to hear a valid argument for someone saying that that would be detrimental to a ward. The other thing that I think is somewhat interesting, I have not heard of the Florida Bar or the Florida Guardianship Association taking any actions to do something against the bad actors that are in their industry, taking advantage of our elderly and disabled here in Florida. And I don't know if they think that they're all perfect people, but I assume they're just like the rest of us. There's a certain percentage that are not good people, and they take advantage of a system that allows them to do that. The other thing that I find very interesting is when I hear a guardian refer to their ward as a client. I think that really implies that the ward sought out this guardian, agreed to pay him, and go for all of those things underneath there. So I think they really should be referred to as wards, not clients or even patients, as one guardian referred to them. So thank you for everything that you do. I hope this comes to fruition, and anything that there's a number of us out here want to see some major improvements, and we certainly want to help you all move this forward. Thank you.
Thank you, Mr. Saylor. And now we have Christine Montani. Hope I said your name right. And Christine is going to win the award for furthest away. She's from Huntington, New York. So you're now recognized.
Thank you. Thank you for giving me the opportunity to speak today. My name is Christine Montanti. I am the owner of a New York-based public relations firm. I'm senior editor of a luxury publication for the Hamptons, and I write and report for New York TV News. 3 years ago, I would have never dreamed I'd be standing here in front of you sharing my most painful and personal story about my mother, Carolyn. But by sharing her story, I can shed light on the national crisis affecting my mother and countless others by unveiling the truth about guardianship abuse. During my 3-year-long grueling, excruciating, grueling process advocating for my mother's rights in Broward County, Florida, my efforts were repeatedly thwarted by 3 individuals appointed by the very judge entrusted to protect my mother's interests, but instead were engaging in abuse by keeping her locked up and isolated. When confronted, these individuals proclaimed their innocence and heroism and blamed any individual who protested their abusive actions. What's heartbreaking about my mother's story is she was kept in a jail-like atmosphere in 2 different assisted living facilities. She was denied communication and access to the outside world. She was blocked from her entire family, friends, and only grandchild. She was not allowed to go outside of her facility while other residents could. She was not even allowed on her balcony. It was nailed down. She was denied access to receive letters, telephone calls, mail, food delivery, or any other kind of communication. What's even more heartbreaking is she was forced to spend every holiday alone for the past year. Even her birthday, she spent in complete isolation. Virtually all of her personal property was taken away from her. Her clothing, her shoes, her dishes, her stove was removed, her telephone was removed, her photographs were removed, her wallet, her pocketbook, and her money. Prisoners have more rights than my mother. As I continue to encounter roadblocks along the way, fighting for my mother in Broward County Court, I was connected with countless others who shared the same strikingly similar horror stories. And when I spoke with countless law enforcement agents, nurses, doctors, care facilities, I found out this conduct was common practice. Many aging adults come to Florida because of its weather and because of its natural beauty, and they bring their wealth here too. And that wealth has made Florida's economy flourish. My parents and grandparents brought their wealth here. I'm asking Florida to take the lead and to correct the systematic corruption and injustices that affect so many senior citizens. I'm hoping that you will set the precedence for the rest of this nation. Thank you.
Thank you, Ms. Montani, for being here and for your comments. Karen Turk, you're now recognized, and that's our final public comment during this period. Ms. Turk, you're recognized.
Thank you, Mr. Burke. I just want to address everybody on this task force and let you know that it's really been interesting to watch the last few months on about how this was going to play out I wanted to be really optimistic, and I told all of you that the first time that I spoke to you. And I want to definitely recognize Hillary Hogue and say thank you very much for being up here representing families, because too often these family stories get swept under the rug. And we do have a systematic problem. And the systematic problem is not perpetuated by guardians themselves. And a lot of the articles that we see come out and a lot of the press that we've gotten is about reforming guardians. Until we attack the problem of illegal, predatory actions in the state of Florida, we are going to have a very big issue. And many of you represent counties here that are plagued with problems. And overall, there's a real lack of transparency. And Anthony, you and I connected after the last meeting, and I called you out and said that, when I was looking for help with my mother, that I really couldn't find any in Palm Beach County. And we spoke, and a lot of the things that we spoke about, I felt that were really heartfelt on your part about wanting to audit the system. But the reality is that until we have transparency, we can't have that. I put in a public records request. I was pretty specific about what I wanted because I know what there is, and I know what evidence there is that shows that this fraud is being perpetuated. Yet my public records request has not been responded to. Meanwhile, I have other journalists that have submitted public records requests, and those requests have been denied. And those requests, too, were strikingly specific in what they asked for. And it's hard to believe, as a logical human being standing before all of you today, that I can't put in a public records request and cite a name and have the clerk's office go ahead and look up that name and give me the records going along with that, whether they be public complaints, emails back and forth, or perhaps in this case, Anthony, a complaint that I know that you wrote to the Florida bar. Those Florida bar complaints, these complaints against lawyers, are the #1 thing that needs to be attacked. Until we take the belly out of this beast, we're going to continue to have a problem. And it's a problem where lawyers thrive in a competitive environment where they're allowed to profit big time. And until we take that out, this problem's never going to change. And I hope that all of you are committed to looking at your colleagues, the people sitting next to you, because many of you on this task force represent those people. You represent those people. You represent the legal community, and the legal community must be dealt with. So let's not turn a blind eye and think this is all about the guardians. Let's make sure we take out the corruption where it lives. And that's in our legalized human trafficking system that strips people's rights, their constitutional rights, and takes away their freedoms. Thank you very much.
Thank you, Ms. Turk, for being with us today and for your comments. Task force members, we have several items. We have the professional guardian tracking, the goal of the report, supportive decision-making, awards right and enforcement, court monitors, and the healthcare pipeline. And that healthcare is the most broad term, including all those types of facilities. Which one do we want to handle next?
The pipeline sounds good.
Pipeline, let's do that one. Okay.
Before we do, I just want to say quick, I really wanted to point out and thank the speakers for making their points in the time limit they were given. I don't usually see that. That was very well done.
Thank you, guys.
And for making the effort to be here. I mean, they come from all over, I was going to say all over the state, but beyond the state to be here. So very commendable that they're here, and we appreciate their attendance. And thanks, Mike, for pointing that out. Very appropriate. Let's talk about the healthcare pipeline, because I hope there's smarter people in the room who can figure out how do we solve this issue, because obviously this was, and JD, maybe you can give us a very brief synopsis of what your investigation revealed with the particular case in Orange County where it seemed like there was.
Well, I think from a high level, without getting into the details of it, it has to do with the relationships between different industries that support one another in relation to services they're providing to the ward. Our investigation pointed out a specific incident where there were bad actors working in conjunction with one another to provide a service that if, and I'll try to put it this way, if
And JD,
they were looking out for
I don't want you to name the actors, but name the type of entity so we could follow back.
So assisted living facilities that work with specific guardians, that have a business relationship with a specific guardian, which entails putting a ward in that assisted living facility. There's also relationships with the hospitals who are obviously trying to get a high-cost patient out of an ICU bed or a high-cost bed. And so they have relationships with guardians that will come in and create a guardianship case to so that they can remove that individual from the hospital to put them in an assisted living facility. Now granted, that's a systematic problem in relation to the healthcare system that's obviously way bigger than what we are, but the issue is not the process so much it is the bad actors and the oversight of the ones who would take advantage of a system that exists. In the example of having a hospital have a relationship with a guardian, and so they employ or they have a relationship with that guardian to move a high cost patient out of a bed to another facility. Obviously, I don't know that we can figure out how to fix that. Some of that is legitimate. The system doesn't want a high cost patient in an ICU bed that could be in a much less restrictive and or less costly situation. However, the problem in the cases that we dealt with are the relationships that weren't disclosed. We didn't have the data to know that there was relationships. The court certainly didn't know that there was relationships that were involved. So the data, the understanding of how people relate to each other. So the system of having relationships is not the problem. I think we heard just a minute ago, the transparency is really the issue, and the knowledge of the court and the folks who are tasked with reviewing and having an oversight role. And so I probably went down a long way with that, but I don't want to attack the specific relationships as much as how do we solve for bad actors? Because I think what we heard at the podium was examples of perceived bad actors, not of a system. You want to blow the system up to solve the bad actors. I say let's solve the bad actors. And the way you do that is through transparency, is through having the people who are tasked with having oversight, having the tools available to do that. And so the pipeline is more, how do we make it so that it's transparent so the court knows certainly that there is a relationship there, it's disclosed. I think one of the ideas in the recommendations from Tom are each individual participant has to explain or tell what your potential conflict is, I guess. And so if you're a guardian that is decided to work with a hospital to provide a service or move a ward to an assisted living facility, having that disclosed to the court, having the relationship disclosed to the court, having the payments, all of that thing, is when it's disclosed and you put sunlight on it, it solves a lot of those problems, as opposed to let's blow it up and create unintended problems that we're not going to know about for years down the road. So, sorry, talked a long time, but
yeah, that's excellent. Hold on, I've got a list of people I saw with their hands up, so we're going this order: Tamara, Karen, Hillary, Sancha.
So I'm going to agree with what you just said. I think that you can't take healthcare in general and isolate it as a component and say that it can't initiate guardianships. I agree with the transparency and the laws that just recently changed that require guardians to, on the record, be very upfront about where they've received any third-party reimbursement from, and that is a requirement now, and I think that's good, and it should be disclosed. I wholeheartedly agree with that. My wanting to make the comment is, I just want everyone to know that in healthcare, whether it's the hospitals, nursing homes, or assisted living facilities, the Agency for Healthcare Administration does monitor them. And when they come in, they are responsible for identifying if someone is incompetent or unable to give informed consent regarding their health care. They are charged with making sure that there is someone to give informed consent. They can't be doing treatments without informed consent. So the idea of taking healthcare providers out of the world of referring for guardianship is not realistic. I definitely think that being upfront and transparent about, if this person's indigent and they're willing to pay for the attorney fees and filing fees and so forth to establish the guardianship, that should be transparent and be on the record. I just wanted to kind of share the
the realization of that is a lot of times where someone has had some kind of traumatic event and they are not able to give informed consent anymore. And maybe the parties surrounding them in their life aren't willing to step into that role. So I don't think we can realistically take that industry out of being realistically referrals for guardianship.
Tamara, I'm going to take chairman's prerogative and ask you a question about something you said. You mentioned that there's now a requirement for these conflicts to be reported. What is the penalty for not? Is it a criminal or civil fine penalty? What are the penalties for not complying with these requirements?
That's interesting. I don't know the answer to that question, but I know that if you follow the statute, the questions that you ask the proposed guardian are specifically those very questions, and they have to answer it, and it has to be documented in the pleading and in testimony. Not answering it, I'm not sure what the answer to that is.
It's sworn. It's sworn. It's sworn, so.
Correct.
If you're, yeah.
It's sworn testimony within affidavits, so there could be a criminal allegation, and now that that's statutorily required, if somebody affirmatively leaves something out or tries to mislead the court, that could be.
Is that a misdemeanor?
Actually, it could be a felony. I mean, it depends on a lot of context here, but it could be a felony offense. But there isn't necessarily a prescribed disciplinary measure or way that this is penalized.
That's a problem with some of this. It may be in statute, but if there's no penalty or enforcement of it that's punitive, then is it really effective? But go on, Karen, you're next in line.
Thank
And then
you.
Hillary, and then Sandra.
Back
I'm
on
gonna get this right, Sandra. Eventually.
back on I want to compliment the
Okay, Ben's going to stop it here.
Everyone can please take your seats.
Yeah.
We're just gonna leave it open-ended, got it.
Okay, let me remind. There seems to be a lot of feedback right now. Is that, or a lot of echo?
No.
Patrick, would you let her know that there's, the system maybe needs to be adjusted somewhat?
But I do sometimes feel like that's what I'm doing. Love boundaries.
Testing 1, 2, 3. I think
Like-
that's a little bit better now. Patrick, does that sound clear to you?
I know. I like honestly like
Okay.
when I like really thought about that concept.
Okay, folks, we're going to reconvene the meeting. I want to point out, since you probably lost your track of thought as far as who was scheduled to speak. Karen's speaking first, and then Hillary, you're speaking next. Sanchez next, and then Zane. So. Okay, well, this is our new bailiff. He's learned this from his many years in court.
Everybody listens to a judge.
You didn't say God save this honorable court or anything there, too. Go ahead, Karen.
So I'd like to first commend JD for going off the cuff with the explanation of the healthcare pipeline. I actually pulled up and I provided to the task force members an article that our prior presenters and experts at our August 19th meeting, Erica Wood and Sally Hermy, that they both recommended. It's entitled "The Use and Misuse of Guardianship by Hospitals and Nursing Homes" by Allison Herschel and Lori Smetanka. And I think it gives a very good breakdown of why the motivations and problems exist, as well as some proposed solutions. I'm not necessarily advocating for saying that this is the way we should go, but rather than reinventing the wheel, I do think that we as a task force should consider this, because it goes through, and if you will permit me, Mr. Chair, I'll give you a very brief overview of what it goes through. The hospital incentives for initiating guardianship, as JD mentioned, is to free up a bed for patients that have more acute needs. Also to free up a bed and get somebody out of the hospital, because Medicaid and other insurance providers only cover a certain period of time, and then it becomes cost ineffective for the patient to stay in the hospital. They also look at the fear of negative consequences or liability in releasing somebody too soon without having a guardian or somebody who is going to be responsible for that person's care. So all of those things kind of culminate and come together. Also,
making sure that the hospital or the facility gets paid. So it's not just informed consent for care, it's also who's going to say that this person is going to get paid? How are we going to get approval for this person to get Medicaid benefits or what have you? So finding a guardian has been the most cost-effective way for the hospitals and assisted living facilities to solve and address these problems. The paper also goes into some solutions to consider problems that may not be as apparent beyond just the conflict of interest. And we do know that there's an issue when the hospital or the facility is proposing a guardianship and they're simultaneously selecting the guardian who is going to be proposed and put in the position over that ward or individual. There's a conflict of interest that's inherent there. The conflict of interest as to the doctor who's making the initial assessment of incapacity so that that emergency temporary guardianship, which is the process that unfortunately just gets used and abused by the facilities and hospitals because it's the most time efficient way to do it. Those doctors are from the facility or the hospital where it's paying the same process. So we don't have objective neutral parties that are necessarily initiating it. And I don't mean to suggest that all of these ETGs are done with any kind of malicious intent. It's just with the volume of patients and the care, this is a need that the facilities need to address. But one of the issues that's mentioned in this paper too, especially for hospitals or for anybody who has undergone emergent care, there is a temporary incapacity that very frequently occurs and corresponds to things like a UTI. We know that the infection causes temporary incapacity. And if we're using that time frame for the basis of requesting an emergency temporary guardianship, a guardianship is established, the rights are removed from that person, and we're saying they're incapacitated based off of that small time frame, as opposed to allowing them to improve first. And that's one type of example, but there's a litany of examples that are mentioned in here as to how that temporary incapacity, or I believe an expert that I listened to yesterday referred to it as transient capacity. Those issues are really not addressed by or helped when we have an emergency temporary guardianship that is the first knee-jerk reaction. So the paper proposes identifying a surrogate for admission and transfer and discharge in order to a person who is designated to address the immediate needs of this individual and to help the hospital or facility so that it's not all on the hospital or facility. That person is the one giving the informed consent. That person is the one who's deciding what facility this person is going to be transferred into for the benefit of that person, not do we have a mutually financial beneficial relationship. And they have a method, and they point to other states that have established these temporary surrogates, if you will, medical surrogates. And I know that
Is it almost like an enhanced guardian ad litem?
in a sense, I guess, but it's a very temporary basis to serve the immediate needs
Triage it.
for this individual who's temporarily incapacitated, and allows a little bit more time before we have the courts take total control over assets and all of these things. And Shannon mentioned in one of our prior meetings, the medical proxy statute 765.401. It actually provides a pretty decent enumerated list of all of the different individuals who can give consent or can stand in and provide, whatever decision-making authority needs to happen in an emergency situation. And those are not necessarily being exhausted before hospitals and facilities are turning to requesting emergency temporary guardianship. So I would encourage you to go through the paper. I tried giving the best overview I could. I think I've hit most of the major suggestions by that paper. They also suggest the establishment of a guardianship ombudsman program. And it's something that the task force should consider.
Thank you, Karen. Hillary?
hospitals, they source out to a law firm. In Pinellas, there are at least 2 filed a month, and they use specific guardians, one of which is Sarah Fuentes, and she lives in Polk County. And on the petition, the attorney who's outsourced and only does guardianship, he only uses Sarah Fuentes. He said that he's looked up far and wide and he could find no other guardian who would take this case. Obvious Pinellas has lots and lots of guardians, but to me, what is glaring, as an attorney would say, that the hospital says if no funds are located, and most of the hospital guardianships are either indigent people or, just as Karen said, people who are late on their bills, and instead of doing some sort of Medicaid planning, they file a guardianship. It says if no funds are located, Baycare Hospital will provide compensation to the guardian, Sarah Fuentes, at her hourly rate, which is $75 an hour. Don't forget, she lives an hour away, so that right away she's making $150 that they will pay her for the lifetime of the guardianship. And a good number of these guardianship cases are dealing with members of our community who are in their 50s and 60s. So again, here I go. What chance, if we're not dealing with an honest guardian, that person doesn't have a chance really of getting their rights restored. And it is just, it's just something, it is of course liability and to clear a bed. And there are lots of family members who haven't been noticed, and they are begging to become, and Ken, you know this, they are begging to become their loved one's guardian, who is in a guardianship that was petitioned from a hospital in the community, full background, worked for the police department, and they're not being allowed to, can't speak to their loved one in their native tongue, no visitation, and there's got to be more done that these hospital guardianships aren't happening as much as they are. So I'll stop to let my fellow task force member, I believe Zane, speak.
Sandra first.
Thank you.
Mine was actually a question, and okay. I spoke with JD during our little break, but I think maybe the question is better for Anthony Palmieri, because JD has already explained to me his answer for it. But I was curious to know, since the law changed to require the guardians to disclose all income that they receive from whatever source in their annual reports, which is a relatively recent change, have you noticed any difference in your investigations? No, it's still a problem. Still a problem. Okay.
I'll try to be brief. Karen took a lot of no, thank you, Karen. So I would second everything that she said. And based on what she said, I would strongly encourage that paper be included in the appendix of the report. So when this is presented to lawmakers, they have access to understand the problem. 2 other things just for
Zane, done on that point.
So what?
We will do that.
Okay, thank you. 2 kind of points of interest from AARP's perspective and our knowledge. Nursing home level of care is far more costly than in-home care. So if an individual has access to a home, whether it be their own or with a loved one, just remember that nursing homes cost way more. But of course, Medicare and Medicaid does not reimburse for in-home health care like it does a nursing home level of care. So just understanding that there is a possible motive as to why some of these groups, owner operators of nursing homes and or hospital systems, may have some sort of scheme to keep people in the cycle for monetary value. The second thing is, it's also important when related to the nursing home industry that there's not just local nursing homes. And a lot of people don't understand that national nursing home owner and operators operate in multiple states. And so there's almost 2 sides of the nursing home here, just like assisted living facility. So you've got the national owner operators versus state level. And so it's just important to keep that in mind when we talk about the long-term care industry, that we're talking about giants all the way down to the small individual owners of these facilities.
Zane, let me ask you, does AARP have a position on how to solve this issue through statutory, I mean, there has been a suggestion of ombudsman, there's been different, does AARP have a solution?
Well, I don't think we have any one, solution. I think it's a series of fixes that should be made and that should be considered. We operate in all 50 states, right? And at the federal level. So AARP definitely has a task when it comes to the individual states versus a federal level guardianship system. I think it's something that if the task force desired, we could put together what our recommendations as just AARP and our experience would support with the task force. I mean, that's something we could do as an addition, but we don't have the silver bullet, if you want to call it that.
And that, I think that's the problem. When JD first, talked about what happened in his investigation, his office's investigation in Orange County, this is the problem. There's a legitimate reason for this to happen, and then there's a for-profit reason for this to happen. And how do we, make the correct thing happen while at the same time, limiting the profit motive part of it? And that's a very tricky, I don't think anyone here really has a solution to that problem. And I don't think this is going to be something, with our limited scope here as a task force without tremendous resources and research people to come up with a solution. Because, usually most of us, because we have this topic's of interest to us, and we may have some ego too, that we say, gosh, I have the answer to that. On this one, it's a harder one to say, gosh, I have the answer and I'm going to fight for this solution, because it's a very difficult one to achieve. And so, I have no idea where I'm going with this, other than say, this may be something we have to hand off to the next task force or this permanent committee to say, this is really a problem that needs, as Jose mentioned, maybe the next group will have some type of committee structure where this is going to have to be delve into the details and really come up with a series of fixes. That's the word I think you used to kind of make this problem at least manageable and solvable. We'll go to Sancha and then go to Tamara.
I just had a question for clarification. I may have misunderstood. Did you say that, Zane, that nursing home care is more expensive than in-home care?
Yes, and I'm happy to provide the committee or the task force with information that we've compiled through researching industry standards, costs, Medicaid reimbursements, Medicare reimbursements, home and community-based services reimbursements, and it all gets into even a bigger web in Florida with wait lists, people waiting to get these services. So we're walking into another spider web. But to put it bluntly, nursing home level of care is far more costly, not for the individual, right? It's costly they get more money for nursing home level of care versus someone who chooses to stay in their home.
Okay, so you're not talking about like someone who has nurses coming in to care for them in their home, because my experience is extremely costly.
Yeah.
Okay.
Thanks for that clarification. I was intrigued by that comment too. Tamara?
So I would just suggest that the entity that's not at the table that should be a representative from maybe risk management or utilization management within the hospital system that can discuss what their internal measures are for requiring them to go through the exhausting the proxy and then going to guardianship. I think that someone from that either physician role or someone within risk management probably needs to be at the table so that there's a clear understanding what happens on that side and how they get there.
Thank you. Anthony.
Just trying to build this to consensus. I think we recognize that there is a guardianship pipeline with the hospitals. I think there's a need by the hospitals. So if we could just make the recommendation, the task force recommendation to look at to examine putting independence and checks and balances into the process. I think that's the direction that we should go in. And those checks and balances may take different forms and in different statutes. But we need to put independence into the process. And that's the direction.
Karen, and then Shannon, please.
echoing Anthony's point, trying to bring this to a head, I do think that first, there are a couple of small suggestions and quick fixes that actually I think we've discussed even in our time waiting for those microphones to be fixed, such as making sure that the hospital or moving entity, petitioning entity for guardianship is not also recommending the guardian that's going to be appointed, who then is deciding all of the medical decisions thereafter. But also, I think as a task force, it might be more simply put for us to state that we would like the legislature to create a different process specifically for the healthcare industry that does not include emergency temporary guardianships to address this issue, because that really is, there does need to be a system, but this is not the one.
Shannon.
And I want to dive into that a little bit, because what I'm hearing is the hospital comes into guardianship court and says, this person needs a guardian, and then handpicks their guardian that's on the payroll. And what I'm hearing from the clerks is that that has not been disclosed as required under the changes to the 2018 law, or you're not seeing it. Potentially.
We don't have enough.
It may or may not be disclosed, but as soon as that check is written to the guardian, the person's not independent regardless on who discloses what.
Right. So maybe what we also add to our suggested fixes here is that, number one, they can't pick the guardian. And then number two, they must consider alternatives such as medical proxy statute. Maybe we add in consideration of the Waynes County, Michigan Ombudsman program. It's online. They already have a hospital ombudsman program. We have a fantastic ombudsman program under a new Michael Phillips is amazing in the state of Florida. How much would it be for us to incorporate that? Now, it's not going to be lawyers.
Shannon, talk more about that. Which entity has it?
The long-term care ombudsman program that works in facilities is so good. The people are amazing. I can tell you that I have in the last year used them during the pandemic, and the ombudsman has been on it, even though a lot of them are volunteers, and they're very well trained. They're very well, at least it's been my experience. What would it take to take that to hospital level? I don't know, but I definitely think this could be a potential resource, and especially because there's not a lot of cost incurred with that. But then the other thing that I'm hearing is this auditing of the disclosure, right? Because we know that there's a new law in play right now that requires disclosure by guardians. And we have OPPG doing a great job, but maybe what we need to do is just get some entity to audit the healthcare facilities across Florida and see, are they paying guardians? Are they paying guardians? And if they are, has it been disclosed to the court as required under the 2018 law? I mean, how hard would that be for us to find out from the hospital? Maybe we could just ask Florida Hospital Association or Florida Healthcare Association, not Florida Healthcare Association. Who would it be that we would ask? Somebody.
Yeah.
And we just say,
somebody's got regulatory roles. I would think if we approach it in terms that we're not. We
Yeah.
understand they have a problem they're trying to solve.
Office of Healthcare Administration.
I would think that they would want to help us.
right. And we could just ask everybody to provide us with do you have any professional guardians that you pay on a regular basis or a 1099 consultant? We've got our answers. And then we can match it with our guardian disclosures and see if in fact there are professional guardians in these conflicted roles. And I mean, I just can see that might solve this problem.
I mean, with my experiences, it wouldn't be hard for the most part. So I ride mainly in Pinellas County. Pinellas County, I can tell you exactly who their in-house guardians are. Chris Scalzi, Eugene Chiesler, and now Sarah Fuentes. The three that I know. So, I mean, that would be something that would be more than just, on a small term to see who they are. And I mean, in your county and you can find out who every week, the petitions that are being filed, and you can see who's filing it, by I'm Jane Smith on behalf of, Baycare Hospital. And they usually do. They always pick the same guardians, and that's usually who they work with.
Zane?
Just a real quick point of order and managing expectations on ACA, and this is not disparaging toward ACA at all. But from our experience in dealing with other issues as it relates to either nursing home or assisted living facilities, they may have very little data in terms of what the workforce, or in other words, contract employees or on-staff employees, what that makeup looks like. We just saw that yesterday at a committee hearing where they admitted they had nothing on a certain new position in nursing homes. Didn't know after 17 months how many nursing homes were using a certain position, what they have been doing since new legislation passed last year. So I just say that to say ACA may not have that data. So I don't think we can depend on that.
Sandra?
This is a spider web.
It is.
And this goes beyond anything I think that we can do here, but this may deserve its own task force. Just this topic, I'm not kidding. Because there are people that ought to be at this table helping to make these decisions and fleshing out some of the things that you raised. I mean, they're all I don't know enough about this issue, and I've seen it, but it's a quagmire for sure, but I think it is worthy of further investigation.
And Karen did propose certain modifications can be done, but even, I feel a little bit even reluctant to do those without all the stakeholders in the room to talk about. And they seem so logical, but I don't know what's the downside or where's the conflicts, but I'm not sure how we move forward with this particular topic other than to say this is a problem. The problem should be acknowledged that this is a problem, and there needs to be work done on a solution to this problem. I mean, I think it would be hard for us to go any further on that at this time. That's just my personal.
And how do you decipher, I think I've mentioned it in prior meetings, I've seen attorneys and or guardians, more so guardians get paid $10,000 just for the hospital guardianship. How do you decipher whether they've gotten it or not? And then you think of HIPAA, if that gets involved, because it's a hospital. So yeah, I do agree with Sanjay that there really needs to be a lot looked into with hospital / nursing home / ALF guardianships.
I agree with all of these points. I agree that this is a quagmire. I do think that there were two very easy solutions that shouldn't rock the boat that we could also propose. And
Let's hear those and we'll see if the group.
that the healthcare professional or, representative of the healthcare entity cannot pick or propose the guardian. So that if it's a professional guardian, they're not handpicking the person who's going to be in charge of the ward's assets.
I see a lot of hands. Okay, head shaking. So we'll put that as part. Go ahead.
And that the healthcare facilities should be required to show that they've exhausted or considered all alternatives to guardianship.
And that seems like a logical one.
Mhm.
Do you agree with those? Sanjay?
Yeah, that's.
Mike.
I guess
Mike?
one issue concern, not knowing much of anything about this, is who then does pick the guardian and how long does that take? And if it's taking even a couple of days, that could be a problem.
The court would select the guardian as they are supposed to be doing
do.
already.
Yeah.
It's just now they're not going to have somebody handpicked already to pick.
Yeah. I can say I have some circumstances where it picks me, but nobody tells me for a week.
Well, you usually,
Hold on. Let me just do the recognition. Sanjay, you're, and then Hillary.
I'm sort of hemming and hawing over here in my own brain, trying to figure out just how that would progress. Would it be the risk management department of the hospital? And are they then going to provide an affidavit that they've tried to find? Because normally the situation wouldn't occur if those people that are named in the statute, the spouse, the children, if those people were known and available, it wouldn't be a problem. So I'm not really sure how we get to that. I don't disagree that that may be necessary. I'm just not sure that we get there, because if we had those people, then we wouldn't have the problem.
But Sancha, under the medical proxy statute, you can go all the way down, friend, and then you can go to hospital social worker that isn't employed by that hospital, switching to another one.
We're talking about the healthcare surrogate.
Talking about medical proxy statute.
Okay.
Under 765.
Okay.
So that, I agree, we don't use that enough, the medical proxy statute for medical decision-making. Now, of course, that's not going to apply placement from one facility to another facility. It's not going to apply to getting the medical bills paid. But if there is some alternative that's less than guardianship, then I think using the options of medical, if they're coming into court and saying, we don't have anyone to make medical decisions, and that's what they're saying they need an emergency temporary guardianship for, and we have the the medical proxy statute will apply. If the only thing they're coming for is medical decision-making, then, the medical proxy statute will always be an option that's less restrictive than guardianship.
Hillary's recognized next, than Gina, but Shannon, to your point too, and former judge can weigh in also if he wishes, but obviously if this was more emphasized, that would be a question too that every judge would be asking before that temporary guardianship. Has this part of the statute been exhausted first, and make assurance to me that it has, so that the next step isn't taken? Hillary and then Gina.
I think I'll just say, please move on to Gina. I think I've said enough about this topic. Thank you.
Gina, you're recognized.
Hi, I was just saying, I hear about this quite a bit. And one of the recommendations I make to the facility is to go through the public guardian entity in their area. If the person is indigent, which most of the time they are, and there's nobody else that is able to speak up, in my experience, the hospital has usually done some pretty good due diligence looking for anybody. As a public guardian in the past, and from a public guardian aspect, if somebody calls with a referral, my first couple questions are, well, is their family, who's involved with this person? How did they end up in the hospital for months on end? If somebody did end up in the hospital for months on end and they actually have assets, perhaps then the public guardian could make a referral. Otherwise, a lot of times these cases are appropriate. I have not been in a situation like you described. In the cases where I've been asked by a hospital to serve as guardian, I've disclosed that to the court, and it's because somebody was in the hospital for close to a year who did not need to be. Hospitals can occasionally be reluctant to use that social worker element when they're applying for benefits and looking for the appropriate care for somebody. But to me, going through the public guardian is always an option, because the hospital is then not picking and choosing who they're having. They're going to an entity in the state who can direct them either to a private guardian, if that's what the situation warrants, or they perhaps can become within the program of the public guardian in the jurisdiction. And so when I get those calls, that's how I refer them.
Thank you, Gina. Hillary, let me see if I could just bring this to conclusion. We had some wording that talked about this topic, and we had two what we considered potential solutions that start the process. No way do we think that's the ultimate solution, and it seemed to be consensus on those points. So I think Tom has enough to go on there, and that's a positive recommendation on a big issue. We have some big topics. We don't have much time left, and I want to make sure we hit some of these, okay? Supportive decision-making is one that is down here. That last one is, I don't think we're asking for a lot of legislative action on that, other than those 2 points there. So where do we rank that? Like a 4 or 3? What's that?
I would say 4 or 5.
Okay, how about 4, folks? We'll put that as a 4. 4, okay. I mean, it's a big issue. I'm just saying, as far as our ability to get something done on the issue with the legislature, that's where I'm kind of putting it. Yep, plus the. Okay, so we have supportive decision-making. We have the ward's right and enforcement, court monitor, and goal of the report, and professional guardianship tracking. And it's 2:38. We're supposed to go to 3, but I think we're obviously going to go past our time. I know someone has to leave before 3. So what topic next, Anthony?
May I add one to the consideration?
It's not the direction we're supposed to go on.
Setting aside advanced directives.
Okay.
Love it.
Okay.
Mr. Burke, if I could, I think the next topic, if we could, is the supportive decision-making one, is if everyone's okay with that.
Let's go with it. Kick us off, please.
My pleasure, my expertise. So supportive decision-making is a least restrictive options to guardianship. And as we said, in the guardianship system, there's a lot of cracks. A fear, but supported decision-making is a alternative to just throwing someone in a full guardianship, which basically would include like a lot of the medical aspects. You can have a healthcare surrogate. You can have a healthcare surrogate, you can have a representative payee, you can have all kinds of supports along with whatever supports that you have in place. But it also involves the person that was in the guardianship to let them make the ultimate decision. And there are some other least restrictive options. Like me, I'm the first person in the whole entire state that has supported decision-making in the state of Florida. Viviana, if you have anything you want to add, or if I missed anything.
You never miss anything. You always do the best job of explaining it. It's a pretty intuitive concept. If you've ever asked someone for advice, you use supported decision-making. And part of the effort that Mike and I have been working on, along with other people who are directly impacted and disability advocacy organizations, is on trying to get language in the Florida statute that states that judges should consider supported decision-making before appointing a guardian. So as you all know, right now, 744 does require consideration of less restrictive alternatives, but it doesn't say what specifically. So judges are kind of left to wonder, well, what does this really mean? Obviously, powers of attorney have been used often, but there's no real guidance about what else. And that step is often sort of like a check. Oh, well, there's nothing else. So we would really love it that supported decision-making be defined, explained how it works, and that judges be required to consider it. So that would be my recommendation for this task force, that we ask the Florida legislature to consider supported decision-making and adding guidance in the statute about how that would work and requiring judges to consider it.
And just real quick, and we do have a coalition in Florida right now, which is called I Decide, which me and Viviana are both the co-chairs of the coalition. And right now we're trying to get a bill into legislation that would be able to get passed and hopefully go through the committees that it would be assigned.
So that's a nice place where we were talking about the need for language. The language is out there. It was introduced last session. And so if we just give a recommendation that is broad about, we like this concept, it's been passed in 16 states and Washington, D.C., it's growing. We would like the legislator to consider it. That could be something that we can all agree on.
Okay, conversation on this point. Sancha?
Thank you.
Shannon, and next?
I think, this is already being presented. This is already in the works. I think Representative Tant is working on this issue.
Which representative, I'm sorry?
Tant is my understanding. I think this is outside of guardianship. This is before you consider guardianship.
No.
No. Well, I think it is. The guardianship is not for somebody who can be assisted with supported decision-making. So I think what we've kind of come to is that guardianships are supposed to be the last resort. This is a small faction of our, of the residents of Florida should, so this is something that is absolutely an alternative. It should be considered, but I don't think it's part of the guardianship law because that comes only if this isn't working.
This is
Michael, hold on, please. We're going to do things in order here. It's Shannon, Anthony, then Michael.
So I reviewed the bill last year, which I think was proposed. Is it the same proposal this year that was from last year?
No, we've made some, so what I'll say is that our coalition, we've been having a lot of conversations, including with the reptiles and elder law section that had some good feedback to share.
Yeah.
And so we're making changes based on that. I mean, it's important that we consider what everyone's thinking, and there were some good additions that I hope will make it into any new bill this year. So
I think that process is a good one, that we should let that process continue, because I think that supported decision-making bill from last year had opportunities for exploitation that were of concern to my section. And so I love supported decision-making, but it has to be in the right format, and we have to balance exploitation potential with independence. And so I would love that to be massaged and done, but I just don't think we have the bandwidth to do that. And it sounds like there's a process happening that's addressing some of those issues.
Thank you, Shannon. It's going to be Anthony, Michael, and then Sean. We have you recognized after Michael. And then Gina?
Yeah.
Okay, then Gina after Sean. Go ahead.
Yeah, I really think this task force can set the North Star that we should move towards supported decision-making. I'm supportive of it. I think there's some in the legal community that don't understand it because many, put this superficial line in the sand of, that this is the line of the sand of incapacity, when there's really no medical definition of what, legal incapacity is. So I'm supportive of moving that line wherever this committee, wherever the emphasis is for this task force, and using supported decision-making to move that very subjective line for, to give people as much autonomy and the ability to exercise their rights as possible.
Michael?
So, and you are correct about it being outside the scope of guardianship, but here's where we have a major issue. Judges in the state of Florida are not looking at least restrictive options before they put people in guardianship. Yes, some judges, but which is where one of the major cracks is in the state. Okay, this is something that really needs to be looked at as a task force and as a task force for the guardianship, because this is not something that should just be underlooked at or like, oh, okay, it's out of the scope or whatever. This is something that really needs to be addressed, because let's just put it this way, and I'm gonna use some of my story. If this was looked at before I was placed in a guardianship, I would have never been placed in a guardianship. They would have let this be an option before they threw me in a guardianship. Okay? Judges are not even required to look at least restrictives. There's other least restrictives like guardian advocacy, POA. So
judges are now required to look at less restrictive alternatives and explain why in their orders they do not. So there's that has been a good movement towards that. So
Sean, you're recognized, then Gina, then JD. Oh, JD's.
Thank you. I am very supportive of the idea of supportive decision-making and anything that we could do to, or ask the legislature to do, that would help people be able to access that prior to ever filing a guardianship petition or a capacity petition. But I also wanted to point out that just in July of this year, a new law went into effect relating to elder care and coordination. And when Judge Morley was associated in some fashion with the task force, I thought for sure we would hear a presentation on that, because there was a pilot project and it's an alternative dispute resolution matter used in these cases that helps the families come together and focus on the elder and find possible solutions to avoid even the guardianship going forward. So the court can now, based on the new law, order parties to elder care and coordination. The problem with that is that at present, it deals with elderly defined as of a certain age. And as we know, that we have individuals that need assistance and would benefit from this that would be under 60 years old. I think that's the age. But asking the legislature to look to the new elder care and coordination statute and see about adding supportive decision-making options and accessibility for people, I think would be a step in the right direction.
Thank you, Sean. Gina, you're recognized.
So like Michael and Sean are both saying, I agree that all alternatives to guardianship should be explored, and better resources for people to be able to do that should be available. And that's a statewide educational campaign as I see it. When we get past somebody who could maybe be served with supportive decision-making as an alternative to guardianship, when I look at this, my question, I guess, is how does this type of an arrangement differ from Guardian Advocacy 393? Because I find that portion of the law is very smart. It allows individuals to retain rights. It looks as at least restrictive measures. It can be filed by family pro se in many jurisdictions. The way the law is laid out is to provide a type of more autonomous guardianship. And perhaps we need to start with looking at guardian advocacy, asking what it's doing correctly, and then how can it be improved to better enhance the autonomy of the person? Because I think it has a lot of elements going for it that that make it worthy. And I just wanted to comment that, of course, you know, I am absolutely for the least restrictive means, the most person-centered care as possible. But looking at what we have in the law right now might be a place to start and incorporating some of these things. Thanks.
Thank you, Gina. Viviana?
So I'll start by addressing that point, and then I'll sort of summarize that I don't know that we're going to agree on all the specifics of what an SDM bill should say. I don't think we're going to try to accomplish that today. My proposal was that we do an overall recommendation for the concept, and then these are some of the conversations that we should continue to have, maybe with whatever legislator takes this on. So with regards to, just to address Gina's question about guardian advocacy, at Disability Rights Florida, and our concern is shared by the National Council on Disability, and many others, guardian advocacy is not really a less restrictive alternative to guardianship. It's basically the same thing, right? Your rights are removed and they are given to someone else. The only difference is that there is less due process based only on the type of disability that you have. The guardian advocacy statute is very specific that guardian advocates have the same powers and responsibilities of a guardian. So it's not really a less restrictive alternative. Although I do understand that maybe for some people, it will be an easier avenue to get someone into a guardianship-like situation without losing all of their rights, because it's hard to limit that when you go into the guardianship process. That would be my first point. I'll also address the idea of it being completely separate from guardianship. it can be used in a lot of points in the guardianship process. So you can have someone like Mike who was under a guardianship and SDM helped him get out of it. It was a way to show the judge that he has the ability to manage his own affairs and help the judge understand what is his life going to look like. Who's he going to talk to when he needs help? When he's going to travel to Tallahassee to be on a guardianship task force? Who's going to help him figure all of that out? It can also be used to help someone develop skills. So if you're under a guardianship, how can SDM help you learn how to do things on your own, help you learn how to pay your bill so that you can be ready to get out of it? And then, of course, before a guardianship happens, to consider it as a less restrictive alternative. So again, I think there's a lot to talk about, and I'm happy to have those conversations outside of this. Mike and I love to talk about SDM. We have language. I think the more people who are engaged in this conversation, the better a bill could look. I just want us to consider making our recommendation. We support the idea of supported decision-making. We think it would be valuable to have that in Florida statute, and then encourage the legislature to look into how to do that in a way that protects people's rights and also keeps them safe.
She just made some good comments at the very end. I shouldn't editorialize on the comments at the very end, which maybe are summarize the consensus of this task force. Does it summarize it?
Yes, sir.
So I think that's what we've covered that topic then. Hillary, do you have an additional comment?
Just quickly, that, supported decision-making is great, but I think that we have to find a way to, stop guardianships, but maybe supported decision-making could be an alternative to guardianship to begin with. Instead of putting me in a guardianship, supported decision-making would be a great start, or a least restrictive alternative.
We can go back to the recording to get it, okay?
Did I do something
No,
incorrectly?
that's fine. I'm sorry, Hillary, I was rude there to you. We were just trying to make sure we had the wording on the last proposal.
Okay, I apologize.
No, it's my apology to you.
So basically, I don't know if anyone agrees that supported decision-making could be an alternative to
I
guardianship.
think we all agree on that. Oh, scoring this point.
I say at least a 4.
5.
I say 5.
I say 5, but.
I'm going to go with 4.
Yeah.
If I may add, while we're racking up and doing, I'm going to invite the two of you to come to my class on guardianship in the spring term, because I teach the new lawyers that come before me, aspiring lawyers, about supported decision-making. It's one of the alternatives. In addition, elder caring coordination. When I was on the bench, I was one of the group of judges that had that as a alternative dispute resolution, because when you come, when folks come to the court, there is all kinds of intra-family dynamic that you can wind up litigating forever and spending a ton of money, as opposed to one individual handling the drama and not having it spill into the expensive court. Now, one of the things that I found a way around dealing with the fact that elder caring coordination is only for elder folks was to use what in family court is called the family coordinators. The family coordination, as a matter of fact, elder caring coordination comes from the family coordination. And because the individual that we had was a 393 individual with a full guardianship, not a guardian advocacy, I wound up getting a parent coordinator to handle them, because again, this young man was 36 years old and outside the elder caring coordination. So if your circuit has a parent coordination as well as an elder caring coordination program, if you cannot find, again, if your individual doesn't fit the elder caring model, you can actually go to the parent coordination and you've got the same alternative dispute resolution that you normally would have. And that may also be something to consider in any writing about elder caring coordination, that when it falls outside to a minor or someone who is not considered elder because they don't meet the 65 and up, that parent coordination should be considered also as an alternative dispute resolution.
Sign me up.
Thank you. Thank you. You have a guest lecturers already here. That's good to see. Shannon, you've been very patient on a topic which I made a commitment to you that we would definitely talk about today and discuss, and we need to do that. So I'm going to move that up as our next item, and that's court monitors. I do want to say something, though, before we have our discussion on this topic. This one is a little bit troubling, you know, in our different languages that we came up with here on the court monitor. It is prescriptive. It's taking a model and saying this is the one that we should do throughout the state. And I'm just wondering if you would be open to this, and you made a proposal, so I'll direct this to you, Shannon. If maybe instead of talking about the system that, you know, works in Broward County, maybe we talk about what court monitors' success should be and focus on that, and then allow, you know, if in Escambia County, they can figure out how to do that and make that successful. And I put measurables, you know, I'm an accountant, so I like measurables, but maybe talk about it from that perspective. And, you know, I think that kind of goes with the flow of our discussions here today, what should be the proper role of the court monitor, and what should they be accomplishing, and how do we judge success
Oh, I'm sorry.
of court monitors?
I want to back up to two things before we pass it over to Shannon about, we didn't rate the last two.
Yes, we did.
We did?
Yeah.
We did a score of 4 for both the past 2 points.
Well, I didn't.
Okay, that's fine.
Okay, sorry.
So Shannon, why don't you kind of lead us in this discussion and maybe how we should go about doing this?
Well, I honestly, I mean, I know that there are different.
And go ahead and move, Matt.
Okay. I know there are different options for court monitors, but I think to keep it moving, that we should just recommend that each county have a system for court monitors.
Say circuit instead of county on this
Or
particular one.
circuits. Okay, that each circuit should have a
Pooling
system
of
for,
resources.
I don't know, a procedure for court monitor appointment. So that when someone needs a court monitor, I just had a case and we needed a court monitor, and there's absolutely no process in this particular circuit. So, you know, we have to go to the judge and recommend things. I actually attached the administrative order from Broward and asked him to consider something like that for this case in a circuit that didn't have that. So maybe what we should just recommend is that there be some sort of process that they have in the 9th, or that they have in Broward or wherever, but that there be some place for someone to go to get a process, and that should be set up in each circuit.
Hold on, let's have the folks talking on this point. We're going to go Karen first, and then we're going to go to Anthony, and who else? And Sancha.
So one point that I would make, we are really trying as a task force to try to create uniformity and consistency across the state and how things are applied. And I do recognize and agree that some circuits are doing it in a way that's successful, and we don't want to curb their successful efforts. But I would encourage us as a task force to consider language that creates a statewide standard and not just best practices, but also an organization of court monitoring in some fashion, whether it has a supervisory board or whatever it may be at the state level, something to ensure that this is done in a consistent way everywhere. The approach is the same. And also to avoid having to send people who have complaints to 20 different places. There's one place that receives all of the complaints. They can dispense with that accordingly.
Anthony?
Yeah, I concur with Shannon with her recommendation, but whatever the model is, whatever works best for each circuit. And I think Clerk Burke brought this up. We need to track that, collect that data, and then analyze it to see which model is most efficient, which is, you know, what's working and what's not working, so we can give that information to decision makers to make minor tweaks to whatever is working best.
I agree with Anthony. I think this needs some investigation too. Excuse me. But I also just on the phrasing, we're not asking for a monitor of the court. We're asking for a guardianship monitor, not a court monitor. So perhaps we need to look at this. We're looking to investigate and create or modify existing systems or perfect as best we can, the systems that are in place in the counties where it's working. But it's a guardianship monitor, not a court monitor.
But it's called a court monitor under
It has been.
744-107.
It has been, but
And Shannon, maybe, and you obviously have a lot of knowledge on this topic, on a court monitor, do you see as the role of the court monitor, or what does that administrative order that you're pointed to say that the court monitor is supposed to be accomplishing?
It's Florida statute 744.107. Yes, I do always carry a.
Yes, of course, yeah.
Fashion lawyer. And what it says is the court may, upon inquiry from any interested person or upon its own motion in any proceeding over which it has jurisdiction, appoint a monitor. The court shall not appoint as a monitor a family member or any person with a personal interest in the proceedings. The order of appointment shall be served upon the guardian, the ward, and any other such person as the court may determine. And then it goes through the list of things that court monitor can do.
Can you go through some?
The monitor may investigate, seek information, examine documents, interview the ward, shall report to the court his or her findings. The report shall be verified and shall be served on the guardian, the ward, and such other persons as the court may determine. If it appears from the monitor's report that further action by the court to protect the interests of the ward is necessary, the court shall, after hearing with notice, enter any order necessary to protect the ward and the ward's assets, including amending the plan, requiring an accounting, ordering production of assets, freezing assets, suspending a guardian, or initiating proceedings to remove a guardian. It's pretty broad.
Mike?
Current statute, it's almost always the court monitor is paid for by the ward. And so I know both myself and Judge Morley suggested some language to at least reduce that a little bit.
Well, I think it should be reduced 100%. You know,
Somebody's got to pay for it.
That's a terrible system to have the ward pay for that.
But if we limit,
It says may be allowed a reasonable fee as determined by the court.
Yeah, that's right. Jose?
But I think also what Judge Morley had amended our motion was to include the bad faith provision, which I think is very important because otherwise we do have people filing requests for court monitors that are improper. And so by adding a bad faith provision that says if you filed it in bad faith, then you can be the one stuck charged with the bill. I think that can also be an effective deterrent for people filing frivolous requests for court monitors.
Jose, then Hillary.
the problem is that it is, okay, let me give you for instance. You wind up having a beautiful home with a bunch of gorgeous artwork and computers all around. Somebody breaks into your house, steals some of your artwork, steals your computer, trashes your house. And then the police officers come to you and say, yes, but you're going to have to pay the cost of investigating the people that have done wrong to you. That's what we've got here. It's the same thing. We're asking people to pay for investigation into how they've been harmed, they've been wronged. And I'm sorry, but I think that's wrong. I think what we need to do is we need to go ahead on a
That's not.
no. This is what I've seen, and I've seen that it is possible. Look, 30 years plus on the bench. One of the things that I saw was how much was being charged for conflict counsel in criminal cases. Eventually, they went to a conflict attorney. Why? Because they were paid a single sum and then they hired individuals. And what they did is they reduced the cost. Exactly the same thing that will happen here. I would like, when this is really studied, to take a look at how much is being spent, say in the Ninth, and what is being paid in other counties, and see that the only cost-effective way of doing it is what is being done away with. And that is the ability of a government agency to pay for that. That's my, the chicken bone that sticks in the throat, you know? Again, the payment by the person that is wrong, and that's wrong.
Hillary?
Well, again, I mean, if you want to go there, we can go to the ward pays for everything. Well, no, the ward pays for everything. They're sitting at home, minding their own business. They're not even served. They're put into an ETG without even meeting the judge. Then everything is thrust upon them. They're paying for the, attorney, court-appointed attorney who they don't want, the guardian, the court monitor, the examining committee. I mean, this is deplorable. And excuse me, Mr. Rodriguez, and to the bad faith filing, again, it sounds great. But the same with the bad faith filing that Magistrate Cadigan agreed with me, it never, ever happens. I thought, great, I'm going to file a bad faith filing on the petitioner. In my dad's case, I've never once seen a bad faith filing come to fruition. It doesn't happen. Just like a ward getting their rights. It just doesn't happen.
Sean, you're recognized.
Thank you. I have to go back with my thoughts here. First, I think how Shannon had changed her proposal in terms of the concept for today, I agree with. I think that's great. I do think the preference should be having some sort of state centralized mechanism, as one of the other speakers pointed out. But until such time as we have some sort of state-funded agency responsible for serving as the monitor in these cases, I just want to make sure that this task force doesn't recommend something that actually ties the court's hands, because the original proposal for the language basically excluded court staff from serving. And as we know, that would impact the Ninth Circuit's plan. And I just want to point out that one of the documents that was shared with us, the nursing home and hospital pipeline document, the final line of it says, creative solutions and aggressive oversight by the court must be implemented to ensure the system protects the rights of the individual. And so to the extent that I know there are other circuits that have court monitors, and even our Elder Justice Center can be appointed as a court monitor in these cases, I would be opposed to anything that we recommend that restricts it, unless we're taking it outside of the court program entirely into a separate agency that funds it like the state.
Thank you, Sean. Karen, you're recognized.
Shannon read the statute to us earlier, and I apologize, Shannon. I was jumping through 3 different statutes that all have court monitor in it. Subsection 5 of the court monitor statute actually does allow the court to appoint the office of criminal and criminal conflict and civil regional counsel, which is what Judge Rodriguez was saying, as opposed to us trying to come up with and reinventing the wheel. What if we recommended that the legislature require that there be staff of ORCC available in every circuit to be appointed as court monitor?
I would say that it's going to be costly because you're going to have new positions. And secondly, I have not spoken to our chief of the 5th DCA Conflict Counsel office, but I can guarantee that they are swamped already with the number of cases that they've got to go ahead and represent. So there may be some resistance there. That's going to have to be handled with appropriations, and more appropriations, and bodies to be hired that may or may not know, that will have a learning curve. Hopefully we can, if that's the way we go, that's
Let's just try to bring this to conclusion, because I think there is agreement, and Karen, in all due respect, I think we've tried to avoid too much prescriptive saying how it should be done or which agencies should handle it. But I think there is consensus that of the need for the important role court monitor play, and that court monitor should be a state-funded item or if it should not be the burden of the ward to to fund the state, the court monitors. That's where I do think.
I think what my suggestion was that we allow each circuit to designate their own process. And like, we don't want to take away the process in the ninth. I'm pretty sure they don't want to take the process away that they have that's very effective in Broward. So my recommendation, and I think that this is a good one for now, is to let it just make sure that we're collecting data to see where it's being effectively, yes.
Okay.
But not through giraffe,
Okay.
but yes, collecting data.
Okay. Is that our recommendation, folks?
So be it.
No, they do not have to have one.
Are we recommending that?
Yes.
That each circuit does?
I don't know, Sancha, what were you gonna say?
I was just going to say that the statutes allow court monitors to be appointed right now as it is. I don't think that all circuits have a system, so to speak.
Right.
And I think that, Shannon's recommendation was that we allow them to do that, right? Each circuit.
Well,
Best practice.
I'm not sure.
That they just need to have a process. When someone files a motion for appointment of a court monitor, it can be like in the Ninth Circuit, it can be like in Broward, where they just have a way of appointing a court monitor when one is requested.
This is a step two in the court monitor system.
Yeah.
There's some statutory language. Now we're saying implement it in every some type of program in every circuit. I think the future, if something like this happens, it's going to be a natural thing. Then they'll start looking for some consistency, some type of, throughout the system as we gather data on it. And again, we're not solving the whole problem, but we're starting to, move the needle on an issue. Mike, did you have a comment?
Using your point that the ward should not be paying for it. Or
I guess that's point two. I think that the first point, did we all agree with what Shannon said as far as at least that each circuit should have a plan?
You know what Shannon, if I may, what Shannon is suggesting is that we respect the individuality of each county and their particular resources that are available. And I think that I'm on board. I'm on board.
Yeah, but the second question, which we haven't answered, is should the court monitor system, do we want to tweak the system to say that this should not be an expense of the wards?
I wouldn't direct.
What's that, Mike?
I wouldn't direct that the ward not pay. I just say, I think this should be included as a concern for each circuit to look at.
Because then who pays for it? I mean, are we going to add it as an appropriation? Because the legislature's going to be like, what? No, like, we're not going to pay for it, And then so I almost like the way it reads, which is, and I know Dr. Cohen, was it Dr. Cohen, who was talking about, he asked for it to be surcharged against the bad actor. And so I just think or Judge Cohen, that we should, I don't know that we need to tweak the language, but it doesn't say shall be paid by the assets of the ward. It says it may be. And so the court certainly would have discretion to surcharge in any guardianship proceeding. So it just says a monitor may be allowed a reasonable fee determined by the court and paid from the property of the ward, but the operative word is may.
Okay, so we're going to be silent on that point.
It's not getting paid.
I'm sorry, I'm still unclear as to what our proposal is, though. Is it that we're gonna see how effective other circuits are doing? Are we gonna require every circuit to have a court monitor on?
My proposal is that we have every circuit have a court monitor process.
Well, and they use it.
Effectiveness of that process.
And to question further, if I may, the purpose of that is so that concerns can be raised to the court monitor. That will be the place where people, including outside parties, can raise concerns, right?
You file a motion in the guardianship report, like, or a letter that says, I think a court monitor should be appointed because my mother's been isolated in a facility and hasn't been able to see her family. The judge can appoint a court monitor. They know that the circuit has a process that appoints from this list, or that court administration has someone who they appoint to look at that issue. And then data on it through that same process.
Do we have a party on this one? 1 to 5. 4? 4 sound good? 5, 4, 5. What's that?
Lower.
How about 4? Yeah, let's make it 3. Yeah. 4 or 5. Thank you. And thank you for your patience on that one, Shannon, because that's, you made a motion. We promised you that would be discussed today, and we have discussed it. So it's now 3:18. We have professional guardian tracking, goal of report, and advanced directives. We're doing really well, folks. Which one should we handle next? Advanced directives?
I like advanced directives.
Okay. Advanced directives for 400, all right. Advanced directives, who wants to start on this?
I would.
Okay, go ahead, Hillary.
From my knowledge, they're never respected. They are, and just to give you, since I have some virgin ears, my take on it. My father in 2003 got up, he took a shower, he put on a suit and a tie, he got in his car, he drove to his attorney's office in Winter Park, Bruce Weigel, and he had his documents drawn up, his power of attorney, his healthcare surrogate. He paid Mr. Weigel what he was owed. He shook his hand, and when he left his office, he had a feeling of confidence that what he wanted would be done. Fast forward to 2017, he was hustled into an ETG. One of the first things that were done.
Hillary, I'm going to interrupt you. What year was the advanced directives done?
2017, November, and he was put into an ETG, and there was no exploitation, brought up, accusations, but still his POA and his healthcare surrogate, not his healthcare surrogate, I'm sorry, his power of attorney durable was suspended. It was never respected. And my dad's case is basically minuscule in comparison to most of the victims sitting here with us, and it's a little bit uncouth, but powers of attorney, basically, they're like a used piece of toilet paper. They are absolutely useless. And I'm almost to the point where I recommend not even having these documents drawn. So I must say that this is, and thank you, Anthony, for bringing up power of attorney issues, that the judges are not respecting them. So thank you.
Karen?
For purposes of the data points that we're going to be collecting statewide, since we're not agreeing to those now, but we are going to include a list of suggested ones in the exhibit, I think that to Hillary's point, this should be one of those metrics that we're tracking when an advanced care directive did exist and whether or not the court left that in place or.
Yes.
Shannon?
I have established 5 guardianships in the last year. Of those 5, 4 incorporated the use of an agent under power of attorney and was honored. So we filed petitions for incapacity. We've asked the court to honor the less restrictive alternative, which is a power of attorney. And in each one of those cases, the court agreed and honored that. So we were able to stop exploitation, but allow the agent under power of attorney to continue to operate to manage the affairs of the incapacitated person. So that has been my experience.
No, Shannon, so the guardianship was not formed or was formed?
The guardianship, the incapacity order is entered so that the court recognizes that this person no longer has the ability to make financial decisions for themselves, but they recognize the less restrictive alternative, which is a durable power of attorney document, and the agent operating under that durable power of attorney then begins to manage the assets of the ward as the ward had intended. And so this is a very common practice in my circuit. Judges love it. We're honoring their wishes. It's private, and it works very effectively.
On the fifth one, was there no advance directives?
There was no advance directive. Yes.
Hold on, Hillary. Viviana first and then Hillary.
Shannon, I'm confused.
Okay.
Was there or was there not a guardianship created?
No.
Okay.
There was no guardianship created.
Okay. Thank you.
Hillary?
Well, I want to move to your county. You know, that's phenomenal because with my research and speaking to victims every day, that's the first thing that they say. You know, my dad, my mom, they had POA, there was a trust, you know, and there's still a guardianship established. So that's great news to hear.
Thank you, Hillary. Gina, and then Sancho.
I just wanted to echo that because in the 20 years that I've been doing guardianship, I found that having good powers of attorney and having your documents drawn up 9 times out of 10 are sufficient for the court in the way that Shannon describes it. It's something I would always look for as a guardian if I came into a case, and something that is brought to the attention of everybody involved, even prior to incapacity, if possible. So I find that those are great tools and that they are honored. And that's not to discount your experience, Hillary, which I'm sure was terrible. But for the most part, I find that they are good tools. The judge does honor them, and most of the time it's one of the best tools you have to making sure you don't get into guardianship. And I cannot say enough how much that needs to be, how much our community needs to be educated about this to make sure that they've done the best planning that they can, and we need more resources for that. Thanks.
Sancho, then Sean.
Thank you. I just wanted to echo in Central Florida, in the Ninth Circuit, that has been my experience as well, is that the judges are honoring those advanced directives, and to the extent that you will have one and not others. For instance, if there isn't a durable power of attorney, but there is a healthcare surrogate, then the lesser restrictive alternative, the healthcare surrogate, remains in place. For instance, if there's not a durable power of attorney, then you'd have a limited guardianship just for the financial aspects only.
Sancho, Ninth Circuit's a big circuit, okay? Have you felt that this has changed in recent years, and maybe, because obviously we've heard lots of testimony or public comment that advanced directives were ignored. So I'm just wondering, where is the disconnect here? Because we're hearing one thing here and another from the public comment. So I'm just, and I don't have any data. Again, we have no data on this stuff. So I'm just trying to find where's this disconnect, and maybe you could help.
From what I have heard in my experience in dealing and discussing this with other practitioners, is it is localized in certain areas of the state because of the way that it's being practiced in certain areas of the state. So I think education, again, at all levels will help that, but certainly in the last, I would say 5 to 7 years, I've seen it more often recognized than perhaps in the past. And that is because this statute requires that you consider alternatives to guardianship.
Okay, that's very good. Sean?
Similar comments. I am just cringed at the suggestion that you should discourage people from actually having these instruments in place. Think about it. All of the cases where these advanced directives were in place that didn't make it into the guardianship court because they didn't need to. That's the whole point. It can keep people out of guardianship. So there's more success out there in the cases where people actually did execute those instruments when they had capacity, and then when they no longer had capacity, a guardianship wasn't necessary. Nobody thought to go to court because the instruments are doing what the person intended them to do for them. And just to speak to my experience is that the cases where advanced directives are not being honored are typically cases, in my personal perspective over the years, where there were issues with misappropriate handling of the power of attorney, or more likely than not, or more common, is when the advanced directive was something that replaced the long-standing advanced directive that they had, and happened very recently when the person was already really incapacitated and they didn't have the capacity to actually execute the new instrument. So somebody was trying to shift things, influencing the individual, shifting them to someone else.
So how do we advance this concept then? Because of, it seems like it's in statute already that the judge is supposed to honor advanced directives. Sandra, even you acknowledged it within, it's localized. It may not be, uniform and carrying out. So how do we tell the legislature, yeah, you've already done this, but it's not being enforced? Or is this something that we appeal to the court and say, court, really, the education factor of needs to be enhanced here? Is that the solution? I'm just trying to come up with where we move forward. So, okay. Thanks. Gina,
And I
Hillary
don't know if this is
first, and then Gina, and then Mike.
in the bud, but obviously it is an issue because someone brought it up. And I, of course, I can do research on this, but if I am not correct, and I'll admit to that, maybe we should have something that does an audit or some sort of research as to just what you said, how many POAs are being pushed aside. Because obviously it is an issue. And I don't think I'm just,
Right.
hallucinating like a lot of times we are told we are, and we're not, So maybe that could be something that.
And Hillary, a lot of times because of recent legislation or legislation that may have been there is more awareness today than there was even 3 or 4 years ago. And the attitude, the behavior may have changed with the judiciary of being more diligent in asking about advanced directives. Again, this is part of our, we don't know because there's no database type of item. Let's go with, I think Gina next, then Mike, and then I see Shannon has her hand up.
Well, it certainly would be good information to have because like I said, I just wanted to reiterate what Sean said. In the times that I felt that there were orders that weren't used, it was because there was questions about the way they were drawn up, whether the person actually had capacity at the time or not, and as well as, or somebody was abusing the power of attorney. And so, like I've mentioned this before, the education of having this stuff lined out and properly done it is a big part of people not ending up in guardianship. And I don't know how widespread this problem is that Hillary describes. I'd like to know. I don't typically hear that. And I encourage everybody to have their documents done so that they rarely can end up in guardianship. And so I think we should continue that education.
Mike, and then Shannon.
Well, I just would totally support Karen's idea to get more data and everyone. And I also agree with Gina and Sean. What we find is one of the things the abuser does is get the person to sign a power of attorney to them.
Yep.
And those should be set aside.
Sure, they should be. Shannon.
And then I would finally say, and this may be obvious, but it is true, that when the data is required to be collected and the court has to enter that data saying, I set aside the power of attorney that's been in play for the last 5 years, you may find that the court itself vets that issue a little bit more thoroughly and actually honors more less restrictive alternatives, including honoring the durable power of attorney, because maybe they don't want to report that they overturned that document. If you see what I'm saying, I mean, it just creates, just because you have to report that data, it may create more compliance with the rules because it's more of a pain to report that than not.
So Karen, you're a smart person. Can you,
There were 2 points that were raised.
let's put this into some type of, you go.
There were 2 points that were raised on this. I guess the idea is to provide more education and training as it pertains to advanced care directives for all the parties involved, especially the attorneys and judiciary, and to make this a point of data collection statewide that has to be reported.
Does anyone have a problem with that? Okay, and 1 through 5, where does this fall? 5, it looks like on this one. Anthony, do you have anything to add on this?
No, I was just going to say education's great, collecting data is great, bestow my heart. But we spent a lot of time discussing, is it a problem? Isn't it a problem? If you look at the language that was in the initial draft, it's just requiring clear and convincing evidence on whether the advanced directive should be set aside. If it's not a problem, then this really doesn't apply. If it is a problem, then we've put in some checks and balances to the process.
I don't agree with that either. Go ahead, Mike.
I mean, I'll just say I don't agree with that. I don't know. We need to get into it any further.
Okay, yeah, but we've agreed to
We've agreed to what you said.
so let's,
Because all undue influence is circumstantial.
yeah, yeah.
Reaching the level of clear and convincing evidence to set aside a durable power of attorney document requires evidence. And if you have only circumstantial evidence, it will be very difficult to meet that threshold. So I would say,
Okay.
let's not include that.
Yeah, and it's not part of the language which we just had consensus on. So we'll move forward to we have 2 items left. The professional guardian tracking. Karen, this was an item you asked to be put on here, so would you mind leading this topic on this?
Sure. The point that I was making is that this was, we took our number 1 from the listed summary recommendations. There were 2 points that were a part of that. Part of it was the professional guardian information, and the other was the guardianship objective court information. So these are 2 separate processes. I think that the conversation that's been had by the task force so far is to have some form of a database that is maintained, and we're not going to specify agency or what, but that says specific metrics of a professional guardian. Are they registered? Are they compliant with education? How many wards do they have in their care? And do they have disciplinary actions that have been taken against them, right?
Is there anyone who disagrees with this?
Well, disciplinary actions against them or findings of fault, because anyone can have a disciplinary action against them, just like anyone can be accused of
not complaints, but actual findings, disciplinary findings or actions.
Yes.
And would the same agency keep that as, I mean, I understand the need for it being a separate sort of thing, but are we going to recommend they go to the same agency, different agency?
I don't, we should.
We're going to stay away from that. And Sean has his hand up, so we're going to recognize Sean.
Thank you. Doesn't the Office of the Public and Professional Guardian already maintain certain information on it? So I was thinking that expanding this information and sharing it is the important part. The only word I thought was missing from what Shannon had pointed out was sharing that information with the courts, because we don't know what OPPG knows. If the person is registered in our circuit, they're required at this time to give us certain information. But when someone's coming to establish to get on our professional guardian list in our circuit and hasn't been appointed yet, we have no idea. They would not have notified us because they're not acting in our circuit yet.
Again,
JD and Karen.
So that's my thought as well. Well, I'll follow up a little bit more on that, is that, I mean, what we're talking about tracking is something that is a responsibility of the professional guardians group, a state agency. So for collating that into a manageable database that could be open and transparent for the stakeholder is the key in my mind. I know that in the past, I'll tell you this from experience, in the past, there's been sort of a disconnect on the role of the task force investigators on behalf of the department, because that's really this statewide investigative task force is a function of the task of the department. At what point in time was it a duty of the investigator to report to the court that there's a concern, as opposed to their relationship to the department? I made it sort of a goal in my office. We're going to report to the court because that's who's got control, and the department. And I think we have formalized that over time because it was a brand new thing the last few years. They are the proper place for the data. So therefore, they're the proper place for the data management of it. Unless there's something that I'm missing.
No, I would agree. I think we do have that today. So their registration status, whether they're registered and compliant and they have all of the statutory requirements, that's on our website today. It's available to the general public. And so that's there. As far as disciplinary actions, that is not available to the general public. It's only available by request. And so if the thought is to create a database that is readily available, let's say online, something published and it's updated periodically, then that would have to be the recommendation to say what information disciplinary wise that would need to be shared with the general public, or if it should be shared with the judiciary and to what level. But that is captured today, absolutely 100% from OPPG. We just don't have a mechanism or a current requirement or ability to share that outside of the public records request or the judiciary or a specific request for it, not voluntary.
Karen and then Hillary.
I agreed with OPPG is the place that has all of this information for the most part. I didn't want to name OPPG as the maintenance body of this database because I think that by leaving it open, the legislature can provide its own solutions, especially for costs and staffing. But I do think that the idea of a online database that's accessible, that contains those metrics that we specified, it seems like that's what everybody has been requesting, and unless there's an objection that we haven't discussed yet.
Hillary.
I think it's more than that. And I'll give for instance, a recent one. For-profit professional guardian Denise Willis in Orange County, who I'm sure a few people know who she is. She resigned from, I believe, 7 cases, and she was removed from 2 cases. And it's not really a good thing. She is still a for-profit professional guardian. But my issue is none of the other counties where Denise Willis works was notified that she was, forget about resigning. Let's not get into that one. But she was removed by Judge Marquez on 2 of her guardianship cases, and it had to do with financial issues. So I do think that Seminole County should have been notified, and every county should have been notified that, hey, this is what happened this week. And they're not, and that is an issue, and it is a legitimate issue.
It is.
And as far as, and I'll be brief, as far as disciplinary actions, the public should know. I should be able to call OPPG and say, hey, look, my mother has Jean Smith as her guardian. Can you tell me if she has any disciplinary actions against her? If you're a nurse and you have them, you can look up and I'm not talking about family guardians. I'm talking about professional guardians. I don't know what's so funny, but I'll let anyone else respond.
And Shante, and I don't think anyone's laughing at you there, Hillary. I agree that that should be made public. And it is actually public information once the investigation is done and there, but
there's no time.
But right now you have to know it's done and request a copy of it.
But it
Instead of
takes
doing that,
months and months.
it should be put into the system. Your point about if a judge is removing a guardian for some cause that's nefarious, and there is multiple county, there probably is no mechanism right now. And that's something which would be a very good idea, because I certainly would think as a judge, and Jose, if you would want to know that another judge removed a guardian for cause, and so a mechanism to make that possible would be a very good thing.
And I agree. I think the sharing of information and the transparency I think we all agree to that. But we have to be clear where the information is coming from. So if a guardian, not specific, I am not discussing a particular guardian. If any guardian has been removed for cause within the courts, that may or may not be information that OPPG has.
Right.
So that's going to be one circuit talking to the other circuit. That's not OPPG. If that is, then we can address.
Talking about OPPG, I'm just.
No, I'm just saying we can address that. I think those are valid points that we have to think about where the information is coming from, who we want it to go to, and what mechanism to share that information. Because I said before, there's several people that have a shared duty of oversight. So that varies from what OPPG does, what the clerks may do or find, and then what the courts are doing. So I think we have to be clear on when we're communicating what we're saying is where.
And Hillary, I'm not going to cut you off. I'm going to call on you a moment. I think we, though, agree. I think in this room, we agree that if a judge is removing a guardian for cause, there needs to be some mechanism. And we don't have to go into what that mechanism here is, but there has to be a mechanism where where it's reported, where there is where the other judges know that they have a guardian in their county with cases where another judge has removed them for some type of cause.
Similar.
That's what so maybe let's not discuss how it gets done. That could be mechanically accomplished somehow. We're not sure, but we know the need exists for that to happen. And you bring up a very good point. Hillary and then Karen.
And thank you. But if my mother was in a guardianship and her guardian was removed from 2 cases in another county, I think I have the right, and I'm an interested party. I have a right to know that.
I agree.
What's happening, we really, really do. And again, if a child is being abused, you take away the abuser and then you ask questions to them. You don't leave that person there. Similar, Ken, to, Cynthia Van Vliet was removed in Pinellas. No one in any other county knew.
Right.
And now she's a member of the examining committee in 5 counties. And all it would take is one email to say, heads up. But I always think about how I would feel if I were a woman.
And you're right.
Thank you.
That seems to be a priority too of all of us. Karen?
So I agree and love the comment. And honestly, the way I suggested the phrasing earlier, I think it would have left that point out, because the removal of for cause is not a disciplinary action. What OPPG does or can do can be finding a disciplinary action. But so if we're going to keep it vague, how about we do the recommendation that there is a statewide online database, which is publicly viewable and accessible, that tracks the professional guardians on the number of wards, where they practice, whether they have received any disciplinary actions and or been removed for cause by any court. That kind of summarize and capture the work.
It does, but I do think, and maybe this is really beyond the scope of what we're talking about, I really do think that the judges in other counties should be notified.
Well, that's part of it.
As long as that's part of it, because on a normal basis, judges won't be going to the database. So thank you so much.
That's good.
That's a
5. Okay. Good. Okay, we have the last topic of the day, and that's the goal of the report. Yeah, and Sancha? Okay.
That was me. I was going to move that we adjourn, but no, that one was mine.
Take care.
All I wanted to raise was our goal that's listed on the report does not match the goal that we approved at our first meeting. And I would just suggest that we mirror what we used before. That's it.
Okay,
Yeah, I agree with that.
okay. We'll do that. Consensus too.
Then I move to adjourn.
Well, we have the movie. I just want to thank you all for your patience today, for your participation. I think it's been robust discussion. I want to again express my thanks to the FCC staff for your help, Tom and Kimberly. Great job, and Patrick, thank you for your help. The people who've made the effort to be here from around the state, our citizens, thank you for your attendance here. I know you probably would like us to accomplish a lot more, and we would like to accomplish a lot more, but given the limited scope of this task force, we hopefully feeling like we're moving in the positive direction. And with our suggestion that the legislature adopt a new task force, maybe consisting of some of us, who knows, and to keep this thing moving on a regular basis is important. I will ask everyone here, whether you're a citizen member here or a stakeholder or in the process, please do this. Go home and call your local state representative and your senator and say, hey, there's been a task force and I'm either part of it or I've been witnessing it as a citizen. And they're coming up with recommendations and as far as concepts for the legislature to consider. Please, do I have your commitment as my state representative, as my state senator, to really follow through with this? Because when we make appointments after we get this report done, and those of us who have the interest of going to visit legislators, and they've heard from their citizens back home, yes, this is important to them, you get a whole different reception when you walk into the room, okay? So I would ask all of you to please contact, especially when this report's concluded, but you can do it now. Start contacting them now to let them know that this is an item important to you as a citizen and you want them to take action. That has much more impact than us hiring $1 million lobbyist up here, I can tell you that. It's them knowing that their citizens are concerned with an issue is their number one item that legislators look to. So please do contact your legislators. Does anyone else have any comments for the good of the cause? Yes, Hillary.
Thank you, Ken, for getting this started, and Anthony.
Well, thank you, Hillary.
Thank you.
Thanks for being
Forever dead.
And Sanchez made a motion that we adjourn, and you can vote by getting up and leaving.
Gavel. Nice to mention.